Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends. Good morning and happy Wednesday, March 5th, 2025. How's everyone doing today? Oh, good. Your YouTube alerts are fixed. Yay, Erica. Yay. Yay. So I don't really know what time court's supposed to start today. I think they, a lot of stations have it set for 11. And so I wanted to come on a little bit early, and also there was some papers that dropped yesterday that we need to look at about this expert neurosurgeon who wants to come in for the Commonwealth, or the Commonwealth wants this neurosurgeon, Dr. Wolf, another Wolf, but without the E at the end, to come in and say that somehow John's head injuries, brain bleeds, and skull fractures came from smashing against the hard as rock ground. I guess. Not really sure. He seems to be a well-renowned neurosurgeon who does all kinds of brain surgery. I'm not really sure how he's going to be able to testify to that, and unless he put in some really good papers. So we can take a look at that, since I think they're supposed to argue that today. I also have the Aidan Carney hearing set up for 2 p.m. I am advised that it is going to be on Zoom, and we will be able to see the video and the audio. So I am just hoping that we can do both. I'm hoping that the Karen Reed hearing will be over by then, and then we can go to Aidan Carney at 2. If not, this is going to have to be like a game time decision. Then we are going to have to do Aidan Carney's hearing on a delay. And hopefully, even maybe by then, a news camera will pick it up, and we'll be able to have a feed where we can rewind. The problem with the Zoom is that we can't pause it. We can't rewind it. Can't really talk over it while it's going on, but it's just going to be like a pivot kind of day. We're going to pivot, and we're going to see what happens, and we're going to see where we go with that. So I don't know if anybody has been live tweeting from federal court. Does anybody know if they say when they're if they're going to let us know when they're on their way from the federal court over to Dedham? I don't know. But well, Dr. Stonebridge but she examined the brain after the brain was taken out of the skull. And I'm sure that doctor, at autopsy. So Dr. Stonebridge, do you remember when Hank Brennan got up in court one day and he started making all these wild accusations that Karen Reed left John O'Keefe to die in the cold on the ground, and she knew he was there, and if she had called 911 or tried to save him right away, he would have survived? This doctor is the doctor who's going to say that, allegedly. And so watching the Massachusetts live, no, this is not the Massachusetts Supreme Court live. This is federal court, so there's no cameras in there. So whatever you're watching is not the right thing, Toy. Hate to tell you. It's federal court. It's in person only. And I think they also have an overflow room there. Federal court never has cameras. So that's what it is. It's like the U.S. District Court in Boston. Completely different thing. Thank you, Tracy Walker, for coming in and gifting 20, not just 20, 40 memberships. Tracy, you're amazing. Thank you also for the matcha latte that you sent me yesterday. Really has just become all of a sudden a very kind and generous contributor to this channel. So to the 40 of you who have already been gifted this morning, welcome. Welcome. J.M. Lawrence. I don't know who that is. Let me see who that is. J.M. Lawrence. Let me see. Hold on one second. J.M. Lawrence. Who is that? I don't know who that is. Boston Justice. Okay. Boston Justice. Thank you. That helps. Okay. I wanted to show you something real quick because I am not ready. I'm not quite ready, but I wanted to give you something to watch while I go and fill up my water and get more ice and all of those kind of things. Good morning. Oh, I'm sorry that you're going to tornadoes in South Carolina. That's terrible. Okay. So Boston 10 yesterday got an interview with Ronnie, the juror. Yeah, they did. And you know what they're saying? They're saying that it's like an exclusive for them. And I guess they don't know that Aidan Carney already interviewed Ronnie, the juror. So that's like, yeah, don't give him credit for it. I thought that was a little bit not too cool, but you know, it is what it is. I'm going to put this on for you so you can watch this for a few minutes, and then I'm going to be right back just so that I can entertain you while I run and do what I need to do for about 5 minutes. So this is a 12-minute clip, and we've got some time to kill anyway. So let me just do some things here so they don't strike it. And let us so this is Boston 10. Did somebody just put that up there? Make sure you can hear this.
Welcome to Canton Confidential. I'm Glenn Jones. Thanks so much for being with us. In just minutes, you'll see the first on-camera interview with a member of the Karen Reed jury. He's from the first trial, which
lies. It's not the first camera interview of Ronnie. Ronnie was interviewed on camera by Aidan Carney, aka Turtle Boy. You can call him a vlogger. You can call him whatever you want, but you can also admit to yourselves that this case may not have the worldwide attention that it does if it wasn't for Aidan Carney and his reporting and trying to uncover the truth of what happened to John O'Keefe. So, you know, it's a little bit, yeah, first on camera interview. I know. Deep breaths, everyone. I'll be right back. Here you go. Enjoy.
Ended in a mistrial. Before we get to that, though, welcome to Canton Confidential. I'm Glenn Jones. Thanks so much for being with us. In just minutes, you'll see the first on-camera interview with a member of the Karen Reed jury. He's from the first trial, which ended in a mistrial. Before we get to that, though, as we near the second trial, there are last-minute procedural matters to resolve. That's why both sides were back at Norfolk Superior Court today. Our John Maroney was there.
I like talking. I like to reveal the truth.
A gag order on Karen Reed's attorneys. Prosecutors are asking Judge Beverly Cannoni to put one in place.
The ongoing, deliberate, purposeful poisoning of the potential jury pool is not only wrong and unfair, it needs to be stopped.
It wouldn't apply to the 45-year-old defendant who's pleaded not guilty to hitting and killing her boyfriend John O'Keefe with her SUV.
You say anything about a possible gag order? How would you like that, counselor?
Michael Proctor prompted the request after the defense released a text message, apparently inadvertently, from the embattled state trooper, despite court orders to the contrary.
It just did not register with me. It got by me.
The defense is asking to keep a dog bite expert for the state off the stand, arguing Dr. Stephen Crosby isn't qualified to offer a medical opinion about the scratches on O'Keefe's arm. Reed's attorneys say they were caused by a dog, part of a conspiracy to kill him. The prosecution has called the suggestion absurd, saying its expert is qualified and has taken a mold of the dog's teeth.
There is no requisite that an expert in this field needs to be a medical doctor.
The federal investigation into John O'Keefe's death has never been confirmed until now, with the Canton police chief releasing his statement saying in part the investigation is no longer active and will be closed.
There is no longer any federal investigation into the investigation of John O'Keefe's death or any related matters.
There are 2 hearings set for Wednesday. One of them will take place here at the courthouse in Dedham. The defense is set to argue its motion for dismissal. The other is at the federal courthouse in South Boston. Karen Reed's attorneys are challenging the SJC's recent ruling regarding double jeopardy. In Dedham, John Maroney, NBC 10 Boston.
Okay, John, on a busy court week like this, we like to turn to our NBC 10 legal expert, Michael Coyne, who joins us remotely tonight. Michael, good to see you. Let's start tonight where Judge Beverly Cannoni started. She prioritized this in her hearing. Here's what she said after laying out the agenda this morning.
You all know that when one of you speaks, you speak for the entirety of the defense team. When one of you acts, you act for the entirety of the defense team. And when one of you makes representations or misrepresentations, you speak for the entire defense team. You all know that. Do you understand that, Mr. Atty?
I do, Your Honor.
Mr. Jackson? Ms. Little?
Yes.
And Mr. Lyon?
And she made each one of them get up in turn and admit to the world that they understand that when one of them speaks, they're speaking for all of them because the knowledge is imputed to all of them, right? Just like, and look, you can't use this as a shield, as a shield and a sword, Judge, you know, because Mr. Brennan is going to come in and say, well, you know, I didn't know that these videos existed. You know, Proctor knew. I didn't find out about it until Proctor testified in front of the federal grand jury. Well, do you understand that Proctor works for you? And then the Massachusetts State Police troopers that are assigned to your office, you are imputed. Their knowledge is imputed to you as well. Okay. So if you want to play dirty games like this by looking for sanctions against the defense attorneys, you better want what you wish for, because the knowledge of the Canton PD and Helena Rafferty and all of the other people that work at Canton PD that know that there is a camera in the Sally Port that was recording, for you to say, I didn't know. We didn't know about the videos. We didn't know. It doesn't work that way. It doesn't work that way. Whatever they know, you know. If they didn't tell you, that's still on you. And I also noticed another error as I was listening to this. Stephen, it's not Dr. Stephen Crosby. It's Dr. James Crosby. I mean, is it really that hard to get the details correct? Apparently it is. This is mainstream media, and this is what, you know, the world is watching. Except you're watching me, and I'll give you the right information. Do you not understand that? Do you understand that? Do you understand that?
I see.
Like a public spanking. It was so ridiculous.
All right, Michael, you need to be the judge whisperer for us. It seems like Judge Cannoni was kind of clapping back on the argument by Reed's legal team last week. They were arguing that they did not need to disclose payment on those 2 accident reconstruction experts during the first trial. We know something
No, that's not what they were arguing. They were arguing that they didn't pay them until after the trial was over, and they didn't know that the bill was coming. That's not what they were arguing at all. They did turn it over. They turned it over in advance of the new trial, which is what they were required to do. And when the judge said to her, well, why didn't you tell them right away that you paid this bill in July? First of all, we weren't even sure that you were actually really going to retry her and re-persecute her. We didn't know whether the case was going to be dismissed on appeal. So no, that is absolutely not what they were arguing, that they did not need to disclose the payment. They did disclose the payment. Okay. So I wish that they could get their details right, because the details here are so important. Thank you.
This gave Judge Cannoni those grave concerns. That was the big quote when they met the last time.
Yeah.
So
the big quote that was left to hang out there for an entire week, And while we're at it, because now this guy's pissing me off. Hold on. Now, while we're at it, I want to take a look at Rule 3.3, because this is what, you know, the judge is like hanging her hat on. And what Brennan seems to be hanging his hat on, and this is the ABA Rules of Professional Conduct, which I'm assuming is basically the same as Massachusetts, because this is just what I pulled up quickly. And this is Rule 3.3. And many of you don't know that in addition to taking the bar exam, as to become an attorney, you also have to pass an ethics test. It's the Rules of Professional Responsibility. It's a separate test on a separate day. Not in coordination with the bar exam. It's done totally separately somewhere else. You can schedule it at your, I don't know. I don't even know when they do it nowadays, but they are not done on the same day. It's a totally different thing. So here it is, Rule 3.3, Candor toward the tribunal. And here's what they're hanging their hat on. And this is paragraph A1. It's A1, and she keeps talking about A1. A lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. Yeah, and here's the thing, Mel. It's okay for Brennan to get up there and lie. Bold-faced lies about waving his papers around, his whole monologue that he practiced in the mirror for a week about how he was sending 2 letters to the feds and he's been down that dark road before and it's a never ending nothing. And, he had to get this information from the feds. The emails, he was talking about the emails between Alan Jackson and Dr. Wolf from ARCA. And he was the email where Alan Jackson said, we'd like to retain you. And then Wolf sent a letter back saying, no, the feds say we have to pause. Then there was another email. And then with regard to coordinating his testimony and when are you available? Can you give me your background, your CV, which he did. And then Wolf sent Alan Jackson back an email on a Sunday night, the night before he was going to testify, with a list of direct examination questions drafted by Wolf, because remember, Jackson was not allowed to prep Wolf under the terms of the federal protective order or whatever. And so Dr. Wolf was probably like, I'm coming in to testify tomorrow. I kind of would like to have an idea about where you're going to go, in addition to like my background and my report, because that's exactly what it testified to, was what was in his report, that the feds hired him to investigate and to perform that work. And when Brennan got up in open court and started making these wild accusations that he had to get this stuff from the feds, Alan Jackson is basically a snake. He's been hiding this stuff from me. He's violating the rules of professional responsibility and pointing to this rule. And this was not the sanctions motion he was arguing at that time. That was the motion about ARCA. And about how he's hiding from everyone, that ARCA is impartial because they're not impartial, because they're working for the defense. And here's the thing. The prosecution had the opportunity to call ARCA too. Both of them could have reached out to ARCA. They could have called ARCA and discussed their opinions with them. They chose not to. They could have called them in as witnesses. They chose not to. So Dr. Wolf and Dr. Rentler traveled from Pittsburgh or wherever they came from twice, once for the voir dire and another time for testimony. After the voir dire is when Wolf sent that email. The day before, it was a Sunday night. You think Alan Jackson was sitting around waiting for these questions to come in from Wolf before he had it? He already had his questions ready. He probably didn't even see the email. And then they mail a bill to the defense after the trial's over for $23,950 or something like that. And then the defense calls the feds and they're like, well, what is this? We got a bill. Are we supposed to pay this? Can we pay this? And they said, yeah, you can pay it. So they pay it in July. So all of these blatant lies that Brennan got up there that caused the judge to have such a panic attack that she had to take a half-an-hour timeout and come back shaking like a leaf, because she was so apparently disturbed that Mr. Jackson said, we didn't hire ARCA, because they didn't hire ARCA to do the investigation and the reconstruction. They paid them for their time and testimony after the fact. And then she starts asking them these questions in open. Like, it's okay for Brennan to get up there and lie, basically, make a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. He's so dirty. But you know what? The defense doesn't have time for it. They don't have time for it. They don't have time to go make motions against Hank Brennan and try and bring him up on ethical charges and try and get the judge to report him to the grievance committee or whatever committee it is in Massachusetts that, governs lawyers. Here in New York, it's the grievance committee. And so when you want to get up there, Mr. Brennan, and start spewing and quoting from the rule of professional responsibility 3.3, candor toward the tribunal, maybe you ought to think about yourself. But it's almost like he doesn't even realize that that's what he's doing. It's wild to me. It is absolutely wild. And it's dirty. And he's just trying his best to get Alan Jackson off the case. And the way she made each one of them stand up in open court and get the public spanking from, the dean of the dean of students, the guy, the disciplinary guy, in Catholic school, who calls your mother 3 times a week to tell her that your son's hair is too long because it's like below the collar of his shirt. Yeah. Brother Joshua, I remember you. Anyway, that's what it was like. Getting them to stand up and say, don't you know this, don't you? So I don't know if that was the way that she was just, trying to get them on board and like she's not really going to do anything about it. But it was wild. Yeah. Somebody said in chat yesterday, how many people have had to have blood pressure medication prescribed for them since they started following this trial? And there were quite a few. Right. So Mel said Judge Bev has no problem with Brennan lying about the defense, this time saying said things about the federal investigation that she shouldn't have, and then revealing she couldn't have known. Yeah, that's true. He did do that as well. Right, because she said that on the 18th. He wasn't notified until the 19th. And then he didn't even tell the defense until a week later. Like, this whole thing is now so dirty. Remember when they brought Brennan in and they said, we're bringing Brennan in because we want it to be a fair trial. And he came in and he's like, I'm going to make this a fair trial. Yeah, fair for who? Fair for the Commonwealth? While you try and prevent the defendant who is being wrongfully persecuted from presenting her actual defense by trying to knock out all of her experts that are going to kill your case again, and by trying to get rid of her attorneys and dismantle her defense team. It's dirty, and I don't like it. And let's listen to this a little bit more.
This to mean that she's leaning toward punishing those defense attorneys.
I think that's the correct assessment. What she asked about today, again, is still on her mind. Were there misrepresentations and misstatements made to the court with respect to the accident reconstruction experts? And she still hasn't got the answer that she's looking for. She asked Attorney Alessi, you said you inferred there were no further contacts. Were there any other contacts between the accident reconstruction experts and counsel? And he said he didn't know, and no one from the defense table answered that question. And I think that's...
Yeah, that I did notice that too. And I didn't point it out yesterday. We don't know when it starts. It may start at 11. They're still in federal court right now because there's somebody who is tweeting live from the courtroom. They're still arguing right now. So I don't think they're going to be back by 11, but we're here for it. We have some papers to go over in addition to this. So when it starts, we'll be here.
A very, very...
But I did notice that, and I didn't like how Alessi said, oh, yes, I'm just inferring that. I wish that he would have confirmed that with the rest of the team so that he could have gotten up there and said, yes, I can confirm that there were no other communications. I think it would have been clearer. And I have to say that I agree with what he's saying, and I hope that can be corrected.
Very telling remark that the court is going to put a lot of weight in. She wants to be assured that the actions that were done were not done with the intent to mislead the court. I don't think she got satisfactory answers to that today.
Except when David Yannetti got up during the sanctions motions, fell on the sword and really said it was my fault. And I apologize. It was an oversight. I'm really sorry that I put in that message about Proctor, where Proctor was texting Lally about calling Alan Jackson an a-hole and not watching the closing. But really, he said that the world already knows how Michael Proctor feels about the defense team, because in the last trial, it was brought out how much he hates me. And he was texting his friends about how much he hates me. I don't think that's prejudicial. I don't think that I don't think that it's prejudicial, and I don't think that it's a surprise. And, it's not really harmful, but I do apologize, Your Honor. I do apologize. And I don't think he did that with an intent to, violate that protective order. And the protective order was based on safety, and really there's no safety issue here and some other things. So here we go.
Some other experts during the hearings today, it was questions about the qualifications of two of the prosecution's potential witnesses. That's Dr. James Crosby, the dog bite expert.
Oh, it's James,
and
not
meteorologist
Stephen.
Robert
Good.
Gilman. Now, the defense wants those guys thrown out. They sound like experts to me as a layman, Michael. How does the judge decide when an expert can indeed testify?
Well, she looks at the
They sound like experts to you. James Crosby, the guy who's a canine behaviorist who is not a medical doctor, seems to be qualified to you to come in and testify about the wounds to John O'Keefe's right. I can't even listen to this. I'm just going to fast forward to the part where Ronnie talks. All right, here's the juror. Hold on.
We look towards the second trial. We are also getting new information about how Reed's first trial ended from someone we haven't seen until now. One of the 12 people who...
You might not have seen him, but we've seen him because Aidan Kearney did a show with the juror. He got the exclusive, not you.
Sat in these chairs, listened to all the arguments, only to have the trial end without a verdict. That juror speaking to our Eli Rosenberg tonight.
Kind of overwhelming at first, and then it got very interesting, and then at the end, kind of disappointing.
You had this front row seat. What do people not understand?
It's difficult for some of the public to understand why we arrived somehow to our conclusion, but it was totally based on the evidence that was provided to us and that we could actually consider.
At the time, there were a couple things during the trial that were a huge deal as it happened on the outside. And I'm wondering, did it resonate with you? One being the testimony of Michael Proctor, the lead investigator, and those texts.
It was very surprising. It was very unprofessional. And at that point, most likely we would discredit or not consider his testimony as strong.
Another big thing was this Google search. How's long to die in the cold?
We didn't believe that there was enough evidence or expertise to kind of indicate that it was reliable. It did not appear, at least to myself, that she intended to commit murder. The other piece, which was the leaving a scene of an accident, also did not appear very clear, and therefore everybody voted for those two charges as not guilty.
It is interesting that he chose to wear pink and a pink bow tie. He wore a different bow tie every day to court, from what I hear. And, to me, this case is simple. Did John O'Keefe get hit by a car? Yes or no? And I don't think he did. And I don't think there's any evidence that he did. And the injuries don't say that he did. They certainly don't prove it. But this juror seems to think that the rest of the jury was unclear about whether she hit. Some of them, I guess, thought that she did hit him, but she didn't know she hit him, or she didn't hit him on purpose. And some of them were like, hell no, he was not even hit by a car. And that's where it ended up.
Second charge, that was the one that was very debated in terms of whether ultimately she did it, became questionable. And now that is where there was reasonable doubt in some minds. Unfortunately, we didn't get clarification early on that we could look at each charge individually and independently of each other. If we had done that, then I don't know where we would be or if we would be talking today.
Do you think
Right. He said the jury was not clear. The jury was not clear. That it was not clear. They didn't know what they were allowed to do. They didn't know what they weren't allowed to do. The jury instructions were fakakta. They were hard to understand, and they didn't get it. And I'm glad that he came out and did this interview last night before they went to argue this in federal court. Not that anybody who's hearing this in federal court might have seen it or heard it, but to know publicly that the jurors were totally confused about what they were allowed to do and what they were not allowed to do may at least serve as a vehicle to have the jury instructions in Massachusetts revised so that they're more clear, especially when it comes to split verdicts. and the fact that there's more than one count, because most of the case law refers to cases that only had one count. And this had 3. And the second count had multiple lesser includeds underneath it. So it was hella confusing.
There was going to ever be resolution on that second charge?
I honestly believe that there would not have been any resolution because some people had very good arguments. And at that point, it was just trying to convince people and change people's beliefs, which would not be possible.
Our thanks to Eli Rosenberg for that important interview. Eli will have part 2 of his conversation with that juror coming up tomorrow, including his advice for Karen Reed, her lawyers, and for prosecutors as the second trial is set to start next month. Well, let's bring in our courtroom insider.
Oh, no, let's not. Let's not. We've got beef with her. We're not listening to her. All right. Their feed is up, but they are not yet over in court. So thank you, Lo, for putting this in the chat. Judge Saylor, that is the federal judge who they were in front of this morning. I believe it's over now because it seems that Judge Saylor says he will issue his opinion as quickly as I can under the circumstances. Mr. Weinberg, who, as you know, is the appellate attorney for Karen Reed, said it's a wilderness. It's a thick forest. Anyway, judge notes. So thank you for that. That was the tweet by J.M. Lawrence, who is at Boston Justice on Twitter, for those of you who choose to wade in the cesspool of Twitter. So I guess he's going to issue his opinion as quickly as he can under the circumstances. And I don't know how long it takes to get from wherever they are in the federal courthouse to Dedham, but we're here for it. On top, thanks via super sticker. Juan is here from South Africa. I think that's South Africa. I mailed you some designs free to use. Thank you. I'll take a look at them. I usually don't like to use other people's designs just because of like copyright issues and, claims in the future, and they have to be on, on tone with my branding, but I will take a look and I appreciate that. Thank you so much, Juan. Chloe's in Scissors is here from Canada and says, this is one of the many, many mispronunciations in addition to Alisi, in addition to calling himself, instead of a prosecutor, a prosector. A prosector is someone who dissects dead bodies. So he is the prosector, Hank Brennan. He also spells his name wrong in many pleadings. Chloe's in Scissors is here. Melanie, would you really accept anything less from mainstream media? Yeah, I guess not. I guess, I don't really watch it much anymore. So I guess, when I see it, it enrages me. It outrages me. I'm going to try and stay calm today, though. I'm going to try. Although I don't think so. It's not going to last long. It's not going to last long. Also, why hasn't the Commonwealth been sanctioned for not following the preservation order from a judge in 2022 when Karen was arrested? Well, that's what we're hearing today. So we really are hearing today the motion to dismiss, in which the defense is saying, listen, Your Honor, listen. They had all of this video for such a long time. They've had this video. We all know they've had this video. And they should have known that they had this video. For him to come in here and say, I didn't know we had the video, is incredibly disingenuous. And so therefore, you need to dismiss this case because the prejudice to Karen Reed is overwhelming, and it outweighs any prejudice to the Commonwealth. It's about Karen Reed getting a fair trial, Your Honor, not the Commonwealth. And they had all this video, obviously, before the first trial. They didn't turn it over. In fact, they're still turning it over. They turned over video. We heard Alan Jackson and Eliza Little say in court yesterday, they turned over something like 9 or 15 new videos that took Liza an hour to download, after 10 p.m. Pacific time. And so they hadn't a chance to look at it. The quality sucks. They're blurry. The new video that they just turned over, I think on January 28th, is blurry in the area of the right rear tail light, but it does show the right rear tail light area of the car, but it happens to be blurry in that area. These things have no metadata, and therefore, how can she possibly have a fair trial? The only remedy, the defense is saying, is to dismiss the charges, dismiss this case, send her home. And whether or not the judge thinks those violations of these discovery orders are going to be egregious enough on the Commonwealth's part to dismiss the charges remains to be seen. But we have seen how this judge has been ruling for the past however long she's had the case. This has been going on for 3 years. But we did together all the pretrial motions, all the pretrial hearings. We've seen it. She didn't recuse herself. She didn't dismiss based on the shenanigans that went on at the grand jury. She didn't dismiss the indictments then. She didn't disqualify Morrissey's office from hearing, from being on the case. So we've seen how it goes. It's not our first rodeo. We've been here. And so what should happen and what's going to happen are two totally different things. Fire on acid, bets on Bev interrupting AJ today. Oh, 100%. I mean, the odds on that are like, 1 to 10. It's like reverse odds on that. Anyway, Skanky Brennan took a week to tell the defense, but yet some in the public knew. How interesting. Yes. There are some people who hate Karen Read that want to see her stoned to death before they hang her in Times Square, hang her in Town Square to really, do her off. Those people seem to know all about it. You know who they are. We don't talk about them in the chat, and because we're classy like that, but how do they have all this inside information? How did they know the inside information? When there was some alleged party at the VFW hall, how did they know which way the jury was leaning and what their split was in the middle of deliberations? I have questions. Hi, Tracy Walker. Do you think the smear campaign for the defense team will have results? I mean, the smear campaign against the defense team and have results? How so? Do I think that the Commonwealth would be punished for misstating facts? I doubt it. Do I think that in any event that the defense even has time to make that motion? Probably not. Do I think that, what the real big problem about all the misrepresentations that Brennan made is that the jury notices are already out. So people already have jury duty notices. Many of you have written me or commented in chat or in comments that you have a jury notice for around April 4th or April 1st. And so you think you're going to be called in on this case. So people already have their jury notices and he's out there saying all this stuff, tainting the jury pool. So I'm not really sure, Tracy, what answer you're looking for or what question you want answered. But I think that what he did was heinous and dirty. And I think that that's what we're in for. That's the way this whole trial is going to be. Bulldog Mom has been here for 8 months. Will is outside the courthouse. Yeah, he was there yesterday too. Thanks, Bulldog Mom. Midnight Mike says Yannetti blames himself. Brennan blames the defense. Yeah. Yeah, and Brennan can't even pronounce Alessi right. So, I mean, really, dude, come on. Every morning, the judge says, "Good morning, Mr. Alessi." Like, can you not get it? Is he doing it on purpose just to be disrespectful? Probably. Stranded in Duluth became a new member and is likely stranded in Duluth. I'm sorry about that. Margaret Hutchins became a new member. Welcome. Charlie appreciates me. Thank you, Charlie Blue. Sandy, hi, Sandy B. If Bev lets Crosby in, the defense could ask, how likely is it that a dog that has attacked people before would attack a person who is fighting with an owner in the Albert House? Yeah. Because that's really his specialty is canine aggression, right? And they can talk about the breed. He was a German Shepherd. She was a German Shepherd. Who even knows if it was really Chloe? We still don't know. I don't think that he should be allowed to testify. There's no world in which I live or practice law that he would be allowed to testify. But again, we are in the upside down, inside out Chronicles of Narnia matrix. That's where we are. And that's where we're living. And we all live here. Water off Leslie's back says Bev is henceforth known as Umbridge. Well, we've been calling it a Shakespearean tragedy. And so we've been calling her Lady Macbeth because that is really what is going on here. It's Shakespearean in so many ways. Amber Bauer is here. Good morning. I hope the defense can get the metadata to that photo the dog whisperer is going to use to measure the wristband. Photoshop much? I don't know. I haven't seen the photo, so I can't opine. I do know that I think there were some autopsy photos in which John O'Keefe was wearing a hospital wristband on his wrist, but I do know that no photos were taken with the proper ruler that is used. So that remains to be seen. Penetrometer soil tester is here. See, you guys change your names to match the case, and you're amazing and you're funny, and that's why we call you the Snark Tank. Says because Bev is the top, no other judge will say anything. Yeah, pretty much. Judges are not going to speak out against her. No. There are judges from other jurisdictions who have spoken out. I've been contacted by a judge in my comments who's a judge for 25 years, and she's horrified by this. So Look, in Massachusetts, publicly, a lot of people are afraid to speak. I live in New York. I'm outside of Massachusetts. I never have to walk into a Massachusetts courtroom unless I'm walking in to watch a trial like Karen Reed. And trust me, when Mark Betterow and I were in the courtroom, the judge knew exactly who we were, and commented to defense counsel about us being there. So, we maybe, well, at least I maybe persona non grata. We'll see if she lets Betterow on the defense team. That still has not been ruled on, and we're still waiting for that. My thoughts on that are that perhaps they have not supplemented their affidavit because they are waiting for to see what happens today with Aidan Carney's case. If Aidan Carney's case is dismissed, the motion to dismiss is granted today. That may, smooth the path for Betterow to get in on the Reed team. So there are some things, I guess there's a lot of balls in the air. And so we just don't know. How long till federal court opines and tells us, well, we just read the tweet from the guy who's in the courtroom, the reporter. I'm sorry, he's not a guy. It's not like the guy, tell the guy not to go in the house. JM Justice. It's a girl, I think. It's a girl. Yeah, it's a girl. The woman who's in the courtroom, her name is J.M. Lawrence. She's a journalist, and she writes for the Boston Globe, Boston Herald, Bloomberg, and The Guardian. And she says Judge Saylor says he will issue his opinion as quickly as he can under the circumstances. That's when Mr. Weinberg said it's a wilderness. And then the judge said it's a thick forest anyway. So I don't really know what that means. But she was in there. She was live tweeting. You can look at her tweets on J.M. Lawrence at Boston Justice on the cesspool of Twitter. Now they're going to put on some really annoying elevator music, and I can't have it. So I don't know. They know that they want to start the trial on April 1st. So perhaps Judge Saylor is going to work on this and only this. But apparently they did argue today. So based on her tweets, it appears, and I'm just going to scroll down through this because I haven't had a chance to read these in full yet. It says he will consider her claim de novo, which means de novo. The literal translation, anew, from the beginning, afresh. He will consider it anew without deferring to the SJC's decision. So he's taking a whole fresh look at this thing. A whole fresh look. It's fresh. And that's good. I don't know how long it's going to take. Kelly Hank Breenan's the pro sector's lost spell check. Well done. Can you feel my blood pressure raising already? Buys Bev and huge fibber Hank. Make my blood boil, please. P.S. The irony isn't lost that I forgot to delete the S off Brennan. Well done. Robin's Landing. I'm still confused about the import of the defense paying the bill from ARCA. Can you explain why it's such a big deal? I happen to agree with you. I think what the judge is so mad about is that she thinks that the defense lied to her. She thinks they lied to her. It's not, I don't think she has such a big problem that it was exchanged late. Although she did say, why didn't you give it to them right away? Like in July after the trial was over. I think that she thinks that they lied to her. Sidebar, when he said we did not hire them, we have no more things to give the Commonwealth. And remember, and this was in the context of the Commonwealth looking for automatic discovery. Hank Brennan made a motion. It wasn't even a motion. It was like a statement that we intend to make a motion to exclude ARCA based on our predicted opinion that the defense team is not going to be able to comply with Rule 14. And Rule 14 is automatic disclosure. And what you are required to turn over in most cases when you hire the expert to do the work is all of the materials that you gave the expert to review to formulate their opinion. And so since neither side was in possession of the things that were given to ARCA by the feds, Hank Brennan said, I intend to make a motion at some point in the future to preclude them because you're not going to be able to comply with Rule 14, nanny, poo-poo. And so Alan Jackson's argument was, look, we can't comply because we don't have the stuff that the feds gave them. We don't really know what they gave them, but they kind of do, because during the voir dire that Lally did of these experts all the way back in the middle of the last trial, there was a list of like 14 or 17 items that they reviewed in coming to their conclusions. And I think that both sides have them. That's why I'm confused about why this is such a big deal. So then what had happened was, at sidebar, he said, we didn't hire them. We don't have this material to give them. And she's thinking that's a lie because you did pay them. Now, my lawyer brain is saying, well, paying them after the fact and hiring them to do the reconstruction are two totally different things. That's my lawyer brain. Then also, another little wrinkle happened when Ms. Little, no relation, made her motion or her response to the motion the other day, to this motion. And she said that the defense did not hire or pay the ARCA experts. And that, she said, she fell on the sword and said that was a misstatement. It's usually, it was a mistake. And even before I think she turned in those papers, they had turned over the invoice to the Commonwealth. And I'm here to tell you also that when you hire an expert to come in and testify for you, or when you call an expert to come in, or when you even call a lay witness to testify for you, you're not going to call in someone who is not favorable to your side. You're just not. So, it didn't really matter in the end anyway, because according to Ronnie, the jury, if you watch the entire interview on Turtle Boy's YouTube channel, which I urge you to do if you haven't, because Ronnie's interview is invaluable to the defense in this case, because now they know what to hone in on. They have get to be a little fly on the wall inside of that jury room, which nobody ever gets to do unless a juror speaks. And they know now what the jury was talking about, what they were thinking, why some people were thinking a certain way. And we know from what Ronnie said during Turtle Boy's interview is that they didn't really give ARCA a lot of weight, those witnesses, because they didn't know where they came from. And they thought they were either hired by Turtle Boy himself or hired by Karen Reed's auto insurance company to defend a car accident case. And so they really didn't give them a lot of weight because they didn't know where they came from. It is my opinion that had that jury known, if the defense had been able to retain them, and if the jury knew that they were retained by the defense, they would have been given more weight by the jury. Right? Because they knew Trooper Paul was hired by the Commonwealth. And so, Lally had the opportunity to ask Dr. Wolf and Dr. Rentschler anything he wanted at the voir dire. Nothing was off limits. And he didn't ask them anything like that. He didn't ask them, have you talked to Alan Jackson? Have you talked to the defense team? Has anybody agreed to pay you for your testimony? Has anybody paid you for your time? And then when Dr. Wolf was asked that on the stand, the question was, have you been paid? And he said, no, we haven't been paid anything. So, and that was all true. So, that's why it's allegedly a big deal. If that's a long answer, it could have been shorter, but that's what I think. Exactly. Thank you, Kathleen Potter, for your super sticker. I appreciate you so much. Nina, thank you for tuning in. Couldn't the weather expert be good for the defense? Officer John O'Keefe drunk, fell on his head on stone hard floor, etc. Reasonable doubt. I'm sure that he will be cross-examined about all of those things, but the weatherman's not going to be able to testify about how drunk, if any drunk Officer O'Keefe was, although we do know from the testimony of the medical examiner that his blood alcohol content at autopsy was something like 0.28. I don't recall the exact amount, but it was something like that. And it was like, that's like over 3 times the legal limit. And that might have dissipated a bit from the actual time of his death. So, there's that. Christina McVeigh is here, and she's putting in a super chat and says, first ever chat. Well, thank you. Welcome. The mods are a little strict here, but we deal with it. We don't like trashing other chatters. We don't like the defamatory comments. We don't like rumors, speculation. We're based on facts. We don't like people trashing other creators. And, if people can abide by those guidelines, then welcome. I'm sure you can. Christina McVeigh. Orphaned methodology is here. That was fantastic. I put that on my thumbnail for today, along with wake up to find out that you are the eyes of the world and a little Easter egg of a dancing bear next to it. Because if you know, you know. And you guys are the eyes of the world, and the eyes of the world are watching. God save the Commonwealth. She says, Tracy says, I think the Commonwealth couldn't get a conviction against Karen Read, so they're now attacking defense team credibility. Yes. It's sad because it's so obvious. Yes, I agree. John was not hit by a car. You state that perfectly. That's it. That's it. That's how I became interested in this case. In addition to the personal ties that I have to Norfolk County, Massachusetts, and the knowledge that I've been told for decades that the police there are corrupt. And look, we're not here to bash police because I do back the blue 100%. But that's where this case begins and ends with me. Was John O'Keefe hit by a car? If the answer is no, that's it. You go home. It strains credulity, and I've got merch that says that, to think that Trooper Paul's hypothesis, thesis, conclusions, it could in any way be realistic that Karen Read could back up into John O'Keefe 60 feet at 24.2 miles an hour, hit him in his arm, which is, extended, he said, like this, only hit his arm, which then allegedly smashes the taillight into 47 or so pieces, which then all at the same time magically rise up and lacerate his right arm in perfectly linear abrasions. Because remember now that the taillight pieces have morphed into triangular teeth-shaped pieces. And then he is pirouetted and thrown 30 feet onto the lawn, where apparently he smashes his head on frozen ground that was hard as a rock, according to the weatherman. And that's how he fractured his skull in multiple places. It strains credulity because guess what? No fracture to his arm or his elbow or his shoulder. No fractures to anywhere on his body other than his skull in multiple places. Temporal fractures here, 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 back of the head, big gash, cracked it open, brain bleeds in multiple locations on the brain. And I've been saying, I've been screaming into a closet, let me in, coach, let me in, let me in, let me cross-examine Renee Stonebridge, please, Dr. Stonebridge, please, pretty please, because she's got it. She's got all the answers right there. She's got all the answers right there in her hand. It's like a gift. It's like a gift. This man was not hit by a car. There's no bruising to his body. There are no bumper marks to his body. Many of you have probably been hit by a car or know someone who has been, and you will have at least bruising. If that car hit his elbow and arm and forearm hard enough to shatter a polycarbonate taillight, his arm would have also been shattered. It's just common sense. You don't need to be a biomechanical engineer to understand that. You don't need to be a medical doctor. You don't need to be a canine aggression expert to know that John O'Keefe's body was not hit by a car. Anybody ever hit a deer? It will total your car if you hit a deer. I don't know. I can't. I could talk about it forever. Tracy says, I think the Commonwealth couldn't get the conviction, so now they're attacking the defense. Oh, this is exactly what we just said. Yes. And I think you're right about that. And I think, yes, now they're trying to get rid of all the experts that prove that John O'Keefe was not hit by a car. They're trying to dismantle the defense team one by one. And it's dirty. It's dirty. Shouldn't we be after the truth instead of a conviction? Shouldn't we? I don't know. I kind of think we should. A lot of prosecutors that I know think that that's what the prosecution should be looking for, is the truth and not just a conviction here. Gail Taylor says, big fuss yesterday about the defense using media, et cetera. Yep. Commonwealth must have leaked the federal news. Public informed immediately by the other side. Yep. Thanks for your super chat. Nathan, for the impeachment evidence in first trial, wouldn't Jen's cell data have been in the prosecution's possession already and wouldn't need to be turned over? Yes. Yes, it was. They had it, I think. And I'm not quite sure whether it was her location data from her phone or if it was the Life 360 data that they had. I'm not quite sure. But they did have it. And I guess that order was so strict that they had to turn over exactly what they were going to impeach her with, which again is, I don't know any other jurisdiction that requires the defense to turn over their smoking guns to the prosecution so that the prosecution witnesses can be prepped using those smoking guns and therefore taking away the smoking gun. So that's wild. Thank you for your super chat. Riley is here. I wrote my thesis on vet med overlap in forensic medicine, and I think his injury is consistent with a dog inflicted injury. Thank you, Riley. We have an expert. We have an expert in the chat. She's here. Her name is Riley, and she knows. So many of you write me emails, and I appreciate you so much for that. And you just lay the knowledge on me and your knowledge on me. And you guys know. All right, we have some new droppings here. Oh, interesting. All right. Let's take a look at this. This is the Commonwealth's updated exhibits for the motion to dismiss that we're going to hear today because, you know, Mr. Jackson was scheduled to go back. He would miss his flight if they had to stick around until Friday. So let's take a look at this. So we have an idea of where they're going to go. I do have the the court TV feed up. So we will go to that as soon as the cameras are up. It seems like from the tweets that we read that they are en route, the defense team, from federal court to Norfolk Superior. So I'm going to take this down. I'm going to put this up. And this is docket number. Oh, thank you again, Riley. Let me take that down. Hot off the presses. This is docket number 544. Commonwealth's updated exhibits on their motion to dismiss for the hearing today. Today is not different. As somebody said, is today different than yesterday? Is it the same judge? It is the same judge. There are different motions that are going to be heard today. First of which is the motion to dismiss for egregious governmental misconduct. And that is based on the prosecution's failure to turn over Brady evidence. For example, that all of the Sallyport video that they produced during trial that was inverted and that was perhaps altered, and for failing to provide chain of custody logs and all of the dribs and drabs of Sallyport video that keeps coming out, even though they said it was overwritten in 30 days. And their violation of the court orders to preserve the evidence related to this case. And, you know, Hank Brennan's argument that there was no court. First of all, there were 2 court orders for them to preserve the evidence. And prosecutors are held to a higher standard than defense attorneys. They are required to preserve all evidence. You don't need a court order to tell you to do it. You're supposed to just do it. And for him to make this hollow argument that I didn't know there was video. I didn't know. They didn't know. Nobody told me. Some of it's on a retired detective's hard drive or iCloud and or paper file, and none of it has metadata. And it's just, it was never authenticated. Who knows if it's even real? You guys follow microdots on all of the things. Okay. We also are going to have the Commonwealth's opposition to the motion to dismiss, because remember yesterday, Brennan said he didn't have it. He didn't have any written opposition. Did he not have any written opposition? Oh, this is on Carney. Never mind. Hold on. Never mind. That's on Carney. We have the opposition on Carney, which we are going to go over in the event that we're juggling a lot of balls today, you guys. We're juggling a lot of balls. But that's the way we do it. All right. This is the Commonwealth updated exhibits for the motion to dismiss hearing that is happening in the Karen Reed case. As soon as they get to court, I have the feed up. And it says attorneys are on their way. Live court will begin around, oh, now they're saying noon Eastern. Okay, so we've got some time here. We've got some time. They're saying, but they may come on early. Right now it's 11:31, so we have time to go over a couple of these papers. Here are their updated exhibits. A transcript of defendant's interview with Ted Daniels. Air date 2/9/25. Video of Canton PD Sallyport inverted camera. Oh, now they're going to call it an inverted camera. Oh, isn't that rich? Isn't that rich and sweet? Now it's an inverted camera from January 1 of 2022. How do you have that video when you told us and the world and court everything was overwritten in 30 days? How would you still have video from January 1st of 2022? Was that like a thing when it became New Year's Day, 1122, everything flipped? Like we were afraid was going to happen to all the computers worldwide, at the turn of the century? Really? The inverted camera. Video of Canton PD Sallyport grainy camera from 12822. Oh, the grainy, they've got an inverted camera and a grainy camera. You see the spin? Does anybody else see the spin, or is it just me? There's an inverted camera and a grainy camera. I can't wait to hear him get up there. And the writing and the date, right. The writing and the date and time flipped twice. Right. Yes. Like a triple Lutz. Give me a gymnastics reference to what they do when they go up there and they flip around. They flip around many times when they're doing their floor exercises. Wow. Trial testimony of Trooper Nicholas Garino on June 20th, 2024. Main driveway, side exterior Sallyport video. Is this the new one that they just turned over that shows the back of the Lexus? Alan Jackson said in open court that it was a triple layout. Thank you, Tara Ellis. Tara Ellis is here with the triple layout. Yeah, the TikTok camera from 1122. Yep. Alessi, orator extraordinaire, says, I'll believe it when I see the metadata. Won't we all? Show me the metadata. I did see that his motion to dismiss was responded to. I have the papers. I also have the stream set up for 2 o'clock, but it looks like we may not be able to do that in real time, and we may have to do that on replay. Okay. Main driveway, side exterior Sallyport video. There's no other, explanation for that. No date, no time, no length. Just guess. Video of defendant's vehicle from One Meadows Avenue driveway at 5:08 a.m. Oh, yes. Oh, here's what they're doing. So that's the video where she's backing up into John's car. Okay. In the driveway, because she didn't normally park in the garage, I don't think. And so she backed out of the garage. He had cleared it out for her because it was snowing and he wanted her to be able to park in there, and she backed out and she hit John's car, the Traverse. Photos of defendant's vehicle from cruiser camera during the wellness check at 8:22 a.m. Remember also, there was no need for a wellness check because Jennifer McCabe, Kerry Roberts, and everyone else who was flapping their gums to law enforcement knew the nephew was at a sleepover and the niece had been picked up by somebody else, and they didn't need to do a wellness check. So why was that police officer there? I don't know. But now, and you remember during the first trial, they showed this video, and I remember we were waiting on the edge of our seat. They show the video of the police cruiser coming into the driveway and pulling up behind Karen's car. And it was like a cliffhanger, and we're waiting. I think the officer went, and there was some video of him like at the door, like banging on the door. And then we're waiting. We're like, okay, what is it going to show? What is it going to show? What is it going to show? And then the cliffhanger ended. And then there was like a weekend or something. And then they came back and nothing was ever pointed out about it. And we're like, what, huh? And everyone on the other side of this is going to tell you that that cruiser camera shows that her right taillight was completely shattered. However, we can see that it's fully caked in snow, so you can't even see what it says. But now we know that the Commonwealth experts, and I use that term loosely, have clarified the video. It's a triple Lindy. I thought you said triple Lally, and I was going to say, yeah, it's a triple Lally and double proctored. Triple Lally and double proctored. I'll allow it. They've clarified the video. So now they have further altered the video. And can we really trust them at this point, Your Honor? Worldwide audience, can we really trust them? Everything is missing. Tow truck driver pictures. Yep. Nerdy Dog Mom is here, and she knows because she's looked at the ExacUvision manual. Inverted is an option, but you have to choose that, right? Doesn't automatically record that way. So there's that ridiculousness. Yes, the date on the inverted video is prior to John's passing because they want to show Rebecca that this is just the way that camera always recorded. But even if it did, you got a huge problem as an officer of the court when you're putting up an inverted video and not telling the judge and the jury that it's inverted and asking your witness to authenticate it as a fair and accurate representation of the way the Sally Port looked on that day. And he says, yes, Buchanan. And then you continue along. And then it's not until cross-examination, which wasn't even the next day. I think there was a break or a weekend or something. So we had time to prep on that. And then Alan Jackson said, well, isn't it backwards or inverted or mirrored, whatever you want to say? And Yuri's like, yeah. And he goes, well, didn't you say it's fair and accurate representation of the way the Sally Port was on the day in question? And he says, well, yeah, it's, fair and accurate, but it's like when you look in a mirror, it's like flipped. That was wild. That's perpetrating a fraud on the court. So even if it did, which I don't believe for a second, always record that way, I think it's a problem for them and their candor to the court. Remember candor to the court, Rule 3.3? We looked it up. Video from alarm.com, number 1. What is that? What is the video from alarm.com? And alarm.com, number 2. Are they coming up with more video? Anybody know? Alarm.com? That's not Ring. Did they all of a sudden find some video from a neighbor? Hello. No, it's not typo, Barney. They're saying that's the way that camera always recorded, and we can prove it to you because we've got video from January 1st to show you that's inverted too. What's alarm.com? Similar to Ring. No, John had a Ring camera. Isn't that different? John had a Ring camera, so the Ring video footage is from John's house. And that is when it says video of defendant's vehicle. Oh, see, they're very careful not to say Ring video. This is like a whole bunch of we're in a land of confusion. That's on our playlist for this. That's a Genesis song for those of you who don't know. Land of confusion. We're in a land of confusion. They don't say Ring video of defendant's vehicle from One Meadows, 5:08 a.m. But then there's some video from alarm.com. Maybe from Karen's parents' house. Yeah, maybe Emma. That could be. Thank you. Thanks, Emma. Emma's here. She's from Ireland. She's awesome. Slancha. Girl, Slancha. Could be. That shows the them coming into the driveway when they got home. And that shows them also backing up the car to put it on the flatbed tow truck. Then they have the trial testimony of ARCA expert Dr. Daniel Wolf on 6/24/24. Okay, right, in which he says we were not paid. Hi, Nurse Kim. Hi, Nurse Kim is here. Hi, honey. Oh, you look so pretty in court yesterday. I saw you in court yesterday. You look so pretty. What a day, huh? Was that crazy being there? I'll have to get the debrief from you. 5 alarm, AJ coming in hot. Yep, it's happening. It's all happening. Love you, girl. It's a Disturbed, land of confusion. Oh, Disturbed does a cover of that? Excellent. I'll take a look for that later. Thank you. 100%. It's her parents' house. Okay, great. Then in which Daniel Wolf says, no, I have not been paid. And then there's a transcript of defendant's unredacted interview with Gretchen Voss on 6/20/23. Okay, yeah, because she probably confessed to Gretchen Voss. Not. All right. So that's what we expect the Commonwealth is going to try and introduce into evidence today during this Michigas. The court feed is up. It's just not live yet. So we're waiting. Let us see where else we are. There is also Docket number 543. In which this is for today's hearing. So let's take a look at this. The Commonwealth wants to unseal portions of the audio from Gretchen Voss's story. Hang on. Commonwealth's motion, this is just filed this morning because, God forbid they file anything in a timely fashion. Commonwealth's motion to unseal recordings of Gretchen Voss and or Metro Corp. So they're moving to amend the court's December 5, 2024 order restricting the dissemination of all audio recordings produced by Gretchen Voss. And then they're saying that on February 11th, the Commonwealth moved without objection by the defense to amend the order to allow the audio recordings to be shared with members of the prosecution team to prepare for trial. They got their transcripts of a June 20, 2023 interview between Gretchen Voss and the defendant, Attorney Yannetti, Attorney Jackson, Attorney Little, and a certified official transcript from a July 13, 2023 interview between Gretchen Voss, the defendant, and Jackson. They're moving to unseal both of them in anticipation of trial, the entirety of both audio and transcripts for use in the case. And alternatively, the Commonwealth moves for partial unsealing. They want 4 pages of it, of the June 2023 transcripts to allow the Commonwealth to reference statements made by the defendant about the damage to her taillight in order to effectively rebut the defense's allegation of egregious governmental misconduct at a hearing scheduled for today, March 5th. And so that's Laura McLaughlin is allowed to sign something today. And so they want to be able to use them today because, the media is watching, and those are the sound bites that the media chooses to run with, as you know. So there's that to look forward to. The court cameras are still not up. They can use Karen's statements without putting her on the stand. That is an exception to the hearsay rule because those are what are known as statements against interest. That is a great question, Zach. Great question. So thank you for that question. Let us see here. All right, we are going to just go through this quickly. I'm not going to read the entire thing to you, but I can summarize it for you. This is the defense motion to preclude Dr. Wolf, the neurologist. Because I don't know how much time we're going to have. And they're supposed to argue this today. He also wanted a gag order yesterday, yes, but that was not in his papers, and it has not been ruled on yet. And again, sleazy. And then that's the, that's that's the headline that every mainstream media went with. Commonwealth wants gag order against the defense attorneys. It wouldn't apply to Karen. It would only apply to the attorneys. But again, Michael Marcy can get out there and make crazy hostage statements to the worldwide audience. No ramifications for his behavior. But let's gag the defense and also let's force them to seal everything moving forward, all of their motions, so that the Commonwealth, the Brennan police, and the judge can determine whether or not they should be released. Because we need to put them in the corner with dunce caps on. It's ridiculous. So this is the defendant's motion to exclude the purported expert testimony of the Commonwealth witness, Dr. Aizik, Aizikl Wolf, and a request for a Daubert Lanigan hearing. This is interesting because yesterday in open court, Liza Little said she filed this a couple of weeks ago. It is just stamped yesterday. I don't know if it got stuck on someone's desk and it never got scanned into the computer, but it is dated February 21st. So I don't know what happened there, but we were all like, I've never seen that motion. And so here's what they're asking. They're asking the court to exclude the entirety of the proffered and purported expert testimony of, I'm not sure how to pronounce his name, and I hate to butcher it, Aizik L. Wolf. Oh, you know what that reminds me of? Because I love musical theater. Fiddler on the Roof. Anybody remember Liza Wolf from Fiddler on the Roof? That was supposed to marry Seidel. Weren't they going to sell Seidel to marry Liza Wolf? And then Liza Wolf's wife came back in a dream, in a nightmare. I love Fiddler. I love Fiddler, one of my faves. Okay. Again, court feeds up. Don't worry, we're not missing a thing. So they want to exclude the testimony of Dr. Wolf concerning the medical cause and manner of death of the decedent, John O'Keefe, the mechanisms of injury and the conditions of the ground due to weather conditions. Okay, really? So they want this neurosurgeon to testify about the conditions of the ground. Okay, great. Again, Alessi is saying it fails each of the two main prongs of Daubert-Lanigan, the qualifications and the methodology. They say Dr. Wolf is not qualified to render an opinion or the opinion that he proffers, and also it is undisputed that he is not a pathologist, nor is he qualified to scientifically measure the material properties of the ground outside 34 Fairview Road. Yet, the Commonwealth is seeking to elicit testimony from Dr. Wolf about the decedent's cause of death, the mechanism of injury, and the conditions of the ground due to weather conditions. Well, sees the day, says, if I were a rich man, I'd sue the Commonwealth for my lost sanity. Karen has arrived. Okay, great. Let me quickly race through this. Thank you. Thank you for the update, sober hipster. So he thus fails the crucial qualifications of the Daubert-Lanigan. He is a neurosurgeon, and as such, he lacks the requisite background, training, and experience necessary to interpret an autopsy report because he is not a qualified or board-certified forensic pathologist. Thus, his expertise is limited to treating injuries rather than determining the circumstances under which particular injuries occur. Yes, I looked him up. He's a renowned brain surgeon, but he's not a forensic pathologist. He doesn't do autopsies. Alessi goes on to say the methodology that he invokes is replete with errors, as is demonstrated by his failure to acknowledge any contributing medical abnormalities of the decedent and his failure to appropriately address and consider the toxicology and autopsy reports. Therefore, here's my argument. He should not be allowed to testify. Although Dr. Wolf is a trained neurosurgeon, the Commonwealth has failed to prove that Dr. Wolf has a reliable basis in the knowledge and experience of his discipline to render an opinion in the field of determining manner and cause of death, identify pattern injuries, diagnose post-mortem hypothermia, and properly read and interpret an autopsy report, all of which require the expertise of a board-certified forensic pathologist. Bettero's with the team today. He's also due in court for Aiden at 2. So I don't know if he's walking in with them or if he's going to be in court. And that's awesome. Cool. All right, let's try and get through this. As a neurologist and a clinician, Dr. Wolf's background, training, and experience is limited to treatment. He's not a board-certified forensic pathologist and has no training or experience in determining the mechanisms of injury or the cause and manner of death. Bettero is there. Somebody said, so Bettero is there. And here we go on to say that Dr. Wolf's experience and training is limited to providing neurosurgical surgery services, specifically radiosurgery procedures for inoperable brain tumors. He does. He's a world-renowned brain tumor surgeon. While Dr. Wolf may be able to provide expertise on how one would treat a brain injury or provide neurological care, he lacks sufficient expertise in conducting the type of post-mortem analysis of the cause of injuries and death included in his report. In his report, Dr. Wolf repeatedly exceeds the scope of his qualifications by reaching opinions on cause of injury, namely, and here's what he says. Listen up if you've not been listening. This is what this brain surgeon is going to testify to or wants to testify to. The mechanism of injury was a fall backwards. The head injury was clearly inconsistent with any type of mechanism of injury, such as a bar or hammer or a car hitting him directly. The frozen ground was enough that when Mr. O'Keefe fell backwards, his injuries were sustained. Ultimately, his death resulted as a combination of the brain injury and his hypothermia. He may be a brain surgeon, but I agree with, I'm going to call him Dr. Alessi because he should be a doctor, that he's not qualified to testify about the hypothermia, the cause of his death, and whether or not he was hit with a bar, a hammer, or a punch, or smashing his head on a weight bench. Yeah, agree. This is what they're trying to do. And this expert's out of Florida because, guess they had to go to find one far away. He could never opine about the ground. That's crazy, right? He goes on to say, in fact, by law, a neurologist is not qualified to issue a death certificate declaring the cause or manner of death of someone who dies of unnatural causes. He's not a forensic pathologist, and he lacks the appropriate licensing requirements and training necessary to do this properly. A forensic pathologist is a physician who's undergone at least 3 years of anatomic pathology residency. You don't duck with Alessi when it comes to experts. This is his forte. This is what he does every day. This is why he was brought in, and he's working for free. And here, a pedologist. Do you know what a pedologist is? Because I looked it up. It has to do with soil. So Dr. Wolf ventures well beyond his qualifications as a neurologist and attempts to step into the role of a pathologist and a pedologist. Pedologist is a scientist who studies origins, composition, and distribution of soils and the materials from which soils are formed. It's a new word for us, pedologist, at least for me. I'm not a science nerd, so I didn't know these things. To opine that, quote, the frozen ground was enough that when Mr. O'Keefe fell backwards, his injuries were sustained, or that his death resulted as a combination of the brain injury and his hypothermia. And I have to agree with him here. He also says that the Commonwealth fails to meet its burden that the methodology of Dr. Wolf is reliable. In addition to whether he's qualified, the court also must determine that his expert testimony is reliable. Yeah, we should charge the ground. Did Alessi Google that? Oh my, was that so rude? Trisha, was that so rude when she said to him yesterday, did you Google that? Is that a Google search? And he's like, no, I actually picked up the phone and called like the director of the something, National Academy of Science or whatever it was, like the head MF in charge of this kind of thing. That's what I did because I got him on speed dial because, I'm the king lawyer of experts. Was that a Google search? Something funny, Judge Canoni? That was so rude, so disrespectful. Yes, disrespectful. I'll allow it. This isn't, where did we see a Google search recently in a case? It was in Delphi. In Delphi, where one of the investigators went out in the hall and Google searched something and then came back and testified about it, that he Google searched something about whether or not you could if you plugged the cell phone in to a cord, it had to do with that. That's what it had to do with. We're not in Delphi, although we might as well be, because I have said, and I said it when I think Allie was on my show, or maybe Andrea the other day, Andrea Burkhart. It's like Judge Canoni is saying a judge, go, hold my White Claw. I'm going in. We might as well be in Delphi. Delphi meets Norfolk County. Then he goes on to say that medical examiners as expert witnesses may base their opinions on facts personally observed, evidence in the records, and facts or data not in evidence that are independently admissible. And so he goes on to say that basically Dr. Wolf is not a medical examiner, nor is he accustomed to rely on autopsy reports and photographs to draw conclusions. And he offered no explanation of his methodology or of his analysis, fails to address or acknowledge the abnormalities present in the decedent, and I'm not sure what abnormalities he's talking about, and fails to acknowledge any evaluation of the toxicology report, both of which are critical steps that would be considered by anyone trained in forensic pathology in determining the cause and mechanism of injury. And so, therefore, XOXO, we don't think you should allow Dr. Wolf to testify. Oh, and this one is actually signed by Alan Jackson, so maybe he's handling this motion. But I thought Alessi said he was arguing this, so I'm not sure. But see how they actually use their actual signatures, and they do that, and no grammatical errors, no misspellings. And here's the affidavit that's attached to it. Oh my gosh! And this is so funny because I don't think he watches my show. I don't know if he does. But he knows that we make fun of Hank Brennan every single time he writes, my name is Hank Brennan. So he did it here. And I think that was a little like tongue-in-cheek nod because usually he does it the right way. In New York, we do it, Robert Alessi being duly sworn deposes and says that the following is true to the best of my, it's Robert Alessi, an attorney of law, practice to admitted to practice in the state of New York, hereby affirms the whatever. That's the way you do it. But he wrote here, my name is Robert Alessi, and I am pro hoc vice counsel for defendant Karen Reed. So not only is he pro hoc vice, he's also pro bono, because he is so outraged by the facts of this case. And then his affidavit goes on to support what he wrote in the motion, that Dr. Wolf is a neurological surgeon with no experience or licensing as a forensic pathologist to testify regarding the cause and manner of death. Therefore, you should not allow him to testify. Commonwealth doesn't meet their burden, not a forensic pathologist. And based on the foregoing, we think that you should not let him in. Says the defense respectfully requests that Dr. Wolf's opinions should be expressly limited to the scope of his expertise, which plainly does not include forensic pathology or the determination of manner and cause of death and mechanism of injury. Citing some cases, one of which is, look, Commonwealth v. Little, it wasn't me, from 2009. Indeed, the, quote, knowledge of a proposed expert must indicate, quote, more than subjective belief or unsupported speculation. Quoting Daubert, signed under the pains and penalty of perjury this 21 day of February. So yeah, this was drafted a long time ago. And here's the guidelines. Team Brittany is here, and she's posting them for you. So that motion will be argued today. It is my opinion that, again, this witness should not be permitted to testify, but we don't know what's going to happen because every day is a new day here. The rules change every day. Rules change every day. I hope that Judge Cannoni has taken an early lunch so that we can, not have to break at 1 o'clock for lunch. She's eating her lunch now, having a little snack, a little sustenance, a little hydration, and that we will be able to go straight through on this, because I think Alan Jackson said that his argument on this was going to be at least an hour, right? And he didn't want to have to fly back to LA and then take a red eye, Mr. Jackson, and come back on Friday. And he said, even though he needed more time because all of those videos were just turned over the night before, he was going to try and get it all in there. And he probably worked all night. He probably hasn't slept, although he still probably looks amazing anyway. Just my opinion. I'm sticking to it. I know you guys like his beard. Yeah, exactly. So Team Brittany, in case you are not chatting and you're just watching and you want to chat later, says, please be aware we are not entertaining any outside drama in the stream. Do not contact anyone being discussed. Doxing and harassment will not be tolerated. Thank you. And I'm going to add defamation to that list. Defamation. It will not be. Look, I'm a lawyer. We got to base things on fact here. So, it's perfectly fine if you want to say my opinion is in my opinion. Yeah, we have 11,489 amazing viewers here, and we need to do better on the likes. Only 3,000 likes. Could that be real? That's not even a third. I mean, that's not even a third. We can do better. Just a reminder, friendly reminder to please hit your like button, because we talk about all kinds of things here, and we try and make jokes, because if we don't laugh, we're gonna cry, and that's why you guys are the snark tank. Karen Reed's taillight became a new member. Welcome. Welcome. Yes. Thank you for pointing this out, Letter O's by Better O, because I also found this out yesterday. Yes. Hank lied again yesterday when he got up in open court and said, she's doing all of these interviews and they're sitting having coffee, and they shouldn't be allowed to do that anymore. And, they went on court TV. David Yannetti and Karen Reed went on court TV. They didn't go on a court TV ever. That was a Zoom hearing. That was a Zoom hearing that was aired on court TV. And so David Yannetti and Karen Reed were side by side on the screen. Court TV was broadcasting the Zoom hearing. And that is when David Yannetti said in the hearing that, did he say actually that Michael Marcy was the target of the FBI investigation, or that I don't remember exactly, but the point of this is that Hank Brennan said yesterday they went on court TV. And no, they didn't. They've never appeared on court TV. What do you think they're going to go on with Julie Grant? Really? No, didn't happen. Another lie. If you're keeping track. Thank you for pointing that out and for your super chat. Kim, I love Labradors. Motion for my head not to pop off today. But I'll take that under advisement. Mine might pop off as well, in which case we're going to have a real Monty Python-esque stream, but 'tis only a flesh wound. Kathleen says, how can the defense clarify ARCA's role for the jury without mentioning the federal investigation? That's a great question. I think that we can anticipate that that will become the subject of a motion in lemonade. Those motions are due next Monday. So we, of course, as always, will be here going over every single one of them. And so I think, Kathleen, that's going to be a motion, and we're going to hear about it, and we're going to see. Jen Shep became a member. Thank you for your super chat. And thank you, Jen, for becoming a member. Avec, does the Commonwealth have a theory as to how pig DNA ended up on John O'Keefe's arm wounds? No, I don't know what their theory is. My theory is that since the Canton PD seems to think it's cool to used solo cups to collect blood evidence and a used Stop and Shop bag to transport said evidence, and then leave that bag of blood evidence open next to the alleged murder weapon in the Sally Port. My guess is that after Michael Proctor picked up the clothes that were crumpled on the hospital floor, which, you know, people have told me who work in hospitals, look, we're trying to save the patient. That's what happens with the clothing sometimes. It also was soaking wet, remember, because he had been out there for who knows how many hours in the snow. And then it was thrown into the back. The clothes were thrown into the back of Proctor's car for several weeks before they were ever logged into evidence. But Proctor says, I think, he went back to Canton PD, even though Canton PD was conflicted out of the case that morning. And he laid the clothes out to dry on butcher paper. My theory, and it's just a theory, is that the butcher paper was probably also used. And perhaps it had been used to wrap someone's sausage or pork roast, hot dogs, or something else. And that's why the clothing has pig DNA on it. Just a thought, but you know, at this point, it could be anything. Thanks for the super chat. Laura Alessi is here. Alessi? Wait, are you related to the Alessi? Wait, are you Robert Alessi's stunning daughter that was sitting in the front row of court the other day? Well, I don't want to make you out yourself or anything, but she says, my mom and I are huge fans of yours. Thank you for all you do and the time you dedicate to sharing your 2 cents. Awesome. That's awesome. And if you are related to our favorite new attorney, Bobby Alessi, I wonder if it was your interest in the case that got you to say, hey, Dad, I think they may need your help, Dad. So that's amazing. Thank you so much for your super chat. And if you are, who I think you may be, it is a pleasure. Karen V. Goliath says, seems like Brennan is focused on only getting her on the charge the jury hung on. Ronnie deduced that 1, Karen was DUI. 2, unsure she actually hit him. But 3, Karen and John were the last together. So 4, leaving the scene. Thoughts? Yeah, I think that is, I think Brennan wants it all. I think he wants it all. I think he wants her to get the max. I think he wants to put her away for 20 years. He's like Big Case Mike. I hate that woman. Remember Big Case Mike? So I think they got a big problem proving that she was even DUI. I think there's video of her drinking a white liquid. We don't know what that is. I don't think there's any proof that it was vodka. I think that she could have gone home and drank a bottle of vodka as she was ramping up her voicemails, getting more and more angry at John as the night went on when he was not responding to her. That would be, in my opinion, a good explanation for why she was ramping up, because maybe she went home and started drinking. She was mad that he wanted to go out partying and he blew her off and he wasn't responding to her. Many of us have left messages like that we wish that we could take back. So I think that those DUI results and the extrapolation evidence is garbage, and I don't think it should have ever been allowed in. I don't think it should be allowed in again, based on the witness from the hospital's own testimony, in which he said the blood that we drew for this is not to be used in court. It is not to be used for DUI. That's a different test. And so therefore, I think that should be tossed. Again, nobody asked me. I'm sure they'll make another motion about it because now there's been testimony from the lab people in the hospital, right? Right. And then Phoebe says, exactly, Melanie, maybe that's why she hit his car backing up. Could be. Or it could be also it was slippery. She's not used to parking in the driveway. She's in a rush. She's frantic, right? Many things can be true. And Karen and John were the last together, so leaving the scene. Yeah. So leaving the scene is something that the jury actually acquitted on, which I found to be wild because it's like, wait, if you believe that she may have accidentally hit him, she also left the scene, right? And so I couldn't figure that out at all. So I thought maybe they just all agreed that, yeah, the people who thought she hit him thought she didn't know that she hit him. And so we can't convict her of leaving the scene because she didn't know that there was a scene to leave. I don't know. You could think about this all day. Karen v. Goliath and never figure it out. But thank you for your super chat. Nina says, I just remember that Proctor searched Karen's phone without a warrant. Help me. Was her phone data allowed to be used in the trial? I don't know if he searched it without a warrant. I can't remember if that's exactly true. I know that he was in John O'Keefe's phone on the day of, because he was able to access the ring footage from John's phone. Oh, is that really Bobby Alessi's daughter? Wait, hang on, I got to scroll back. People say also the pig DNA, pig ears are a dog treat. I'm so like, my mind is in so many places right now. And Remy, I guess it's been confirmed. Laura Alessi, we all love your father and his brilliant use of language. Thank him, Rosen. Thank you for attending. Oh, would you send me an email? Because I would love to talk to you. I want to know, are you in law school? Do you want to be a lawyer? There's so many things I want to know that can just be between you and me. So my email is in the show notes below. I would love, Laura, to hear from you, because I think your dad is amazing. And I think he gives New York lawyers such a good name. And I am one too. So I can say that. And I'm sure that I would love to. So many things I would love to pick your brain about. So that's amazing. Hey, here's Scott McGinnis. He's on his phone in front of the court. Difficult to tag, folks. So he's there. We're waiting. We're waiting for court to start, as always. But Bobby Alessi's gorgeous daughter is in the chat. So that's awesome. Her name's Laura. So her phone it was allowed to be used in the trial, yeah? Wait. What did happen while her phone was in police custody is that the location data was wiped, right? I don't know if Olivia and Niall is here, but yeah, they definitely did use some of her phone data, right? I mean, they had the voicemails, but those were on John's phone. They had text messages, but those were given to them by Higgins. He had no warrant for the phone or the car when he seized both of them, right? I know that. And so they've had it. Oh, thank you. Thank you, Olivia. So all the GPS data was wiped when they had it. All the GPS location data were wiped in April while her phone was in MSP custody. Olivia Niles, amazing. Follow her if you choose to be on Twitter. I'm always going to call it Twitter. I know it's called X now. I don't care. At Olivia Lambo on Twitter. She's got amazing explanations for so many of the tech things that I don't understand. She ties everything together very, very neatly, and she does a lot of research. And she's my go-to on this. And so, thank you, Phoebe, or Nina. I'm sorry, that was Nina for that super chat. Michael, can the defense take the Chloe molds to see if they match wounds on the dog's past victims? If they don't match other Chloe victims, Crosby debunked. Oh, that's interesting. Because yes, there were other victims that were close in time, right? And they have photos of those wounds. Michael, you might have just cracked the case. I have my doubts about whether that's even Chloe. How are they going to prove it? And how are they going to prove it? But that is a great idea because dogs' mouths shift. So in the past 3 years, dogs lose teeth, their teeth shift, they crack. So I'm not a forensic odontologist or a canine behaviorist or a canine odontologist. However, common sense would tell me that a dog's teeth would be different today than they were 3 years ago. So that's great. Excellent, Michael. I like your thoughts there. Wolf Netties, thank you, Melanie, for sharing your knowledge. How do we know the next set of prospective jurors will not be corrupted as Jim is organized. Well, they're going to have to really, really, really buckle down on voir dire. And they're really going to have to question these jurors very carefully. And I think they have an advantage now because one of the jurors, Ronnie, as we saw before with his pink shirt and pink bow tie, has spoken out. And so we know, or they know, what these jurors were talking about, what they were hanging their hats on, what some of the jurors were thinking. And so I think they have an advantage now for the next voir dire, but that's a great question. Lady Zelda is here. Thank you for your super chat. In my opinion, the mainstream media says the investigation is over in the Karen Reed case. It's always been over. They found her innocent. The Commonwealth forgot to mention that. Lady Zelda Kelly has a YouTube channel. She reads tarot cards, and she's done a lot of work on the Karen Reed, John O'Keefe, and other players. She's read their cards. And so if you like that kind of stuff, go check her out. Thanks, Zelda. Bite my bits. Digital video would never appear blurry or grainy. If there were data loss for any reason, it would appear pixelated because it's digital. Thank you, Bite my bits. Here they come. Hold on.
Knowledge, signed and sworn to under the pains and penalties.
Hold on. We're taking it back because it just started kind of in the middle. Let me know that you can hear it.
Dismissed for extraordinary governmental misconduct, are true and correct to the best of my knowledge, signed and sworn to under the pains and penalties of perjury this 21st day of February 2025. So the fact, what you state as fact, that Lieutenant Fanning had control over and access to this jury is simply not true, Mr. Jackson. The only people who have any access to those jurors are the court officers in the Department of Security of the trial court in this courtroom. So I am going to ask you what your good faith basis is for that. And I'd like.
Okay, we're already in for spanking. We're already in for spanking. We just missed her coming on the bench and them saying, God save the Commonwealth, but this is where court TV started, and this is where she's going with this. How dare you, Mr. Jackson? How dare you? Mr. Fanning had nothing to do with the jury. And really, and you're saying that under oath? No, you're not under oath, Judge. She's going to be like, what is your good faith basis? Prove it. And this is going to be another reason for her to spank Alan Jackson, to get rid of him if she wants to. You just watch and wait. I'm going to take that back again. We're going to be a little bit behind, but I want you to hear that because that's super, super, super important. You can see where she's going with this already. Ipsy Dixit, because she said so. Okay? Because again, here's the thing. Judicial immunity is a thing. She has judicial immunity for the things that she does with her judicial discretion as a judge. She also happens to be the administrative justice of Norfolk Superior Court. Her administrative duties may not be protected by judicial immunity. And so if she did appoint Fanning, who has a clear conflict of interest because he is proctor supervisor, to oversee the jury, that may eliminate her judicial immunity because it's an administrative duty. Are you following? Her ass is on the line. Here we go.
True and correct to the best. Dismissed for extraordinary governmental misconduct, are true and correct to the best of my knowledge.
She's reading this up.
Signed and sworn to under the pains and penalties of perjury this 21st day of February 2025. So the fact, what you state as fact, that Lieutenant Fanning had control over and access to this jury is simply not true, Mr. Jackson. The only people who have any access to those jurors are the court officers in the Department of Security of the trial court in this courtroom. So I am going to ask you what your good faith basis is for that. And I'd like you to start there.
If the court recalls the discussion at sidebar, we were told for the very first time, Your Honor, about this issue concerning the juror and concerning the individual who reported information suggesting that there was some sort of misconduct at sidebar by the court with no additional information.
No, I didn't tell you about the role. I didn't know who it was.
I'm getting to that.
Let him
That was
speak.
the next conversation that we had. When we were told on the day of closing argument to approach sidebar, the court indicated through multi-level hearsay, we'll all agree that it was some sort of multi-level hearsay suggestion that there was some sort of misconduct by the jurors or by a specific juror. We pressed the issue at sidebar and asked who the source was. At that time, for the first time, we were told the name Lieutenant Fanning. We obviously
You were not,
recognized
just
that.
so we're clear, you were not told that by me.
No, we were told that by, and I'm getting to that as well. We were
She's
told
trying to
that
insulate
by
herself.
Ms. McLaughlin. She's the one that indicated that it was reported. I'm sorry. That's not right. That's not right.
Okay, I'm pausing for a second to say there's Betterow in the front row. Okay. Laura McLaughlin told them it was Fanning. It was at sidebar. We know all those sidebars were sealed. I'm going to put myself over here so you can see Betterow. You can see Betterow better. She's like, it wasn't me, right? It wasn't me. She's trying to insulate herself. Here we go. Now he's going to correct it.
We pressed the issue on who was the source. I believe the court then inquired of one of the court officers.
Who are in charge of the jury?
Your Honor, I'm getting to that. If I understand that.
She's so
But if
defensive.
you'll allow me to make the argument and to indicate what as my declaration says, my good faith belief, based on reasonable belief, this is how we get there. We were then asked, or the court asked the court officer to join us at sidebar. He then indicated that it was Lieutenant Fanning. Ms. McLaughlin then went on to say, and by the way, he indicated that Lieutenant Fanning had reported this, supposedly gotten it from some unnamed or unidentified person. There was no evidence presented at the time, as the court knows. There was no declaration. There was no report. There was no supporting documentation whatsoever, no recording, even though this report to the court through the court officer from Lieutenant Fanning indicated that this juror may be, quote unquote, may be on a recording. And the court confronted that juror with that information. There was a brief colloquy with the juror where she said, not that I remember. No, that was the initial statement that she said in terms of any misconduct. No, I wasn't talking about the case. Over the defense's objection, this very potentially defense-friendly juror was then excused. During that discussion at sidebar, that's when Ms. McLaughlin explained for the very first time to the defense that who Lieutenant Fanning was in this circumstance. And she said that he was the, quote, commander of the extensive security operations that this case has required, period, end quote. That sentence says a lot. It said a lot to me.
It does not say he has access to or control over the jurors.
It says that
And
he
I'm
has.
just going to stop you. I'll let you finish in a minute.
Okay.
She
Mr.
won't.
Yannetti, as a Massachusetts practicing lawyer, knows that the court officers are in charge of the jurors. Go ahead, Mr. Jackson.
If there is a command.
They are supposed to be, Judge. Now she's pointing at Yannetti because now she wants to get everybody off the case. You see what she's doing here, right? Do you see what she's doing?
Of the extent.
Go ahead, Mr. Jackson.
If there is a commander of the extensive security operations over the entire case, there is, Your Honor, no greater security operation than securing the jurors. That is sacrosanct. It's paramount among the security operations that the court embraces. And we were told, I didn't make it up, Ms. McLaughlin told us. We were told he was the commander, not part of a security operation that was outside the court, not part of a security operation that helped parking cars or making sure that citizens got in and out of the courtroom appropriately. We were told he was the commander of the extensive security operations in this case. It is reasonable to conclude from that statement that Fanning was either directly in charge of the jurors, which the court is now telling me he wasn't. Again,
You were told that at sidebar
No.
that day by Ms. McLaughlin.
No, we were not. We were told.
I have the transcript.
Well, Your Honor, what we were told is what
fighting.
his title was. Commander of the extensive security operations of the court. So we reasonably concluded that he was either directly in charge of the jurors or in charge of the people who were in charge of security of the jurors.
Yep.
But we were never allowed the opportunity to find out exactly what his role was. because the court didn't take evidence, refused our request at the time in good faith. Both Mr. Unetti and I asked the court to take evidence from Lieutenant Fanning. The court
I think it was
declined.
Ms. Little.
I'm sorry?
I think it was Ms. Little who asked me to.
And what was the court's response? The court's response was to decline that invitation. We didn't take any evidence, which would have drawn down on the issue, so I wouldn't have to make reasonable conclusions. I would actually have the information. So of course, that's one of the issues that is attendant to our motion to dismiss, because it seems wildly inappropriate. Here's what we do know about Lieutenant Fanning. Once his name was uttered, here's what we did know. He's among the troopers that is one of Michael Proctor's supervisors. He interviewed several prosecution witnesses who testified at trial against Miss Reed, including Laura Sullivan, Marietta Sullivan, Bridget Meehan, Heather Maxson. He interviewed all of those individuals, or took part in those interviews. Lieutenant Fanning was at the defendant's home and seized her cell phone in January of 2024, just months before the trial began.
I didn't know that. Fanning seized her cell phone. Because remember, they were trying to indict Karen and Aiden Carney on charges. So these are all the things that Lieutenant Fanning did in this case. We initially thought he wasn't part of the real investigation of this case because he wasn't brought up and he wasn't on anybody's witness list. But I'm going to take this back a second so that you can hear all the ways that Fanning had his fingers in the Karen Reed case. Listen.
Heather Maxson, including Laura, interviewed several among the troopers. Name was uttered. Here's what we did know. He's among the troopers that is one of Michael Proctor's supervisors. He interviewed several prosecution witnesses who testified at trial against Miss Reed, including Laura Sullivan, Marietta Sullivan, Bridget Meehan, Heather Maxson. He interviewed all of those individuals, or took part in those interviews. Lieutenant Fanning was at the defendant's home and seized her cell phone in January of 2024, just months before the trial began. Lieutenant Fanning was included on the text chain where Trooper Proctor said he was going through my client's phone looking for nudes. Yeah. And then his name comes up at sidebar as the commander of the extensive security operations attendant to this case, and he's the source to whom something was reported about juror misconduct.
Right.
When you couple those two things together, that he's the commander of security and a person who supposedly, through hearsay, overheard a juror making statements about the case, and they have an entire myriad of individuals to whom they could report it. They report it to Fanning, and then Fanning reports it to the court officer who reports it to the court. It is not unreasonable to conclude that he was at least within the orbit of the security operations governing the jurors, which is exactly why we put it in our papers. And without additional information clarifying that, we have no way of knowing that he wasn't involved or didn't have any direct access to the jurors. If he didn't, he didn't. And that's a fact that everybody can agree on. But when we heard the information, the only reasonable conclusion we had, given the fact that he was the source of the information and he was defined as the commander of security over the entire case, not part of the case, the entire case, which includes the jury, that is a reasonable conclusion.
All right.
So you signed your affidavit 2 weeks ago when you already knew that he did not have any access to the jurors.
No, I didn't. I absolutely did
Signed
not.
and sworn under the pains and penalties of perjury this 21st day of February 2025.
Yeah, he didn't know that.
On February 21st, 2025, we were still at the first time that it was mentioned that he had absolutely no access to the jurors. He never had any contact with the jurors is when we received our responsive documents from the opposition from the Commonwealth. In that document, they mentioned he never had any direct access. He didn't have indirect access. They make these claims with no verification, by the way, no declaration, no supporting evidence, no declaration from the attorneys who filed the opposition. Right. That's the first time someone actually took the position that he had absolutely no access to any of the jurors, direct or indirect. So when we filed our papers, the information that I just told the court is the information we were working from.
Yeah. Put that in your pipe and smoke it.
I will let you move on. I can tell you, I'm really not satisfied with your answer, Mr. Jackson.
I don't give a duck.
Well, put it this way. Let's say it this way. So
Get Fanning in here and put him on the stand. How about
now
that?
that you know that he had absolutely no access.
There's no proof
to
of
the
that.
jury,
I'm sorry.
what's the nature of
I'm sorry. There's no proof of that. There's no sworn affidavit from anyone with actual knowledge, Your Honor, that he actually had no contact with the jury. There's no proof of that, Your Honor, other than you saying that he had no access to the jury. Are we just going to, like, the rules of evidence here are evaporating? They are exhausted. They don't exist anymore. I am not satisfied. Okay, let's get the jurors in here like you should have done originally to call them back about their verdicts. And then let's put Fanning up there and find out. I am not satisfied. Listen.
with your answer, Mr. Jackson? We'll let you move on. I can tell you, I'm really not satisfied.
I'm
with
really
your
not
answer, Mr.
satisfied with
Jackson.
your answer.
Well, put it this way. Let's say it this way. So now that you know that he had absolutely no access to the jury, what's the nature of the conflict? How is your client's right to a fair trial jeopardized?
Is
now
there
that
evidence
you know
that-
it's not true.
Is there evidence? My question to the court is there evidence that he had absolutely no access, either direct or indirect, with any of the jurors? I don't know that to be true. I mean, I take the court at its word, obviously, clearly. I take
So
the court
we
at its
will
word.
we
But
will move on from that, Mr. Jackson.
That
We'll
is
move on from
bullshit.
that. So
Well, the court's asking what is our evidence of, or what's our indication of the impropriety of him being the person that actually reported this misconduct and ultimately leading to the exclusion of a very, very
Ipsy Dixit.
witness. I'm sorry, defense-friendly juror, or presumably a defense-friendly juror, and knowing at the same time that he was intimately involved in the prosecution of my client. That's the reason, because he was at least within the orbit of commanding, according to Ms. McLaughlin, commanding the extensive security services over this case. And he ends up, just ironically, who knew? He ends up being the source of the information that got that juror removed.
That's right.
That's awfully coincidental, Your Honor. And yes, that's the foundation on which we built our argument that that shouldn't have happened. He certainly never, ever should have had any access, even in the orbit of the jurors, directly or indirectly. And the court never even inquired as to why he was the one receiving the report. Why Lieutenant Fanning, of all people, who then reports it to the court officer, who then reports it to the court, who then removes the juror.
Right.
That's an awfully straight line between Lieutenant Fanning, who has an interest in this case, and the removal of a juror. That's improper in our view. And that's why we put it in the papers, and that's why we argued it the way we did. Because we were working off of extremely reasonable beliefs based on information that was provided to us at sidebar in the court's presence.
Right, Judge, just because you say so. You don't know what Fanning was doing on his off time. You don't know if he was following that juror around. His information that he gave the court was that that juror was overheard in a bar talking about the case, and he knows that she's pro Karen Reed or something. And so they took her off the jury prior to closing arguments, I believe, based on Fanning's word. So, Your Honor, when you say to a worldwide audience, because we're 12,659 strong alone, with me, we're 12,660 people who have eyes on you right now. When you say he had no contact with the jury, you don't know what he was doing outside the courthouse. You don't know what he was doing at night. You don't know. And we have a right to know, because he should not have been. You remember they ran criminal checks on all of these jurors after they were seated? You think that he might have access to that? You think he might know her address? He might have known where she lived. He could have followed her. This is wild, because she says so. Not good enough. Not good enough. You're talking about putting away a woman away for 20 years. It's not good enough. Watch Mark Betterow, because his head may pop off in the front row.
all right, so that's your answer to my question.
That's my answer.
May I have a moment to confer with counsel?
Yeah, please, Ms. Dianetti, please give him some more things to say, because we are outraged. We're a little bit behind, so now we can catch up a little bit. We are outraged. This is outrageous. And the judge
The court
is clearly personally invested in this.
Thank you for that. The court invoked Mr. Unetti and said as local counsel, he knows this not to be true. Mr. Unetti just indicated to me that that's not quite the fact. And so Mr. Unetti, I think, should be able to at least address the court. As the court said yesterday, when we file something, we file it on behalf of everyone, including Mr.
That's right. Let him speak.
So if the court would allow Mr. Unetti to explain what his experience is, that may elucidate on this issue.
If we have time later, go on.
You
with
called
your
him out
argument.
on it. She
I'm happy to.
called him out on it. Let him address it now. Don't let it hang around out there. Mr. Yannetti, you know this is the way it goes, right? No, that's not the way it goes, Your Honor. And let me tell you why. Because she did say yesterday, made each of them stand up like they were children in a principal's office and say, one by one, you know that when you say something, it's on behalf of your whole team, right? Wow. Rules for me, but not for thee. Or the other way around. Rules for thee, but not for me. Call him out in open court and then don't let him address you. Great. I see how this whole day is going to go. Not going to go well.
Your Honor, and thank you for giving me the opportunity.
Yes, we did.
The cumulative discovery misconduct by the Commonwealth, as laid out in our moving papers, through their agents has been both egregious and pervasive. We've outlined most of these issues in our moving papers, all of these issues in our moving papers. But I want to concentrate my argument for the court this afternoon on the exculpatory Sally Port videos. I'm not waiving any of our arguments in the moving papers, but in the interest of time and focus, I think it bears upon the court at this point to consider most prominently the Sally Port issue, or the Sally Port video issue. The Commonwealth, to start off with, two facts that are true. The Commonwealth cannot deny the untimely disclosure of critical exculpatory evidence. They cannot and they will not deny that untimely disclosure. And they also cannot deny that critical evidence was intentionally, not by some sort of mishap, but intentionally was withheld from us. So what do they do in their opposition? Most of the time they spend saying that the prosecutors themselves did not know. They had no actual knowledge. Well, they concede the unavoidable in their moving papers, which is that the Massachusetts State Police and the Canton Police Department both knew about the evidence and both withheld it. Conveniently, they throw much of this on the back of Michael Proctor. It was sort of to be expected. He's already damaged goods, so why not? And they also bring in a newly revealed sergeant, a sergeant by the name of DG Petro, who's already retired, gone from the police force, and who interestingly retired just 2 days after the Commonwealth's October 2024 disclosure revealing previously withheld Sally Port video.
I'm just going to ask, is he available, Mr. Brennan?
Not today, but he could be available.
No, I'm just curious. So he's still around?
He is,
Okay.
yes, and he's cooperative.
All right. All right, Mr. Jackson, go ahead.
I have another question. If Canton PD was conflicted out of this case, why did anybody who worked for Canton PD, why did any detective at Canton PD have their fingers on this video? Dropping and dragging. Sounds like she's going to have an evidentiary hearing and call in DG Pietro. He's cooperative. Interesting, Mr. Brennan.
Our motion illustrates that, and by the way, I'll walk through the videos that we did get and when we received them. Our motion illustrates that dismissal in this case is required because of the cumulative impact of clear-cut discovery violations, clear-cut, inexcusable Brady violations. And from a legal standpoint, the conduct in this case is so egregious, it's so pervasive, and it's so deliberate that prejudice must be presumed. We don't have to prove prejudice, it should be presumed. To begin, I want to start the issue by talking about the condition of Miss Reed's passenger taillight. The condition of that SUV passenger taillight at the time it was brought into the Sally Port at Canton PD is of critical importance. And that may be one of the most important facts in this entire case. It's important because we know as a fact now that not a single piece of taillight was ever recovered at 34 Fairview until after that vehicle was in the possession of Michael Proctor and the Massachusetts State Police. That is the foundation on which this entire argument is built. And it is an undisputed fact, although it wasn't undisputed for years. Other material facts that are not in dispute. The Sallyport video has been in the possession and custody and control of the Commonwealth since January 29th, 2022. That is a fact. It's also a fact that none of it, not one bit of it, was ever disclosed to the defense until April 4th, 2024. On April 4th, and I want to walk through what videos we did get and when. On April 4th, we got two videos. One was the Sallyport interior front wall. That was the video that was missing 42 minutes, which was the 42 minutes where it would have shown the car being pulled into the Sallyport. And we also received a Canton Police Department driveway video with the SUV on the flatbed, which did not show the rear end of the car. On April 23rd, 2024, and by the way, April 4th, the court will recall, was just in the shadow of the beginning of the trial. On April 23rd, in the middle of the trial, we received another Sallyport interior back wall video. That was the video that is now sort of famously inverted. On October 10th, 2024, 2 days before Sergeant D.G. Petro retired, we received four videos. The Canton PD interior hallway, the Canton PD rear lot main side, the Canton PD rear lot cruiser side, and the Canton PD church side exterior Sallyport. And I highlight the word exterior because it becomes extremely important in just a moment. These are four videos, all of which show Brian Higgins in some way, shape, form, or fashion at the Canton Police Department on January 29th, 2022.
Oh, he's in four videos.
Then on January 28th, 2025, the Canton Police Department main driveway side exterior Sallyport was given to us. It's a grainy and very wobbly video that nobody can sort of make heads or tails out of. You can see the general outline of a vehicle, but the condition or the quality is so bad that you can't tell what the condition of the taillight is, which is what we're interested in. And I bring this to the court's attention, or I highlight this, because this is the second exterior Sallyport video that we ever received. One on October 10th, one on January 28th, 2025. Then on Friday, this past Friday, something pretty remarkable happened. We just received a report from Sergeant Buchnick dated February 28th, which is 5 days ago now. And he makes an important admission in that report for the very first time during all of this. He indicates that in May of 2024, during trial, he was, quote, provided with a thumb drive and the CD labeled with a Post-it note on my desk to review prior to testimony. He goes on to say, quote, at this time, I reviewed the video and I reviewed video made available to me, which included video footage of the Canton PD exterior Sallyport. Exterior Sallyport. That means that the Massachusetts State Police not only had in their possession exterior Sallyport video, but they knew about it and were reviewing it during trial. But we didn't get any of it until, as I just said, October 10th, we got one. January 28th of this year, we got the other. So that was.
Wow. Wow. Buchnick reviewed it. Yes, he did. During the trial in May, he got a thumb drive on his desk. He just filled out a report dated February 28th of 2025, even though he reviewed that thumb drive that was left on his desk during trial in May in 2024. Everybody wave goodbye to Sergeant Buchnick. All together now. Na, 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 na. Hey, goodbye. This is insane. Yeah, big Brady violation. We're at the Brady Bunch already. We're like a double Brady Bunch. We're at the Brady Bunch and their grandchildren by now.
Was withheld from us for the entirety of the first trial and all the way until at least October 10th, possibly as late as January 25th. I'm sorry, January 2025. And they've now admitted that.
Wow.
But who else knew about this withheld video in May of 2024 during trial? On cross-examination.
So can I just ask, was this of better quality than anything you had had, or was it the same wobbly?
Same. Okay. Same. Wobbly, grainy, can't make heads or tails out of hardly any of it. No. The question is, who else knew about this? Did anybody else know about this being withheld from us in May of 2024 during trial? On cross-examination on June 6th, Trooper Butnick admitted to reviewing video evidence with Mr. Lally in May of 2024 in prep for his testimony.
Lally knew.
Was that the video that they were reviewing together? Was it the exterior Sallyport video? We now know that Butnick watched some sort of exterior Sallyport video. He admits it in this report that we just got 5 days ago. And we also know that he and Mr. Lally were reviewing video together before his testimony in May of 2024, because he admitted to that on cross-examination during trial. But I didn't have information about what he was reviewing because we didn't have the videos. So either they reviewed together the inverted video that was then played and knowingly presented false evidence to a jury and to this court, or they reviewed exterior Sallyport video and intentionally withheld it from us. This is binary. It could only happen one of two ways. Either it was the inverted video that they prepped on and then presented inverted video to the jury, which is a problem, or they reviewed external or exterior video and did not provide it to us intentionally. Either way, the withholding that evidence admitted to now by Trooper Butnick was obviously egregious. It was obviously in error. It was obviously calculated.
Intentional.
Another important material fact not in dispute. On April 10th, 2024, the DA certified disclosure of, quote, all evidence.
Sorry, can I just get back to that?
All right. While she interrupts, can we please put the camera on Lally right now? Court TV cameraman. I know it's a man because I've been in court with him. Please. I see Will DeGlaire in the back row, and I also see Will DeGlaire and Nan Gallagher in the back row. I spy. She wants to get back to something now. Is this actually going to change her mind about the deliberate, intentional? No, we can't stop interrupting. I'm sorry, but this is what I do. I commentate. So if you'd like to go somewhere else, you can watch Law and Crime. Good luck over there. Thanks. Leah, get him on the stand. Let's have an evidentiary hearing today.
Of, quote, all evidence.
Sorry, can I just get back to that? What you were just discussing about May 2023.
Yes.
How is that exculpatory?
Because the videos themselves, as the court will see through the presentation of my oral argument, that the fact that those videos all just happen to either be grainy, wobbly, missing 42 minutes, or from the wrong angle and flipped backward, all tend to show that the Commonwealth doesn't want the condition of the taillight to be seen by anybody when it's pulled into the Sallyport. That is a reasonable inference. In other words, it's the cumulative effect of the bad videos that helps us. That's why it's exculpatory.
All right. And also, could you explain to me the prejudice?
Prejudice?
I will get to, yes, I will get to the prejudice as I move through
now or no?
She went through the first trial.
If you're going to do it later, that's fine.
I will do it later. I will do it later. I think the prejudice is cumulative. Obviously, we didn't have the information that we needed to be able to cross-examine the witnesses that we needed to be able to cross-examine at the time that it was provided. Okay. It just very obviously, there were certain videos that were clear from some cameras on other days and other times, but these cameras that were late discovery that was provided to us just so happened to all go out. They all find their way to be defective in one way or another at the exact moment that we would need them.
Yeah, there's other video that's been turned over that is perfectly clear. It is only the potentially exculpatory videos that are grainy and blurry and blur out the taillight. And Judge, I've got my argument already planned. Do not interrupt me and tell me to go to a different topic to try and throw off my flow, because you don't do that to your boy Brennan. So rude. He's got his argument laid out in a methodical way. He uses methodology. You are watching just another surgeon, a trial lawyer who is like a surgeon in his arguments. And we know you hate him, and we know you're trying to get rid of him. Let him argue his motion the way he wants to. Stop interrupting him.
On April 10th, 2024, the DA filed its certification of giving us all evidence that they had in their possession.
Compliance
and that they had done a
compliance.
reasonable inquiry. Both of these, that certification was just flat not true. How could that be true? And we're still getting video evidence that is in their possession, custody, and control in October, in January. How could that possibly be true? It isn't true. And it's illuminating when you look closely at the Commonwealth's opposition to our motion. First and notably, the Commonwealth makes these broad statements couched as fact. They're bold pronouncements, and there's myriad excuses in their opposition paperwork. And it's backed up by next to nothing. Not a single exhibit at the time they filed their opposition. There's some exhibits that have been lately provided, including some exhibits just a few minutes ago that they're now adding to their exhibit list and to their opposition. But at the point of fact, at the time they filed their opposition, there was no factual support for any of its positions.
So are you pointing me to something specific, or are you just saying in general and you'll wrap it up?
In general,
Let him argue.
The only thing that they had attendant to their opposition was this joint affidavit that doesn't address any of the defense allegations at all. Contrast that with the defense motion, which was supported by nearly 20 fact exhibits. There may be a reason why they didn't support their positions with exhibits at the time. It's because the facts don't support the Commonwealth's position. These are indefensible and indisputable facts that I'm explaining to the court about the turning over of these Sally Port videos. Specifically turning to the Canton PD surveillance video. The opposition says, or reads, the Commonwealth provided the defense with a...
I just always like to read along. Where does it
17. Thank you,
I
capital
don't
call
have
out
the page number.
Okay.
for counting the
It's point in
interruptions.
which the Commonwealth indicates that they provided 90 photographs,
Okay.
crime scene photographs in support of the vehicle in the Sally Port. That is a distraction. What they don't mention in their moving papers is that the date of those photos were all February 1st, 2022. There are no photographs from January 29th, 2022, when the vehicle was brought into the Sally Port. The only
Right.
thing we would have would be the videos,
Right.
the surveillance videos,
Mhm.
all of which are somehow, some way defective and which were held in their possession in some instances for nearly 3 years
Mhm.
before it was turned over to us. So it's the condition of the car at the time that it was brought into the Sally Port on January 29th at around 5:30 p.m. that matters. That's the only time that it matters. The other evidence referenced by the Commonwealth about a 5 a.m. ring video and Canton police cruiser at 8 a.m. and the independent observations of Dighton police officer Sergeant Barrows, they all corroborate the defendant's contention that the taillight was cracked and not shattered at the time it was brought in to the Sally Port. And we're still talking about the condition of the taillight, obviously, when it was brought into the Sally Port. The Commonwealth next mentions that Lieutenant O'Hara from the CERT team arrives at 32 Fairview Road at 4:56 p.m. They then go on to mention that he was preceded by another trooper at 4:54 p.m. and that the car got to the Sally Port at 5:30, suggesting, obviously, that the search began and taillight pieces were found before the car ever arrived. That would be interesting if it were true, but it's not true. It's a distortion of the truth. It doesn't matter when the CERT team actually arrived and drove up there and sat in their warm cars and waited for other team members.
Mhm.
The last team member to arrive didn't arrive until 5:41, 11 minutes, long after the car had already been secured in the Sally Port, long after Trooper Michael Proctor had access to that passenger taillight. The first taillight piece was not seen or found or recovered until 5:45 p.m. after the vehicle's arrival at Canton PD. That was seen. We can see who's got access to the vehicle and who makes access to the vehicle in that inverted video. Once we turn it back around, it's very obvious. It's Michael Proctor milling about at the passenger taillight. These are important details to get right. The timing matters. The opposition claims that the defense theory is quote unquote evolving. They write that the defense quote struggles to establish how the condition of the defendant's broken taillight in Canton, in the Canton PD Sally Port is in fact exculpatory. How is that exculpatory? the condition of the taillight, that it was cracked and not shattered as it moved into the sally port, how do we struggle to describe that as exculpatory? Of course it's exculpatory. Of course having those videos withheld from us is prejudicial. There is no struggle. It's on the video, it's on the ring video that establishes that the right rear Lexus hit the back of the Chevy Traverse, cracking its taillight. The Commonwealth, pretty desperate to ignore that inconvenient fact or that inconvenient piece of video evidence, literally previously said in open court that the Lexus only got close to the Traverse, only to be completely impeached when everybody in the courtroom at trial saw that 5,000-pound Traverse jostle, its rear wheel jostle, under the impact of the SUV right at the right rear or the passenger side taillight. Now the Commonwealth, with no factual support, no factual underpinnings whatsoever, says, okay, hang on a second. It did hit it, but it didn't crack the taillight.
And so they've got an expert.
Ours?
They've got an expert who's going to come in and testify that. The Commonwealth does. Take that back a sec.
So whose theory is evolving? Ours or the Commonwealth's? The defense has never wavered. We knew that Michael Proctor, from the very beginning of this case, had been lying about the time he first took possession of that SUV. He claimed that it was at 5:30. The court will recall this. We had litigation concerning this. He wrote it in at least 9 reports that we were able to count. 9 reports or affidavits. Those affidavits sworn under oath, and the Commonwealth repeated that time for nearly 2 years, even going so far as to argue to this court that the defense got it wrong, that we were wrong because we failed to calculate for daylight savings time.
Yep.
So the Commonwealth battled us, and this is something I think the court has to really weigh and balance the following conduct. The Commonwealth battled us for nearly 2 years on the singular issue of the time that the SUV got to the sally port. They finally took their medicine at some point and had to admit to the false time and chalked it up to a Scrivener's error in 9 separate documents, memorialized 9 separate times, some of them under oath. And all the while they were battling us on the time that it got there, no, the defense is all wet, they're wrong, they just didn't account for daylight savings time. Oh, no, this was just a little mistake, it's not a big deal, it was a Scrivener's error. And the entire time they're making both of these claims, they had video in their possession that established unequivocally that that car was in Michael Proctor's possession at 5:30 and pulled into the sally port at 5:30. They knew the time. They knew that he had retrieved it at 4:12 in the afternoon and not gotten it to the sally port until 5:30. So the Commonwealth was well aware in 2022, the Commonwealth and their agents were well aware in 2022 that the SUV got to the sally port, and that was the centerpiece of the defense case. They knew that the videos would directly impeach the lead investigator on this case, and they say that we struggle to explain the exculpatory nature of this evidence. It's not our struggle to explain it. It's their struggle to acknowledge it. Of course, that's exculpatory. It directly and unequivocally impeaches their lead investigator on one of the most important issues in the entire case. And that's only one aspect of the withheld videos that also is exculpatory. The other is the point at which it would show the condition of the taillight. In other words, when it's being pulled in to the sally port, would it show the condition of the taillight before Trooper Proctor had access to it in the sally port? That's what we've been seeking. The Commonwealth is well known from the beginning of this case that the defense has demanded all physical evidence be preserved. That is, this is not a game of Wordle. This is not something that's supposed to be parsed. All physical evidence be preserved. That's pretty straightforward. The Commonwealth shouldn't be in the business of withholding exculpatory evidence by playing some sort of a gotcha game with definitions of words. They knew what we meant.
It's semantics. They have a duty to preserve it.
We don't actually know what the Commonwealth has. So we have to be as broad as we possibly can when asking for evidence to be preserved. So all physical evidence clearly includes the entirety of all the Sallyport videos. The Commonwealth parses words by saying, well, we never asked for the Commonwealth to preserve the CPD footage from the Sallyport because the Canton PD is not the crime scene. You asked for crime scene footage, and Canton PD is not the crime scene.
Yep.
Well, first, I think that's a disingenuous argument that plays right into that sort of gotcha that we've discussed.
Semantics.
I think the Commonwealth is better than that. That's not what we should be doing
No,
in a
they're not.
trial for murder.
They're not.
And second, let's not forget that District Attorney Morrissey actually defended publicly Michael Proctor by explaining that when Michael Proctor said he responded to the crime scene, and of course we knew he didn't respond to 34 Fairview, DA Morrissey said, oh, he was talking about Canton PD, which is the crime scene. So they can't have it both ways.
Right. We talked about this when we went over the motion. Awesome.
They write on page 4 of their opposition, quote, the trial prosecutor was not aware of the existence of surveillance video in the Canton Police Department's Sallyport until receiving the federal grand jury transcript of Massachusetts
Wild.
State Trooper Michael Proctor.
Go get him.
End quote. So they've taken the position, look, we personally did not know anything about that Sallyport video existing until we received the federal grand jury paperwork showing that Michael Proctor testified to it. First, the Commonwealth has to know that that is not the state of the law in Massachusetts. Massachusetts State Police and Canton Police Department are both arms of the prosecution actively involved in the investigation of this case. Not one, but two separate agencies not only knew of the existence of the footage, but the lead investigator actually admitted to a federal grand jury that he pulled the footage at the start of the case. He pulled it all. And then he said he reviewed it all because that's what the case agent does.
Wow.
The Commonwealth cannot absolve themselves of the egregious and very obviously intentional discovery violations by Michael Proctor, by the Massachusetts State Police, by the Canton Police Department, by saying, I personally didn't know about it. The cases are legion on that issue. Commonwealth versus Sleeper, 2002 case found at 435 Mass 581. And this is Hornbook law. Quote, a prosecutor's duty to disclose exculpatory information or exculpatory evidence extends to evidence in the possession of the police who participated in that investigation. And then Massachusetts Rule of Criminal Procedure 14A1A, the prosecutor shall disclose information covered by mandatory discovery, provided it is in the possession, custody, or control of the prosecutor. Persons under the prosecutor's direction or control, or persons who have participated in investigating or evaluating the case and either regularly report to the prosecutor's office or have done so in this case. Michael Proctor worked out of the Norfolk DA's office, physical plant. There is no question that Michael Proctor and both agencies intentionally withheld that evidence.
That's right. Preach.
Let's talk about Michael Proctor's testimony before that grand jury. He was asked the following question. Are you aware whether there are any cameras in the garage or Sallyport where Karen Reed's SUV was parked?
Okay, listen up, because ordinarily grand jury testimony is secret. It's not allowed to be talked about. And she was like yelling at them yesterday for revealing grand jury testimony. Now he's going to talk about it. Is she going to spank him again or stop him? If you're ahead, don't tell me. Don't spoil. I'm going to take it back. So if you weren't listening and your mind was wandering, listen up.
Let's talk about Michael Proctor's testimony before that grand jury. He was asked the following question. Are you aware whether there are any cameras in the garage or Sallyport where Karen Reed's SUV was parked? Answer, yes. Question, have you reviewed the footage of that garage? Answer, I saw one very grainy video and then another of Sergeant Buchanan and I arriving in the main entrance around 5:30 following the vehicle. Question, when did you watch the video from the Sallyport? Answer, I haven't reviewed it, sir, in quite some time.
So do you have those page numbers for me?
I can get them for you, Your Honor.
Okay.
I didn't cite them in my notes.
Yeah, if Ms. Little can get them for you before you finish, that would be helpful for my review.
Yeah, put them
I
all to
haven't
work.
reviewed it, sir, in quite some time, so I can't recall what's on there. Question, why did you review video of the Sallyport? Answer, we review every video we pull. We pull a lot of video. It's on the case officer to watch it. By his own admission, Your Honor, Michael Proctor recognized himself in a video along with Sergeant Buchnick. That was likely the video that ended up being inverted by where Michael Proctor was by the passenger side taillight.
It's on the case officer to review it. He said that in front of the federal grand jury. They tried to demote him during the trial from case officer to customer service rep, but we know he was the case officer. And then they tried to make him the co-case officer, the co-lead investigator with Buchanan, tried to have Buchanan testify to all this stuff. Proctor said under oath in front of a federal grand jury, it was my job to review all this video. We pull a lot of video. How are they going to wiggle out of this? It was intentional. It was Brady. It showed the rear of her vehicle, which is the crux of their case. The condition of that taillight is imperative. It is exculpatory. And the audacity of this judge to say, well, how would it be exculpatory if it's blurry and grainy, is beyond comprehension of any practicing attorney, I would guess.
And that was before any taillight material was ever recovered at 34 Fairview. That is highly inculpatory of Michael Proctor. It is highly exculpatory of Karen Reed. Another point of fact, by his statement, Michael Proctor admitted that, quote, we pulled, end quote, the video. That video is on a 30-day overwrite.
Yeah. She's on it. Ms. Little's got the papers.
The Michael Proctor testimony in front of the federal grand jury is at page 79, lines 1 through 13.
Thank you. Thank you, Ms. Little.
Exhibit C is in Charlie.
Okay.
The video is on a 30-day overwrite, Your Honor. We all now know that. We didn't know that before just a few weeks ago. I don't expect that the Commonwealth knew that either. This is new to everybody.
They
right?
should have known.
But
look at Bobby Leslie. He just turned around.
You have
Wait,
to
check it
pull the
out. Check it
video
out. He's
in the
like,
first-
what? Of course they knew. They should have known. Watch. Look at his watch Mr. Leslie on the right side of your screen on the bottom.
day overwrite, Your Honor. We all now know that. We didn't know that before just a few weeks ago. I don't expect that the Commonwealth knew that either. This is new to everybody, right? But
He just got whiplash.
you have to have pulled the video within the first 30 days to even be able to review it. We've been getting these videos in dribs and drabs for not months, but for years. Actually, it's been months. Hasn't been years. He further admitted that it shows the SUV arriving in the Sally Port at 5:30, which means he wrote those reports and signed those affidavits, the 9 that I was talking about earlier, with full knowledge that there existed a video that he had and had reviewed that proved he was lying. It doesn't get any more exculpatory than that. And that was the video, that was the very video that was withheld from us, from the defense, for 2.5 years until the middle of trial. The Commonwealth says the, quote, trial prosecutor, end quote, was not aware. It's becoming a relatively common refrain in the opposition. That's neither a defense nor a justification for blatant and egregious discovery violations by the Commonwealth and its agents. The fact that the trial prosecutor, whoever that is, it's an interesting use of a name, of a pronoun. I don't know who the trial prosecutor is, but apparently the trial prosecutor, according to the Commonwealth, didn't know anything about this.
Mm-hmm.
But that's not a defense. Who is the trial prosecutor? Is it Adam Lally? Is it Laura McLaughlin? Is it both of them? And why are they only referring to one trial prosecutor when there were clearly 2 in the courtroom? They make the statement with no factual support for that anywhere. Again, the only affidavit that was supplied was a type of affidavit I've never seen before, where
All 3 signed it.
signed under oath by 3 different people.
Yeah.
So which sentence goes with which person under oath?
Doesn't matter.
The single declaration
No big
is
whoop.
odd, to say the least, but it certainly doesn't define who's responsible for what statement in that declaration. We certainly know that it was not Hank Brennan. He was not involved in the first trial, so it can't be him. The Commonwealth writes, quote, the prosecutor had not been alerted to its existence by investigating officers, end quote. but claim that on April 4th, they promptly presented the defendant with 9 surveillance videos in its possession. The Commonwealth received the federal material.
Were those all from the Canton Police Station?
I'm sorry.
Were those all from the Canton Police Station, those 9 videos?
My understanding is those were from the Canton surveillance. They're talking about the Canton. I didn't go back and audit which 9 they're talking about because I thought we only received 8, but I believe they're all from the Canton.
Ms. Little, were they all from the Canton Police Department?
Yes, Your Honor.
Okay.
Oh, so she'll let Ms. Little get up and answer a question at her pleasure, but she will not let Mr. Yannetti get up and explain himself when she calls him out to say, you know, Mr. Yannetti, that it's the court officers that are in charge of the jury, right? It was wild. Judge Gull, hold my White Claw. You got some competition.
The prosecutor had not been alerted to its existence by investigating officers, but on April 4th, they promptly presented it to the defense. The Commonwealth actually received the materials that highlighted the fact that these existed in February of 2024, probably around February 21st, 2024, because that's when both sides got all the federal materials. That is not prompt.
Right.
We presume that Mr. Lally has daily communications or had daily communications with Michael Proctor as the investigator, the lead investigator on the biggest case that the Commonwealth, this office of the Commonwealth has seen in a long time. And it took 2 months to produce an incomplete production of these videos. We didn't even get all of them at the time. The Commonwealth writes, quote, the quality of the video is poor in certain portions. However, this is the condition it was recorded in. Says who?
Right.
That's a fact question, one that needs to be answered. And it's an important question. Who says that the Commonwealth received these, or I'm sorry, who says that this is the condition that those videos were recorded in? We have no facts to support that whatsoever. And then the Commonwealth goes on and says, and that was the condition in which it was received by the prosecutor. That's also a fact question that needs to be answered.
Right.
And these questions could be answered with a proper evidentiary hearing. The Commonwealth's representations about Louis Jutras, the technology director for Canton, being subject to cross-examination about the Canton PD video surveillance system is also just not true.
Right.
They indicate, well, we had access to Louis Jutras and could have cross-examined him on all of these issues. Louis Jutras was called for a very specific reason, the town library video.
That's right.
We had no way of knowing at that time that he had any connection whatsoever with the Canton police video system. We were not told that until well after trial. That was never disclosed to us. And I think Mr. Brennan used this phrase not long ago, that would have been nice to know.
Yes, for the win. Using his words against him. I love that everything that I screamed about when we were reading the papers, the opposition papers, they had the opportunity to cross-examine. He didn't even name him. He didn't even say it was Louis Jutras, the guy from the town who was in charge of the video. And I said, didn't he only testify about the library footage and the library footage that was missing? And Lally handed him a disc and said, do you recognize this? And Louis Jutras, to his credit, said, no, I've never seen this before in my life. What is this? And he said, well, isn't it the video that you pulled from the library? And he said, no, I didn't give it to you on a disc. I gave it to you like on a thumb drive or something else. And then Brennan has the audacity in his papers to say, well, they had this witness on the stand. They could have cross-examined him about the Commonwealth, about the Canton PD video footage, but they didn't know. Yeah, would have been nice to know. I love it. I love this. I love this so much that I'm going to play it again. Would have been nice to know. They didn't know he had any connection. They thought he was like the library video guy.
Called for a very specific reason, the town library video. We had no way of knowing at that time that he had any connection whatsoever with the Canton police video system. We were not told that until well after trial. That was never disclosed to us. And I think Mr. Brennan used this phrase not long ago, that would have been nice to know of Mr. Louis Jutras. The first time Louis Jutras was ever disclosed to as the person who installed the cameras at Canton PD was in a report dated October 10th, 2024. According to Colleen Crawford, and the court's heard her name as well, one of the Commonwealth's experts, Jutras indicated that he replaced and disposed of the camera capturing the inverted video at some unidentified point between January 29, 2022, when the inverted video was actually taken, and July of 2024, because it was quote unquote defective. Interestingly, that's the only video that's clear. It's inverted, but at least it was clear. And that's the camera that, according to the Commonwealth, was replaced as defective.
I need to take that back. The only camera that was clear was the one with the inverted video. That's interesting. Turtle Boy's hearing does not start until 2. So Betterow is in the courtroom now. We're a little bit behind. So I'm sure he will go over to the other courtroom at 2. So hang on for a second.
'10th, 2024. According to Colleen Crawford, and the court's heard her name as well, one of the Commonwealth's experts, Jutras indicated that he replaced and disposed of the camera capturing the inverted video at some unidentified point between January 29, 2022.
Really?
When the inverted video was actually taken, in July of 2024, because it was quote unquote defective. Interestingly, that's the only video that's clear.
Yeah.
It's inverted, but at least it was clear. And that's the camera that, according to the Commonwealth, was replaced as defective.
Wow. Before July of 2020, between January 2022 and July of 2024, they couldn't pin it down. They couldn't pin it down. If you're going to pin it on the girl, you need to pin it down when you replace that camera that was allegedly defective. And get Jutras in here with an affidavit, because this is so far beyond the realm of like what Judge Summers in New Mexico would have done. She would have had this after the first paragraph of his argument. She would have been like, case dismissed. We're out of here. Ms. Reed, you can go home. Just like she did for Alec Baldwin. Wow. Ipsy Dixit, because they said so.
A week after filing its certificate of compliance, after the defense brought to the court's attention that 42 minutes was missing from the Sallyport video that we did receive, lo and behold, the Commonwealth produces a new video that also purports to show the passenger side taillight, except, as the court now knows, that's the one that was inverted. In the moving papers, in its opposition papers, the prosecution says, well, the prosecution had not previously received this video or knew of its existence. This is now the third or fourth time the Commonwealth sort of runs to this argument. I didn't know. We did not know about its existence. No matter how many times they write it, however, it does not change the Commonwealth's responsibilities. It doesn't change the prejudice that the defense suffered. We should have had these videos at the very beginning.
So, Mr. Jackson, I'm just going to ask you how much longer, this is the luncheon recess, but how much
Oh,
longer?
really? We need to go to lunch.
Probably
We need to go to lunch?
45 minutes, I would say.
Look at
All
Mr.
right, so
Reed.
we'll-
Mr. Reed. He's like, really? We need to go to lunch? We need to go to lunch so that you can convene or go eat your whatever the duck you're eating back there? What are we ordering today, folks? Subway, Jersey Mike's? What's on the menu? Are you kidding me? They didn't get there until after 12, and we're going to have to break. Okay, of course. My freeze game is on point.
Break.
45 minutes.
It's got 45
All right,
minutes
so
left.
we'll break.
We'll break until when, Your Honor? When are we going to break? Until. Well, we're a little bit behind, so it is currently 1:15. How far behind are we? About 15 minutes. So I guess they, at the stroke of 1 o'clock, somebody's blood sugar is going to, be off. And so somebody might die of lack of food or hydration. And they're on break until 1:45. We got a half an hour. We got a half an hour to digest this. It seems clear to me that we are not going to be able to cover the Turtle Boy hearing live. So I am going to change the time on that so that we can look at that later today. I hope, if there's video up of it, if somebody posts a video up of it, which they sometimes do on delay, I'm just going to have to change the time on that. So give me a second for all. I don't know if there's anybody waiting over there in the chat. I thought we were hopefully going to be able to finish with this one. But it seems that they're not going to come back until 1:45. So we're not going to be able to do that exactly at 2 o'clock. So let me edit that. I'm going to put that on for 5 o'clock pending video. because I don't know if the Zoom will be recorded or if anybody's going to be streaming it live. I hope they will. And if we're done before then, we will change the time again on that. But yeah, we need Judge Mary Marlowe Summer vibes. That is who I was talking about. Yeah, that is the judge who dismissed the Alec Baldwin trial. Just dismissed the charges, and then Carrie Marcy, that crazy special prosecutor, got up and put herself on the stand, and that was wild. This is insane. Let's go to the super chats because there's a lot of them. Thanks, Katie. Leone says, Melanie, I love listening to you and had to share. I'm a third generation CU Buff alum. That's amazing. I have Buffs and my kids are Buffs too. Some of them. In fact, my grandparents met at the sink over 60 years ago. Thanks for all you do. Funny story that my ex-husband, who grew up in Norfolk, Massachusetts, who tragically died during the time that I was covering this case a year ago in February. And that's when I came out and told you about that story. We met at the Dark Horse. So that is interesting. A lot of couples meet in Boulder. And so SCO Buffs. Karen V. Goliath, missing ring video from when the SUV was left unattended after Karen, Jen, etc. left. That's the most important time. Yes. Where was Higgins and McCabe then? Good point. Thanks for your super chat. Mother of Spaniels, thanks for your super chat. Jen's 227 search. Would it be available on the cell extraction, whether the search was made at Wi-Fi or cellular data? 34 Fairview. That is not something I can talk to you about because I am not a cellular forensic expert. There are people on Twitter who might know. Thank you for your super chat. I can't answer that truthfully. So, Letteros by Vetero, thank you for gifting a membership. So very kind and generous. Nicole Lee says, what was the hearing? What was the interview Brennan accused Karen and Yannetti of doing? Was he referring to her Zoom hearing? Yes, he was. It's out there. It was Court TV broadcasted. It was on Zoom. And they broadcast it. And then Brennan said in open court, they went on Court TV and said that Marcy was the target. No, that was during a court hearing. Get your facts right or go home. Kyle, hypothetical, AJ gets kicked out and Bev levels a gag order on the defense. Wouldn't that free AJ from that gag order? Under the ethical rules, I don't exactly know the answer to that question, and hypotheticals are something that I don't like to opine on, and the answer is I'm not quite sure what the rules of Massachusetts are because they're wacky, and it's something for someone to look into, Kyle. Piney Woods, thank you for the hopefully he's not going to get kicked off the case, but the way she was going with her questionings this morning make me think that she really does want to get him kicked off, and she's trying to make an appellate record for kicking him off. And she come hell or high water, that's what she wants to do because she keeps putting all of this stuff on the record, and it feels to me like that's the way that's the vibes I'm getting those vibes. The vibes are off, but I feel like she's making a record and she's speaking publicly about it, and it's on worldwide television. Questions. Pineywood says, when I was briefly a judge, I had to go to judge school. I think Bev was absent for Karen Reed. The judges also have a handbook they're supposed to read and abide by. And maybe that handbook needs to be changed. I don't know. Did she read it? I don't know. Thank you, Pineywood's. If they slam a gag order down, we will just get louder, says Loudmouse. Yep. Just to clarify, the gag order would only apply to the attorneys in this case, not to Karen and not to us. A Gatling gun dystopian. David Reese is here. Doesn't the Commonwealth already have a neuropathologist? Yeah, isn't that Dr. Renee Stonebridge who did the autopsy, the postmortem examination of the brain? Yes, but I guess she's not willing to say because she testified that she doesn't know how the injuries occurred. They could have occurred from a bat. They could have occurred from a fight. She doesn't know. She's not going to say that they absolutely occurred from his head slamming on frozen rock hard ground because, she has integrity. And she cares about her license to practice medicine. That's just a guess. But yeah, they have one. But now they want a neurosurgeon. Nerdy Dog Mom says, in civil, how do experts connect accident to injury? Do you mean like in general in civil cases? You have doctors come in and testify. That's how the injuries occurred. That is, they are usually the treating doctors of the plaintiff. They will testify that's how the injuries occurred. Sometimes you have eyewitnesses who say, was a car accident. That's how it happened. It was a dog attack. That's how it happened. But in this particular case, they're going to have a problem because they do not have a crash report. There is no motor vehicle accident report indicating a pedestrian fatality. And in New York, that is the law. It must be filed. To my knowledge, it's never been filed in this case. We've never seen it. And it's going to be a problem, in my opinion. Thank you, Super Chat. Bacony Butchie Paper. I put this up before, but I love your username, so I'm putting it up again. Thank you for that. And Mindless Grift Cult. Hank Brennan to Rex. I assume full responsibility and all obligations for prosecuting this case and will do so meticulously, ethically, and zealously without compromise. Yeah. And what Christina Rex is who you're talking about, the reporter, right? And when I first thought that, I'm thinking, I immediately, my mind goes to Long Island serial killer Rex Heuermann. So I was like, Rex Heuermann? What? But yeah, you're right. That's what he said. But, you know, did he mean it? I don't know. You decide. The world is watching, Amelia says. Free Karen Reed. Much love from Zurich. Zurich is here. Zurich in the house. Thanks, Amelia. Chibi says, can Alessi's daughter tell us what kind of emoji we should make about him? Superman is trademarked. Yeah, right. Great. Thank you. Thanks, Chibi. Heather Target says, watching from Maine, came into trial 1 completely cold and objective, now outraged. John O'Keefe was not hit by a car, sending good vibes to Karen and the dream team. Thank you so much. Madam Roz is here telling us that the troopers escorted the jurors from court to the hotel. Well, they were not. They weren't sequestered. So do you mean the hotel, like, were they parking in a hotel parking lot? I'm not sure what you mean, but, you know, the whole beginning of that, where she was so defensive about Fanning having no contact with the jury. And then Alan Jackson brought out the fact that Laura McLaughlin was the one who told them at sidebar Fanning was the source of the information that this juror, who was clearly pro Karen Reed, was allegedly talking in a bar about the case. There was no hearing held. There should have been a hearing. There wasn't. And that was all new information for us. Crypto or Cyrodo 30 says, I love when this defense team gives it right back to Auntie Bev. She's so darn rude. Thank you for your 5. Bev's panic attack. Bev came out defensive and swinging this morning. I see you change your username. I'll allow it. Nurse Kim talked about the toxicology test was illegal. It's not protocol for what she was hospitalized. There was no lawful reason to do that blood draw. Well, I can't opine as to what Nurse Kim actually did say, but I can say that whether it was proper and admissible and whether it was legal or illegal are two different things. I don't want to misquote her. I don't want to misquote anyone, but thanks, Susie, for your super chat. What the witness did say is that we don't do this for legal reasons. That was, her blood draw was pursuant to this section. She was sectioned, meaning put on an involuntary psych hold because she was deemed to either be a danger to herself. I think that's why. There's some fuzziness around why she was brought in, but she was quickly released the same day. So she wasn't put on an involuntary 72-hour hold. I think they call it a Section 12 in Massachusetts, if my memory is not totally exhausted by everything that is this case. But that's why they did it was like a CBC that they did, right? Chloe Albert's revenge. Norfolk County courts remind me of those small towns where the sheriff, mayor, family doctor, and mailman are all the same person. Yeah, it's like everyone's related here. Forget 6 degrees of separation. This is like 2. Keita, the fact that Fanning or anyone involved in this case is part of a security detail for the jury says it all. And biased Bev wanting to move on without giving the defense proof says even more. Yep, you're all here. You're witnessing it. You're watching it with me. We're screaming together. Pauline says, you know, this is duck and infuriating when even Melanie is using curse words openly. Love you, Melanie. Oh, sorry, I forgot. I did say something. Sorry to those of you at work who are listening to this without headphones. Thank you so much, Pauline, for your super chat. Random thoughts. I wonder if I can call a space rescue for my brain that just launched into orbit, lost in space into a black hole of insanity. So true. Thank you. Hard plastic and static mannequin. Thanks for the super chat. Look the other way. In my professional opinion, Morrissey had all the jurors followed during the trial. My personal opinion. Thank you, Chloe's Incisors, for your thoughts and for tuning in from Canada. And that's interesting. Maybe because we know that some of Marcy's emails from his private email were released to all sides, and in Aiden Carney's case as well. Maybe we'll know more about that later. Kyle, thanks for the 5. We are not supposed to hate people as Christians, but evil. But what if that person is evil incarnate? I don't know about your beliefs, but some people are evil, and it's hard to wrap our head around that, isn't it? Because we don't want people to be evil. Derp derp, Spicy Jackson. AJ sat with his hands folded at the defense table for weeks. He's now ready to go to the mat with Bev. Thank you for your super chat. Michelle, she has no choice but dismiss this case on this argument alone. But you know, Michelle, she's the gatekeeper. She has so much judicial discretion. She can do whatever she wants, according to her. I agree. Should it be? Yes. Will it be? No, I don't think so. I mean, that would be amazing if it was. Should be. In the interest of truth and justice and fairness and Brady. Canton PD's inverted camera. Where was Officer D. Gianpietro and the videos that are now dropping when the expert from Arizona visited Canton PD? Yeah, I don't know. But isn't it interesting, too, that Alan Jackson brought out that he just happened to retire 2 days after the Commonwealth started turning over some more videos in October 2024, long after the first trial was over. He retired. Coincidence? I don't know. A lot of people retire so they can keep their pension because, you know, if you're terminated, they take away your pension. So it is a thing that many of the involved or recipient witnesses in this case have done. They've retired from the police force, from their law enforcement agencies in which they were previously employed. Did Brian Albert retire? You guys can help me on that. Did Kevin Albert retire? Thanks, Team Brittany. I saw that too, and I don't know how to confirm that. If you see a confirmation of that, please forward it my way. If that were true, I think Betterow would not be in that courtroom. So let's not, no rumors and speculations in the chat, please. Karen Reed Taillight says she will rule if it was wobbly and blurry, it was not seen as valuable or exculpatory by the Commonwealth, and that is why it was not shared. Yes, I think that's where she was going with that. Sweet Caroline is here. My voice is like a frog. Commonwealth and Massachusetts State Police are fighting over their life jackets. Sinking ship, in my opinion. Yeah, they're rearranging deck chairs on the Titanic, but I don't know. Will it ever sink? I think they're unsinkable, the Commonwealth, but that's a great analogy. Thanks for the 20. Craig says, wobbly video is not possible with digital video, only with analog video. Exact Uvision is digital, clearly manipulated after the fact. Thank you. Brian Albert retired. Kevin Albert has not retired. What about Higgins? I don't know. The chat's reporting that they have another witness intimidation filed on Aiden today. I don't know if that's true or not. So can we refrain from continuing to write that in the chat until I can confirm? Mass Dad says Higgins is on desk duty. Okay, that's interesting. We know that Proctor's on ice. Higgins on the rubber gun squad. Emily tuning in from, is that Sweden? I don't know if you were referring to my comment. I meant Bev, stop interrupting. Oh no, honey, I don't think it was you. I think some people complain that I interrupt all the time, but you know, that's what I do here. I love you. Thank you so much for your super chat. Zoe B, plugging an unknown thumb drive into government computer is a security violation. Dropping a random thumb drive with malware for a government worker to find is the oldest trick in the book. Don't do it. Interesting, because now we're finding out that Proctor is saying that somebody dropped a thumb drive on his desk all the way back in like May, and he watched the video and they never turned it over. Thanks, Zoe. Thanks, Michelle, for your super sticker. Can the defense appeal if she denies this? Not right now. I don't think there's a right to appeal right now. Unless there's special circumstances, the answer is, would an appellate court agree to hear it now? There's questions about that. And so the answer is usually not until after the trial's done. Bev's albuterol. Who's the cop looking dude sitting next to Peggy O'Keefe? That is Carl Dougal. He was friends with John O'Keefe. He is Boston PD. He was kicked out of the first trial for allegedly shoving Karen Reed in the hallway. So there's that. Thanks, Rachel, for your super chat. Super sticker. Just Irish says, I just love this for Bev. Thanks, defense team. We are Karen Reed. Wordle has entered the chat. Thanks, Abacus. Janelle, who writes police reports years after the fact? They do. They do. Canton PD, MSP. They do. Without noting that the report is being written X amount of time after the event, they do. They date it, and then they say, on such and such a date, I interviewed so-and-so. And it could be months later. Bev is a Commonwealth agent. Guilty. Thank you. Thank you, Lucci, for your super chat. Michelle, should the defense move off Karen being set up to showing the facts and use prosecutors' own evidence and witnesses against him? They may want to back away from the actually being framed theory to something happened. We don't know what it is, but he was not hit by a car. I've been saying that for a long time. So yeah, that could be a good strategy. Do I know what they're going to do? Would I tell them what to do? Both answers are no. I don't claim to have better strategy than they do, but based on all of based on all of the interviews with the jurors and, you guys are the mirror jury. So many of you and so many other people out there shouting about this. People think, maybe just something happened. Don't point to specific people who did it because we don't really know who did it. It doesn't matter who did it, but it wasn't Karen Reed. K-Mick, they could have had Higgins' phone because it wouldn't be a fishing expedition, right? Because now there's 3 videos of him talking on the phone. Well, 3 videos of him outside because all of a sudden they found the outside camera footage. One of them has him on his phone. Christina says, I've been literally shaking and not on trial. Take a deep breath. Kevin, thank you for all you do. I don't have a lot of money, but I want to support your channel. Oh, thank you so much. Thank you, Kevin. That is so sweet of you. It's a great way that you guys can support the channel without it costs you nothing is to shop through my Amazon link. So many of you ask me what kind of makeup I wear on camera, and it's all in there, but you don't have to buy anything that I have on my list. So you can do your regular shopping through my Amazon link, and it gives me credit for whatever you buy. So for just your regular Amazon shopping, I don't know about you, but I've got Amazon coming to my house like at least twice a day, sometimes more. So the link for my Amazon influencer link is like down below in the show notes at all times. And that is a great way for anyone who would like to support the channel without spending any extra money. Thank you so much, Kevin. I really appreciate that. Edward, the fact they did try to hide the ball on such poor video is exculpatory. Why? Why do all this for bad video that wouldn't help the defense? Yeah. Exactly. Daisy Duck, Dennis the Menace says, Auntie Bev's meme is Daisy Duck. Thanks for your super chat. Waiting for B to interrupt for her lunch break. Well, I'm behind in the super chats, as you can see, but random thoughts. You were right. There seems to be a court docket that's got Aiden Carney charged with some more charges as of no, hold on. No, those charges, he was arraigned on those charges on March 18th. Maybe that he's going to be arraigned on March. This is a date in the future. It's like back to the future. Like we're going into the future. There was a criminal complaint issued this morning in Stoughton District Court. Let me pull this up because I know you guys like receipts and so do I. Hang tight for a second. Let me see if I can get the actual mass courts docket on this. Don't worry, because they're still at lunch. We're not missing anything yet. Lunch break is still happening, but let me see if I can pull up those new charges for you. Hold, please. Talk amongst yourselves for a second. All right. Well, a bunch of people have sent this to me, but it's a screenshot of something. And so I don't really want to pull it up because when I look up the case number that is cited in the screenshot that some people have sent me, it could be a deep fake. It purports to say that some new charges were filed against Aiden Carney today, witness felony intimidation, but without an actual case number that actually comes up in mass courts, I'm not going to go off onto a tangent about it because I just can't verify that it's true. I can't find it in the mass courts docket. It says Stoughton District Court. I don't see it. And all of the screenshots that I'm being sent don't have a case number. So hope nobody's trying to deep fake you. But I wouldn't put anything past anybody. Yeah, it might be BS. So let's keep it out of here. Aiden and a ham sandwich were charged. Yeah. Yeah. I mean, this alleged, it could be a deep fake here, says that there's an arraignment scheduled for March 18th. I pretty much think that if this were true, Betterow would not have been in the courtroom right now. He would have been outside dealing with that. It's probably another altered document by somebody. The trolls are busy. Mass courts website. Okay, but until I can prove it, I'm not talking about it. I'm not putting it up. He posted it. Aiden posted it. So hang on. If he posted it, then I can say that it's true. Oh, okay. My paralegal's on it. So hang on. But how come when I look up that case number in Stoughton District? All right, but my paralegal knows what they are doing. Not obviously going to dox my paralegal because people will go after this person, but hang on. This is an official document from mass courts, so hang tight. They're still at lunch, so don't worry, we're not missing anything. I thought they were only going to break until 1:45. Oh, it's 1:40. Okay, so we didn't miss anything yet. Do you think she's going to take longer than 1:45? I mean, wouldn't surprise me. Such a tight schedule. Come on. Come on, you little thing. Come back. Come back to mama. Well, it's not cooperating with me right now. Talk amongst yourselves. All right. Well, what the hell just happened to my little well, no, that's Karen Reed. That's not the thing that I'm looking for. Hold on. That has nothing to do with what we're looking for here. Well, whatever. What I'm going to tell you is that my paralegal has sent me proof that it is actually real and that apparently Aiden Carney has caught some more charges today. I mean, it will be arraigned for them on March 18th. Apparently, it's a felony witness, juror, police court official intimidation charge under that witness intimidation statute 268. And it says that the criminal complaint was issued from an electronic application today in Stoughton District Court. Today's March 5th, right? Yep. So it's March 5th, and it says that it's set for arraignment on March 18th. I don't know any more details than that. So for those of you who were hot on the, yeah, wow, just wow. Yeah, they're not going to stop. They're not going to stop. Who is intimidated this time? I don't know. College friend of Karen Reed, the troopers interviewed, but she took complaints on I don't know. We're not going to speculate. No speculation. But this is, this is par for the course. This is what goes on in Norfolk County. You see, they really, really, really want to shut him up, don't they? They really do. They really want to shut him up. And they'll go to, they set him up the first time. He was at CF McCarthy's last night. That's right. There were some pictures that were posted of Glare and Nan and Meredith and Turtle Boy at CF McCarthy's last night. My paralegal's on it. So if I get any more information, we'll talk about it. But yeah, let's ignore the stories until we know the truth. But yeah, they're doing it again. Oops, they did it again. Back to the supers. 10 misstatements of facts says we're all mad as hell and we're not going to take it anymore. It's true. We're not. Sage, I think I will have a brain aneurysm if I have to listen to Brennan argue this. Hopefully that happens before I scream at the TV. He's going to deflect. Yes, he is. Oh, yes, he is. Thank you, Sage, for your super chat. Casey Lee, I'm a few minutes behind, but holy shite, Bev is going to make me go into labor. I love you. Oh my gosh, are you almost due? Congratulations. Congratulations. That's exciting. Bev's BS. She doesn't want Mr. Yannetti to get up because she's afraid of what he's going to say. She knows AJ is right. Love you. Yeah. Is she going to remember to let him get up and talk? Probably not. She probably won't. Cult jamming. Attention, all Massachusetts residents. Please vote like your life depends on it, because it does. Vote all small town elections. No change without change. Thank you for that reminder. But also, we elect our judges here in New York. You don't do that in Massachusetts. They're appointed. So, but you can vote for your district attorney. Bernie says even Houdini can't help the Commonwealth escape this circus. Thank you. I literally feel like throwing up, says Cat Q. Thank you for tuning in from Canada. Tracy Russo, thanks for the 20. If these cameras are similar to tractor trailer dashboard systems themselves, they maintain a hard copy on the device and upload periodically to the cloud. Well, that's interesting. I don't know if they are or not, but thank you for that laying the knowledge on us. Just wait for the break between Jackson and Brennan. She has to make some calls, says Auntie Bev is factually biased. Stephanie. Thanks, Steph. Bev has a ripcord if she has the sense to pull it. Thanks, Kyle. I agree. She has her way out of this. 1 p.m. lunch is contractual for court officers. Oh, thank you. Thank you, Cam, that one, for telling me that. I had no idea. Every court runs a little bit differently. A lot of judges work through lunch and say, you're at an important point right now, and so I want to let you finish, and then we'll take lunch. But if that's interesting, if it's a 1 p.m. contractual lunch for the court officers in Massachusetts, then she got a break. Thanks, bye, for your super chat. Chloe Albert's Revenge says, excuse me, Mr. Jackson, we need a minute to get our story straight. This is too much. Oh, I mean, it's time for lunch. Yep. Team Wicked Smart versus Pure Wicked. Oh, that might be my favorite username of the day. Team Wicked Smart versus Pure Wicked. That's a work of art. If the federal investigation is closed, can the defense call more witnesses from the feds? I don't know. I don't know if they're going to be released any more information. That information will not become public. The answer is, I don't think so, because I don't think they're going to know who they were. I mean, they can call the witnesses that they already know about, that have testified in front of the grand jury, that were already witnesses in this case. Can they call other experts? Maybe, because there was an expert that the feds hired who did say that 227 did happen at 227. So that would be an interesting idea. Great idea. Great idea. Deja vu, I'm so torn. I was looking forward to Bettero, but I know you will air it later. I'm staying. Oh, thank you, sweetie. Appreciate you. I see you, says if JOK's head hit the ground, there could be melt and wound would be dried blood and dirty. I don't know, maybe, but no swabs were taken from any of his wounds, so we don't know. But there should have been a lot more blood on the ground, as a lot of people seem to think, and there wasn't. Especially if the ground was frozen hard as a rock, don't you think? If the ground was frozen hard as a rock, wouldn't that mean that it would not absorb lots of blood? I don't know. I'm not a pedologist, but I don't know. It's just my educated guess. I would love to see other judges speak out. Thanks, Buzzing for Truth. Piney Woods, I give you kudos on covering this travesty and not just losing your mind. Oh, it's already gone. My mind is lost. It is forever out there in the woods with Hansel and Gretel. It is gone. This judge cannot continue on this case, in my opinion. You think she's ever going to recuse herself? You think she's going to dismiss the charges? Do you think Marcy's going to come in and dismiss the charges? I don't think so. They're paying Hank Brennan a lot more money than we originally thought. We thought he was going to get paid the $75,000. Now it's up to like $250,000. Compare that with poor Adam Lally, who sits there like a character from Despicable Me with his hunchback posture, looking all dejected. I was calling him the water boy for a while, and then I said he's in some hot water now, so we should call him Hot Water Boy. And then you guys are like, wait, he's not hot. We can't call him that. But he made $140 last year. And when you break that down to all the hours that he spent prepping and trying that case, it's probably like $1 an hour. I'm sure he's not happy. Isn't it ironic that Free Karen Reed, aka FKR, is also an anagram for Ducker, to address Bev's judicial misconduct? Yes, Christina. The medical examiner gave everyone the answer. She stated, follow the science. That would be ARCA. Thank you, Adam Handful, for your 10. Thank you, Sarah, for your super sticker. Mike from Providence says, this woman with her breaks and days off and leaving early, Christ, it's a murder case with a woman's life on the line. Yes, 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 it is. But if the court officers union, if they have a union, I don't know, says you got to break at 1, you got to break at 1. I guess that's what we're learning, Mike from Providence. I don't know. The whole world calls me Hank is coming in with a big, giant $50 super chat. Thank you so much. Says, since they can't reach out and touch the judge, I will throw my money your way. I appreciate that. Thank you. It's all I can do. Oh, I appreciate you. I am infuriated. My stomach is ablaze. Poor Karen. I think so many people feel so helpless that they don't know what to do. You know what you can do? You can donate to her defense fund. They're going to need it for all of these experts. That's a great way to help. It's expensive, and all of her attorneys are working for free. They've said that publicly. It's a scary thing, Hank, when you find out that this could be any one of us. The railroading to us is obvious. I'm just dismayed that the jury didn't see it. Hannah Laura says, how's the whole team so calm? I would be livid. That's why I almost am more grateful to be home with you and talking to you about it, because I can scream. If I was sitting in that courtroom and the judge started, you know my facial expressions. I mean, I can't control my facial expressions. I have a lot of facial expressions. I'm very expressive. Don't know that I could control them sitting in the courtroom. Of course, when I do go to court, I will control them, but it is not easy. Not easy. Gatekeeper to Hades. Dennis the Menace. Hey, Bias Bev. But can we all imagine Lally Lag chain smoking? He does smoke. We know that. Escape to Eleuthera is here. Highly unlikely. What if Bev feels the proper move is to dismiss the case for misconduct and is just saving face for herself and the Commonwealth by raking the defense over the coals prior? I mean, that would be wonderful. Be a great thing. The saddest part is that if, in fact, the federal investigation is closed and nobody is going to be indicted for the actual murder of John O'Keefe, that justice for John O'Keefe will never, ever happen. And that's sad. All right, looks like they're coming. Oh, I saw a blue screen there. Thank you, Escape to Eleuthera. DMB Mars, is that Dave Matthews Band? What's the job description for commander of the extensive security operations? Yeah, we want to know. That's what the judge said. That's what Fanning was. We learned that this case has required. P.S. Love you, Mel. You're my Pisces spirit animal. I'm Aquarius. Sorry. My birthday is tomorrow. Happy birthday. I'm Aquarius. Happy birthday to you, DMB Mars. That's awesome. Yeah, he's the supreme commander of the security, because they're, they had to have a buffer zone, and they had to have they had all those people outside, and he had to be in charge of security. And who was he securing? They sure don't give a duck about Karen Reed's safety, that's for sure. If Carl Dougal can allegedly push her in the hallway and then he gets banned from the courtroom. Can the defense subpoena jurors to testify whether Fanning was involved with the jury? I guess if there's an evidentiary hearing. I'm not sure, though, what the rules are, if they would be allowed to. Because I don't think you can force a juror to testify They would need court approval to do that. Do you think the judge is going to approve that? I don't know. Heather Target, Judge Bev has a legit out. You would think she would want to take it, dismiss and be done, but she's too legit to quit. Too legit quit. K-Wags, I wish the defense would go outside the motion and lay it all on the line. Skanky Brennan sandbags them. Goose and gander, goose and gander. Yep. Kyle, I just saw Zoe B's comment. She's absolutely right. We all had multiple cyber security courses on that very subject called social engineering. My external HDD was sterile, maintained a log too. Yeah, and didn't he said, because this is what Alan Jackson said, that Proctor testified in front of the grand jury that somebody left a flash drive on his desk and he just watched the video. I'd have to go back on my notes. But yeah, that's like number one in the list of things you should not ever do. Like, don't try this at home, kids. You just can't make this up. You just can't make it up. Literally La La Land. Oh, I love that. I love that. I was on my last vacation when I came to you guys from a undisclosed location. I was in Hermosa Beach. It's always Hermosa and Hermosa. And that is where the Lighthouse Cafe is. And of course, my daughter is a huge La La Land fan. And so we went there and she took pictures. And, you know, says how any law enforcement, let alone a friend of John O'Keefe, could hear how poorly his investigation was handled and not be outraged is both heartbreaking and mind-blowing. It is. It's mind-blowing. And we're watching this develop in real time. The fan is back. Thank you, literally, La La Land. And Attorney Wannabe, thank you for gifting a membership. And Flower Lover 8, thank you for your super sticker. You guys are so sweet and kind and generous, and I love that about you. Kelly, I wonder if Bev is diabetic or has a condition that requires timed medications. If she needs, say, insulin at 1 p.m., she'll have to break even if the late start. Well, we learned that it may be a court officer rule. We don't know. I also thought that perhaps she has a medical condition that causes tremors or, you know, something else, because that day when she came out and she was shaking, and it's not the first time that I've noticed her shaking. And I don't know. I don't want to guess about her medical conditions, but that could be. It could be. You could be right. In my opinion, says 10 misstatements of fact. We are witnesses to modern day witch trials. Yes, we are. Yes, we are. We are. We're watching it. It's really happening. KOB, the world is watching. End the circus, and dismiss this case. Thank you for thanking me, and thank you for your super chat. And Mickey's here. Thank you for your super sticker. AJ White, I've learned. Oh, the fan looks like it's dying. Look at the fan. The fan is like, I have had it. My credulity is strained and exhausted to the point where I cannot even properly fan the audience here because I am losing all sense of reality, credibility, and it's like I'm in slow motion and walking in a trance. That's what the fan is saying right now. I have learned that one needs to be involved in their own town's politics. That's right, AJ. You're right. Run for office. Thanks for your 20. Kyle, I've been on too many traumas to count. That kind of blood loss would pool and congeal on the softest ground. I've seen too much grape jelly. Oh, I can never unsee that, Kyle. But thank you for sharing your personal on-the-job experiences with us and for your super chat. Mickey says, I'm sure the weatherman will clear up ground and blood. Oh, and now the fan is totally dying. Thanks, Mickey, for your super chat. Auntie Bev's parole officer is here and says, in my opinion, the only explanation for Brennan's confidence to blatantly lie is that Bev is fully involved in this cover-up. This is a horrendous miscarriage of justice. Thank you, Auntie Bev's parole officer, for chiming in here. And for your super chat, can you pin the link to Karen's defense fund? I can. I will. Give me a second. Thank you for reminding me. Bo Cephas says, wasn't Trooper Fanning the one who drew the lottery numbers at the end? I don't think so. I think that was the clerk court Jim. Bo Cephas, I believe that was clerk court Jim. And I'm sure if it was, that Alan Jackson would have brought that up in his argument. Chloe's in Scissors says, with Karen having MS as I do, stress could cause Karen into a serious relapse. Yes. Been there, done that. Yes, that is true. Stress can cause a relapse, 100%. Marie says, hi, the double jeopardy is a bigger deal if a juror was dismissed without fact finding. And that's why Bev is pushing back, because she might have to dismiss this for that reason. Thank you. That's a great point. It's a great point. Jury tampering is a crime. It's a crime. It is. We saw it in Murdoch, right? Becky Hill, the court clerk, had some improper communications with the Murdoch jury. And we saw that happen too. Run the World is here. Thank you so much. My son was just accepted to medical school at Columbia. That's amazing. Congratulations. That is a huge accomplishment. Columbia Medical School. That is something. Congratulations to you, being the mom who raised that amazingly genius of a son. We need more doctors like him. He's going to be an excellent doctor. And Bev and her bull dinky is turning a joyous day into one of anxiety, bewilderment, and fury. Turn it off and watch it later. Go celebrate with your son. Thanks, Melanie. But yes, absolutely. Go spend the day with your son. That's an amazing accomplishment. We'll pop some champagne for him later. Congratulations. Deja Vu Cha 2, thank you again for giving me another 50 when your first super chat would have sufficed, but thank you so very much. Hold on for a second. Okay, I'm going to pin it now. All right. But the thing, I got to go to like 14 different devices, so just give me a second. There it is. Done. Thank you. Thank you so much, Deja Vu Trial 2, for your super chat. Very generous. I really appreciate you. Sandy B. Bev is sitting there fuming, listening to every judicious mistake be laid at her feet and the world nonstop by AJ, and he won't let her stop him. I love it. Yeah, me too. Team Wicked Smart versus Pure Wicked. If the FBI case is closed, can the actual federal investigators themselves be allowed to testify for the defense? I do not know the answer to that question. I'm not going to lie to you and say that I do. I think the investigators, probably not. Experts, maybe. Great question. I just don't know the answer to it. Turtle Boy got a new witness intimidation charge today. Arraignment is March 15th. Yeah, we pulled that up. I haven't been able to confirm it in the court docket, but yes, we do think it's confirmed actually. And we also think, I don't know that it was the 15th or the 18th. I can't recall now off the top of my head, but thank you again for pointing that out. I don't know what it's regarding. I don't know what it's related to. Dr. Russell is the GOAT, says, I'm here with you, yelling at my TV. We are outraged. Thank you. Thank you for yelling with me. I just think Beverly Canoni is a disgrace, says Kevin. Thanks, Kevin, for your super chat. Good time to point out that my viewers' opinions are not necessarily always my opinions. However, sometimes they are my opinions also. I'm going to take a quick break off screen here to drink some water because people get really annoyed when I swallow into the mic. Can you believe it? There's this thing called misophonia, and people don't like it. So excuse me for a second while I hydrate. I'll be right back. Don't worry. I'll be right back with you.
Court's back in session. You may be seated.
Banana, but apparently nobody's being
All
allowed
right,
into
Mr.
the
Jackson,
courthouse.
go ahead and continue.
Thank you, Your Honor. When we left off before lunch, we were discussing the inverted video. In the moving papers, the prosecution indicates that, quote, the prosecutor had not previously received this video or knew of its existence. This is I don't know, it's the third or the fourth time that the Commonwealth sort of runs to this argument about not knowing personally about the existence of a particular video, but that it doesn't matter how many times they argue that point, it still doesn't change.
Yeah. We know that Mark is not there. Mark is not there because he has to be in the other courtroom for Aiden's 2:00 hearing. If you guys want to find out what's going on with him, you can go somewhere else and do it. But let's keep the chat on task right now about the Karen Reed case. That's what we're here for. We're here for that motion. Mark has Turtle Boy's hearing at 2. I can't cover that until later. And we will hopefully find out about all of that. So please, again, let's just try and stay on task and topic right now. I would appreciate that so very much. Thank you. And take it back a bit.
Fourth time that the Commonwealth sort of runs to this argument about not knowing personally about the existence of a particular video, but that it doesn't matter how many times they argue that point, it still doesn't change the fact that
doesn't make it true.
It prejudiced the defense by not having it, and one of their members, whoever that agent is of the Commonwealth, was lying about having it and not disclosing it. Somebody knew, and the question before the court is, who was it? Who did know? Perhaps it wasn't Mr. Lally, perhaps it wasn't Ms. McLaughlin. Was it Chief Rafferty? Certainly Proctor had it. He watched it. Who else knew about it? Members of the prosecution knew of the existence of this and other videos, and they hid them. And that's the galling issue. Then the Commonwealth writes that the defense altered, their word, the defense, quote, altered evidence to correct the image, as if we were altering something to deceive the court. When in point of fact, the Commonwealth well knows that that altered video was altered by them in some way, shape, form, or fashion. When it was played inverted. What we did is recorrect it to the proper orientation to confront Sergeant Buchnick with it. They indicate that they played the entirety of the video, of the corrected video, to somehow suggest that the Commonwealth during this debacle had clean hands. And that's just not true. Over the course of 2 days, the court will recall 2 days worth of testimony. Day one with Sergeant Buchnick under direct examination by Mr. Lally. Going into the next day, still under direct examination by Mr. Lally, they played that video completely inverted. They talked about it, they discussed it, they described it. Not once did Sergeant Buchanan or Mr. Lally inform the jurors or the court that the video was actually altered, that the video was actually backward. Not one hint to the court or the jury members. When the defense stood up and began questioning Sergeant Buchanan about that video, that was the first time that he admitted that it was inverted. He used the phrase mirror image, and that he knew that it was inverted. Amazingly, that was the same time that Sergeant Buchanan started having trouble with his memory about who was actually depicted in that video. The court will recall before I stood up on cross-examination, under direct examination by Mr. Lally, Sergeant Buchanan was very quick to point out that the individuals on that inverted video were himself and Michael Proctor. And they made the point that Michael Proctor never approached or had any access to or didn't manipulate in some way, shape, form, or fashion. This was the intimation by the Commonwealth, that passenger taillight. The Commonwealth has now conceded that that person was, in fact, Michael Proctor. It's notable that the Commonwealth went to great lengths to state that, quote, Trooper Proctor, and this is in their opposition, Trooper Proctor is standing feet away from the defendant's vehicle and never touched the right rear taillight, end quote. That's a statement made in their moving papers, specifically on a fact that is of great material importance to this case. The three of them signed, the three prosecutors signed an oath and a declaration, and the court just called the defense out on signing a declaration or an oath. And the court's intimation, at least in its initial comments to me, was, you may have said something that you don't have a factual foundation for. And I think I have done my best to disabuse the court of that we were drawing from reasonable inferences.
Somebody needs to disabuse, because this is nothing but abuse. But yeah, you're going to call me out in front of a worldwide audience for something that you think that I lied about under oath, and you don't do it the same way for the other side? Really? He's right.
I wonder if the Commonwealth is going to get the same treatment for saying that Trooper Proctor was standing feet away from the defendant's vehicle and never touched the right rear taillight.
That's right.
That's a very bold statement for the Commonwealth to make, and it's also completely untrue.
That's
it's
right.
Not supported by a single fact.
Yes.
It's not supported by a fact or evidence before the court. The problem with this unsupported motion, because it's unsupported and the declaration is signed by three different individuals, you can just sort of say whatever you want in the motion.
Right.
And I guess get away with it.
Three people on an
The video
affidavit.
speaks for itself, Your Honor. It shows Michael Proctor walk behind the car directly to the position of the passenger taillight.
We've all seen it. We know.
He positions himself right on the other side of the camera view, not feet away. And it certainly does not show, and there's no evidence before the court, that he, quote, never touched it. As a matter of fact, we would submit.
Does it show that he does touch it?
Well, of course it doesn't show he touches it, Your Honor. He's on the other side of the car.
And it's graining.
That's not the point. The point is, a reasonable inference is he could have touched it. He was standing right there. Nobody forced him. Nobody was holding a gun to his head. He walked around the other side of the car and obviously was standing there for a reason.
And they made you
in a corner, out of the view of a camera. And then when the Commonwealth plays the video, it switched. And the intimation to the triers of fact was he never approached the right rear taillight, that passenger taillight. And all of that
and you cleared that up.
Right.
It does not correct the material, fraudulent misrepresentation to the court, the suborning perjury, the clearly introducing of fraudulent, altered evidence. She's like, oh, and you cleared it up, so no big whoop, no biggie. Are you kidding me? My head's gonna pop off. It's official now. It is official. You cleared it up, right? So no big whoop. It's cool. We're all good because you cleared it up. There's no prejudice now because you cleared it up. The prejudice was how about Karen Reed having to sit through a persecution? She's already been on trial for this, Your Honor. There is no other proper remedy now for Karen Reed for justice than for you to dismiss this case now. You cannot say you cannot say the Commonwealth can withhold all of this evidence, manipulate it, trash the metadata, not turn it over until now, and say that she suffered no prejudice. The prejudice was the entire ducking first 10-week trial. She's already been prejudiced. How are you kidding me right now with this? Well, you cleared it up. No big whoop. I gotta rewind that because you gotta hear it again because heads are popping off all over LawTube right now, I'm sure. And I can't wait for Aussie to make her mashup video of this because I am outraged.
And then when the Commonwealth plays the video, it switched, and the intimation to the triers of fact was he never approached the right rear taillight, that passenger taillight. And all of that
and you cleared that up.
Right. But that is the galling part of this entire thing.
Mm-hmm.
The court has asked me a couple of times, and I'm going to get to it a little bit more in detail, what the prejudice is. If that's not prejudice, I don't know what is. It's literally propounding false information to a trier of fact. That is not a small thing.
But to her it is.
Even after the trial was
cleared that up, right?
Concluded, and the mistrial was declared, we're still getting videos that we can't get a straight answer about their source. Where did these videos come from in October? that surveillance feed is on a 30-day deletion loop. That's what we've been told.
Right.
I said a few minutes ago this morning, I said the Commonwealth may not have known that it was on a 30-day loop. What I meant was actually the prosecutor sitting in this courtroom.
Right.
The three, my brothers and sister, may not have known about that 30-day override.
I want to say to my sisters and my brother, keep the faith. It's a song. It's a Jerry Garcia band song. Sisters and brothers and sisters. I forget the real name, but I'm going to say to my sisters and my brothers, keep the faith, keep the faith. And now he's pulling out that old term where he's calling them brothers and sisters. And that's what they do. Apparently in Massachusetts, occasionally they call them my brother, my sister when they're talking about opposing counsel, because we saw that in one hearing a very, very long time ago. Let's hear that again. That's going on the playlist. Jerry Garcia band. They may not have known. Bullshit, they knew. Sorry.
This morning, I said the Commonwealth may not have known that it was on a 30-day loop. What I meant was actually the prosecutor sitting in this courtroom. The three, my brothers and sister, may not have known about that 30-day override. I don't know. I don't know what they knew or didn't know. I'm certainly not going to cast aspersions and put that on them.
Like they did to me.
Someone from the Commonwealth darn sure knew that was on a 30-day loop or a 30-day override. So who's had those for all this time? How were they stored? Why wasn't that information revealed to our expert when we went all the way to Canton to try to download that DVR? Where's the original? Where are the copies? These are questions for which we need some facts. And the fact that those have been withheld from us is exactly the kind of bad act and bad faith that demands that the court presume prejudice in the case.
Of course.
A few minutes ago, the court asked me before lunch, what is the prejudice? There's plenty of actual prejudice, but I'll get to that in just a second when I speak a little bit about the law at the end of my comments. We don't need to prove actual prejudice because the law presumes prejudice against Ms. Reed because of the bad conduct on behalf of the Commonwealth. And yet again, when it comes to this same issue, the Commonwealth recites this now worn out sentence, the prosecutor was unaware of the existence of these videos, end quote. How many times are they going to try to excuse away a blatant discovery and or Brady violation with the sentence that the prosecutor was unaware? It just doesn't matter.
It doesn't.
And that brings us to the October 10 videos that we got in 2024. The Commonwealth claims that they received these videos on or about August 21st, 2024. They sort of vaguely claim that these videos were provided along with a letter, quote unquote, letter from Canton Police Chief, end quote. There's no report, there's no email, there's no communications, there's no text message, nothing other than this, quote, letter.
I screened about that too.
And it actually wasn't a letter. It was more of an informal note written on a personal pad, a Canton PD pad by the chief. There's no chain of custody log authenticating the videos, no authentication documents whatsoever, no foundational documents, no indication of where the videos came from or how she came to possess them at the time. But she did write on that little pad, quote, that is how it records, LOL, no tampering.
LOL? No tampering? What?
LOL.
Stop.
Laugh out loud.
Stop. Okay, we're getting somewhere about Helena Rafferty. Okay, Helena Rafferty is the chief of police of Canton now. Yeah, she also mowed down an old man. I'm sorry, maybe he's not that old. I don't know how old he is, but he's older than I am, so he's not an old man because he's probably close in age to me. She mowed down a pedestrian in a crosswalk, Helena Rafferty, the chief of police of Canton, and broke like every bone in his body. He's had multiple surgeries in her police issued vehicle and kept it a secret from her constituents, from her people of Canton. And now we're finding out that this is what Chief Rafferty said in her note, no tampering, LOL. Hold on. Now you see why they brought in a new attorney. Yeah, it was their bold assertion that the chief handed them this video. And here we're going to find out. Here's the bombshell of the day. So listen, everyone. Listen, I'm rewinding it. Prepare your head to pop off right now. Put a bucket next to you to catch all the blood. Here we go.
Commonwealth claims that they received these videos on or about August 24.
Wait, a little bit.
October 10 videos that we got in 2024. The Commonwealth claims that they received these videos on or about August 21st, 2024. They sort of vaguely claim that these videos were provided along with a letter, quote unquote, letter from Canton Police Chief, end quote. There's no report, there's no email, there's no communications, there's no text message, nothing other than this, quote, letter. And it actually wasn't a letter. It was more of an informal note written on a personal pad, a Canton PD pad by the chief. There's no chain of custody log authenticating the videos, no authentication documents whatsoever, no foundational documents, no indication of where the videos came from or how she came to possess them at the time. But she did write on that little pad, quote, "That is how it records, LOL, no tampering," end quote.
That is how it records, LOL, no tampering. XOXO, Chief Helena Rafferty, or as Gary's calling her, Riff Rafferty. Really? This is like a little sticky, a little post-it note that she attached when they turned over the videos in October of 2024, way after the trial, way after the mistrial, way after Karen Reed is already $5 million in debt for legal fees, has to sell her house, has to liquidate her 401ks. This is a big ducking joke. It's a big ducking joke. LOL. Isn't this funny? Isn't this funny? Karen Reed's life has been destroyed because they've been trying to pin it on the girl when John O'Keefe was not hit by a car. A car did not hit John O'Keefe. And Sandra Birchmore did not hang herself in her bedroom from a doorknob either. And this judge needs to get her head out of her ass and figure out that all of this stuff is relevant. All of this stuff is so highly egregious that this case would be dismissed already in any other jurisdiction. Those Birchmore police reports that have been redacted should absolutely be turned over. How dare she sit up on that high bench, Lady McBev, and say that there is no relevance? Can you tell me how those Birchmore reports are relevant? You know what? Fanning was the lead investigator in that case. Fanning met with Matthew Farwell, the one who's now accused of federal murder, of murdering the 23-year-old girl that he impregnated while his wife was in labor in the hospital, whom he met when she was about 11 or 12, took her virginity at 15 in the Police Explorers program. Fanning was the one who was in charge of that investigation. Fanning was the one who interviewed Matthew Farwell, Stoughton officer Matthew Farwell, in a car outside in a school parking lot or some shit somewhere. Fanning is the one who cleared him of any wrongdoing in the death of Sandra Birchmore. And Fanning is the reason that that was ruled a suicide. And the feds had to get involved in that case and quickly found the 32,000 messages that Trooper Garino couldn't find on Matthew Farwell's phone that indicated all of this stuff. And he's now sitting in Club Fed, Matthew Farwell, ex-Stoughton police officer, for murder charges on Sandra Birchmore. So don't sit up there, Lady McBev, on your high horse and tell us that none of this stuff is relevant. All right? Because we're mad as hell and we're not going to take it anymore. And this is complete and utter bullshit. I got a button for that. And for some reason, when I play it, it doesn't play in the mic. I don't know why. You probably couldn't even hear it because it's too close to the mic. I don't even know. And I am outraged, and every single one of you should be outraged. And if you think Karen Reed is guilty, you should be even more outraged at the way that this case was handled. You should be even more outraged because there's no video from Canton PD showing a shattered taillight. Pictures of that taillight in Karen Reed's parents' driveway in Dighton, showing the condition of that taillight when Proctor and Buchanan went there to seize it without a warrant. You should be even more outraged if you are the O'Keefes who have to sit there and listen to the way that the investigation of your dead son police officer was handled. This is a joke. This is a laughingstock, and every single person watching this should be outraged. I have never seen anything like it. And every single person in the media back there sitting at their high top, you see them all with their laptops. You think they're going to report on this today? Do you think mainstream media is going to report on this today? Or do you think they're going to report about Judge Bev's public spanking of the defense team? What do you think they're going to report on? All right, I'm going to be quiet now. I'm going to let him talk because I've had it. I've had it. Laugh out loud, Rafferty, laugh out loud. You guys know that the Canton police audit report is due on April Fool's Day too? And that's the day Karen Reed's trial is supposed to start. I'm not involved in the local politics in Canton, but that's what I've been told. That the town of Canton has chosen to have their police department audited, and the report on that audit is coming in April 1st. And I hope whoever the auditors are watching, because your chief of police thought it was funny. It's funny. Karen Reed is facing 20 years in prison. I don't need to go through the list of things that have also happened to her in that time. That I just did about the $5 million in debt, et cetera, et cetera, et cetera. But how are we here? The police chief thinks it's funny. Okay, here we go.
How it records LOL, no tampering, end quote. LOL, laugh out loud. So the chief of police is laughing in the face of serious Brady violations, in the face of serious evidentiary violations and
what was the
discovery
date?
violations.
10/10/24 you received that? Was that the date?
10/10/24. That's correct.
Hey, Bev, how about something funny, Chief Rafferty? Something funny, Chief Rafferty?
By the way, the Commonwealth claimed in its opposition papers that, quote, the prosecutor requested that both Massachusetts State Police and Canton Police Department produce all relevant and material surveillance video, end quote. And that was sometime unidentified between April 17th, 2024 and April 24th, 2024. I laud them for that. Good. I'm glad they demanded finally, in the middle of trial, quote, all relevant and material surveillance video. So why didn't we get this from Canton PD until October 2024, well after trial? What was the delay? And why did we get another video in January of 2025? What was the delay? How could this be seen as anything other than intentional? We know now that Sergeant Buchanan, we know that Proctor, we know that Chief Rafferty, and now through another report, we know that this officer, DGM Petro, all had access to and knew about the videos. And then we have on top of that, in the middle of trial, I think it was Mr. Lally, it may have been Ms. McLaughlin, someone said, it's unclear from the opposition, that all relevant and material surveillance video be turned over immediately, and it still wasn't done. That is an intentional withholding of evidence. And then we get these new reports.
Okay, before he gets the new reports, Rhiannon, great question. Do you have grave concerns now, Judge Cano? Do you have grave concerns that the Canton police chief said, and I quote, "This is how it records, LOL, no tampering." The Canton PD was conflicted off of this case on the morning of January 29th of 2022 when it was discovered, not that it had to be discovered because everyone knew, 34 Fairview was the home of Brian Albert, a Boston police officer whose brother, Kevin Albert, was a Canton PD cop. They were conflicted off of this case because, I'm shaking now, they were conflicted off of this case because of the familial relationship between Brian Albert, homeowner, and Kevin Albert, Canton PD officer. And do you have grave concerns now that the Canton PD chief is still got her hands in this case as of October of 2024? Do you have any grave concerns that those videos were not immediately taken from Canton PD and brought somewhere else? That the Canton police officers who were conflicted off of this case had access to this system, to these videos for over 2 years? Where's your grave concern now? Where is it?
What's probably most troubling is what's in the reports that we got on Friday, this past Friday.
There's going to be
Additional
more
reports from the Commonwealth. In a report from Sergeant DGM Petro.
I don't know if I can handle this. I don't know if I can handle it.
He reveals the following. He writes this report on the 27th, which was last Thursday, and then we got the report on the 28th.
Of course.
He says that in February of 2022, and I'm paraphrasing, in February of 2022, Proctor requested Sallyport video of SUV inside Sallyport. Apparently that was provided. I mean, we have to presume from his report when he says Proctor requested in February of 2022, Sallyport video of the SUV exterior footage that he downloaded it from somewhere and gave it to him.
They had it in February of
Assuming it
22.
was February of 2022, that would have been before the override, I presume.
Yes.
I think the math in my head is it's 28 days in February. If it's in February at all, it's within the 30 days from January 29th. So it has to have been. Wow. Then he writes that in June of 2023, Proctor requested Sallyport video again of the SUV exterior footage. Quote, this is from his report. I believe this may also have been the approximate time that I downloaded video recordings that covered the entire time frame that the suspect's vehicle was held at the Canton police station.
Oh.
End quote.
Oh. All
He
the
goes on
videos.
to say, quote, due to the large size of the files at that time, I had to break it down into 6-hour blocks for ease of exporting.
Oh,
This
really?
is the first we're hearing of any of this.
Wow.
Last Thursday.
Last Thursday, this guy, this retired guy who we joked about missing his tea time to all of a sudden now make up his chain of custody logs. Boy, he's like, I'm not losing my life for you people. I'm going to tell it like it is. And he's telling us that he has all of the video. He had all of the video from the entire time that the murder weapon, also known as Karen Reed's Lexus, if you believe the Commonwealth, all the video, he had it and he downloaded it in 6-hour blocks because there was so much of it and they've had it since the beginning of this case and they didn't turn it over. And DGM Pietro is telling them that and they just got this on Friday. This case has to be thrown out today. This has to be like a Judge Summer thing. This has to be out. The case has to be thrown out right now. How's Brennan going to defend this? It's a Canton police officer who's retired, who's swearing to this under oath. June of 2022 is outside 30 days, right? They've got it all. They had all the video. He had all the video. All the video.
How is that? Sure. Ms. Looms just handed me a clean copy of the DGM Pietro report. I would like to have this marked and appended to our motion to dismiss if it's okay.
Sure. Did I get that attached to your motion to change the scheduling?
Yes.
You probably did.
So I've seen it.
Okay.
I've seen it, but really, how is it relevant?
Hold
How
on.
is it
what, Ms. Little?
exculpatory?
We'd still like to make it part of the record if that's all
Sure.
right, Your
Yes.
Honor.
I just wanted to know whether I needed a copy because I have a copy. I've seen it.
May I approach?
The world needs a copy, and he's going to tell us what's in it too, because this is insane. This is egregious. This is, they should all go to jail. They should all go to jail. Every
So are
single
we
fucking
marking
one.
it? So
Every single one of
we
them should go to
need it
jail.
If we're marking it.
Oh, I'm sorry. My mistake.
Look at Karen. Look at Karen. Look at her face. Look at what she's been through. Look at her family's
ahead,
been through
Mr.
for 3 years.
Jackson.
And look at
Thank
that
you, Your Honor.
asshole Paul O'Keefe sitting behind her. Something funny, Mr. O'Keefe?
The question is, how in June of 2023, now I'm going to go a little bit slow here just because it's linear. The argument is linear. In June of 2023, according to DGM Pietro, he downloaded every single bit of video of that car while in the Sallyport or while at
All of
Canton PD in Sallyport. How is that possible? How could that be? As of February 28th or maybe March 1st, those
They lied.
videos are gone.
They
So how could
lied.
he have access to the whole thing? It's because someone at the Commonwealth downloaded the whole thing. They saved it. Or the only other explanation is That DVR was not at the time on a 30-day override. It's the only two explanations. Again, this is binary. So in April of 2024, as the court knows, we got additional video, and that's the inverted video. In the spring of 2024, while trial was being held, DG Petro, quote, it says, quote, I downloaded some video recordings that you and I believed may be needed to refute claims being made by the defense. The you and I is him to Chief Rafferty. That's who this report is to. And it includes footage of Higgins. So now we find out for the first time that Chief Rafferty and this sergeant had been talking and strategizing about how to defeat some defense arguments, presumably, by use of videos that had never been turned over. And the Commonwealth uses a phrase in its moving papers, I believe in this motion, about ambush. That is the definition of an ambush. So DG Petro admits that he, Rafferty, and the Canton Police Department had Sallyport video that was material to the case. Remember, his quote was that you and I believed may be needed to refute claims made by the defense. They were strategizing about how to defeat certain of our arguments, and they didn't turn it over.
God. Oh my God, they're so corrupt.
Specifically, he downloaded video and presumably gave it to Chief Rafferty. But then the interesting thing is Chief Rafferty held on to it. She never turned it over.
Oh,
probably because they didn't help.
How do you think those silver bracelets are going to look on Chief Rafferty? Anyone? Anyone? Somebody in here said, stop stopping it. Let him talk. No, this is my channel. I'm going to do whatever the duck I want. And sorry if you don't like it, go to law and crime. Again, can you stop? Go off later? No, don't come on here and tell me how to run my channel. Thank you. Here, this person. Now I'm going to stop it and then we're going to sit here. We're going to sit here now because this is like kindergarten. Okay? Break. This is outrageous. They should all be in silver bracelets right now. There should be troopers outside arresting them. And they're putting some more charges on Turtle Boy today? Really? Somebody said in the chat it has to do with Rafferty. I wonder why. I wonder why. Rafferty should be the one in bracelets. Where's her grave concerns now? Me too, Scott. I'm shocked she hasn't interrupted yet.
Prosecution. They showed Higgins engaged in conduct that is, at the very least, highly suspicious and clearly exculpatory because it impeaches his other testimony. It shows him on the phone. And he testified that he didn't make calls in the middle of the night. There's no question that with this example, that is an intentional withholding of evidence. That is the legal definition of bad faith, and it's unconscionable to do that. Now put in context what we eventually did receive during the trial and then after. We received the inverted video that was falsely presented as the right passenger side of the vehicle, or the passenger rear side of the vehicle. Number two, we received several videos of Brian Higgins at Canton Police Department, clearly using his phone at approximately 1:35 or so a.m. We received exterior footage that would ordinarily show the condition of the passenger taillight, which all happens to be corrupted, like every other video of the rear passenger side of that SUV. This is stunning. It's not like the Canton Police Department and the Massachusetts State Police were sort of blissfully incompetent or blissfully ignorant and unaware of the existence of these exculpatory videos. It's quite the opposite. Multiple officers, Proctor, Rafferty, Buchnick, O'Rourke, DG and Petro, these individuals, we believe, O'Rourke may not have known, but we know that the others did, and have now basically admitted it or been caught trying to hide it. They were all variously actively engaged with these videos. They were searched for, they were discussed, They downloaded them, they saved them, they copied them, they labeled them, they transported them, they reviewed them, and they strategized about them. These videos were top of mind for all of these folks. We know there were hours and hours and hours of footage that was so large it had to be broken down into 6-hour blocks. All of that was pulled. And none of this footage was disclosed to the defense before April of 2024. And most of the files that have been turned over so far have been turned over after the trial was over. We had no idea this footage existed, and to this day, it continues to be, the bulk of it continues to be withheld from the defense. And then we move to Sergeant Buchanan's actual report. As I indicated, he wrote a report last Friday as well, dated the 28th. Quote, in furtherance of the John O'Keefe Canton homicide investigation, sometime in early spring of 2022, I was made aware that a request had been made by Trooper Proctor and then fulfilled by Canton PD for surveillance video as it related to the arrival and storage of the Lexus SUV belonging to Karen Reed.
2022?
This was the spring of 2022.
He's just writing a report now? Okay.
At Trooper Proctor's request, I proceeded to Canton Police and picked up the digital media storage containing said video and transported it to the Canton, Norfolk District Attorney's Office.
Oh, so they had it.
Over to Trooper Proctor. I did not review this video at this time.
What date did he do that? The same date?
He says at this time, but it's the sometime early spring of 2022. That's the best he can do in his report.
No, I'm screaming. You're screaming. We're all screaming. Buchanan is throwing Proctor under the bus. Do you see what's happening here? 3 years later, Buchanan is writing a report to throw Proctor under the bus. There was no chain of custody. Contemporaneous with the events, as it's supposed to be. Boozy Beauty is here. She's beautiful. She's boozy. She's got an amazing YouTube channel and she makes amazing TikTok videos. And I don't even know what's happening with TikTok. I digress. He's throwing Proctor under the bus. They are all going to jail. In my dreams. Listen to this again. He didn't review the video, but he's making a report 3 years later. We're going to need to watch it again at some point later. But for now, we're a little behind, so I kind of want to catch us up.
The same date?
He says at this time, but it's the sometime early spring of 2022. That's the best he can do in his report. Paragraph 2, in July of 2023, so this is a little more defined, I was once again made aware by Trooper Proctor that a request had been made to Canton PD for additional video and that it was ready to be picked up. Since the Canton Police Department is conveniently located on my route of travel to work, I stopped by and picked up the CD from the front desk of the police department, which was labeled Trooper Buchanan with a yellow Post-it note. I further added Canton PD 12922, and then the case number, which is, or their case number, 2022-112-33, to note to more accurately identify the item and transported it to our office, subsequently turning it over to Trooper Proctor. So there's a second CD, now in July of 2023. I did not review that video at that time. See the attached copy of the Post-it note. Final paragraph, in my preparation for trial in May of 2024, I was provided with a thumb drive and the CD labeled with a Post-it note on my desk. What's interesting is that the CD with the Post-it note on his desk may or may not have been the same CD that he transported in July of 23 because they seem to be labeled a little different.
So I haven't seen this report. Does he say from whom he received that?
I'll finish reading it, but I don't believe he does. No, it's pretty vague.
She's actually paying attention now?
It's pretty vague. I was provided a thumb drive and a CD labeled with a Post-it on my desk to review prior to testimony. So it does not say. At this time, I reviewed video made available to me, which included video footage of the Canton PD exterior Sally Port. This
And they just
video was
turned those over
labeled
last
with a
week.
Post-it note on a CD, and it contained a video of the interior of the Sally Port, which was grainy and had a camera vantage point from the front of the Sally Port. I also reviewed the Canton PD driveway footage. In review, I also viewed video of the back wall Sally Port camera vantage point. I had not seen this video prior to my May date review. I later learned that this video was provided in an inverted manner. After I reviewed all the provided video, the thumb drive and the CD were returned. It doesn't say to whom they were returned. Your Honor, if I could mark this report as well.
Sure. Do you have an extra copy for me?
I do. It does have one highlight on it.
Yeah, I sense a dramatic shift in Bev's attitude too, Brian. I'm with you on that. I just want to take that back. Well, while they mark that, we have a little bit of time. And because I want to hear, I got distracted by something. I just want to hear that again. What exactly? Because this is mind blowing so much.
I also had a camera vantage point. This video was labeled to me, which included
Buchanan's report. Hold on.
Passive voice, and it's pretty vague. I was provided a thumb drive and a CD labeled with a Post-it on my desk to review prior to testimony. So it does not say.
This is Buchanan. This is Buchanan's report that he just wrote the other day, just so I don't have to rewind it again. Okay.
I reviewed video made available to me, which included video footage of the Canton PD exterior Sally Port.
And the first exterior Sally Port videos that they got were after the trial was over, right? Yes. Okay.
Exterior Sally Port. This video was labeled with a Post-it note on a CD, and it contained a video of the interior of the Sally Port, which was grainy and had a camera vantage point from the front of the Sally Port. I also reviewed the Canton PD driveway footage. In review, I also viewed video of the back wall Sally Port camera vantage point. I had not seen this video prior to my May date review. I later learned that this video was provided in an inverted manner. After I reviewed all the provided video, the thumb drive and the CD were returned. It doesn't say to whom they were returned.
Yeah, it's going to be break time soon because how's her head not popping off?
If I could mark this.
All right, and that's where we left off. Do you have an extra copy for me? Now she's all nice.
The two still marked?
So you do have an extra copy, Ms. Little?
I do not have an extra copy, Your Honor.
Send Jim to the
I
Xerox
thought Mr.
machine.
Jackson just said he had an extra.
Oh, I'm sorry.
Yeah. Mr. Jackson, do you have an extra copy?
I think I might.
I've got it right here.
Really? Judge?
You have an extra copy? Is that one clean?
It has your notes on it. Don't give it to him. Yeah, this guy here in the suit that looks like a Fed, that's Carl Dougal. He was friends with John O'Keefe. He's also I think, a
This
Boston
has
police
highlights
officer.
on it. I apologize.
It's okay.
People keep asking who he is, so I'll keep telling you.
All right, go ahead.
Thank you, Your Honor. The court asked probably the most important question about this report, which is who was it that supplied the video or the thumb drives or the CDs to Sergeant Buchanan? Who's at the center of all these Sally Port videos? Who does he say was requesting the Sally Port videos that he was acting as the courier for in other particulars? Every one of those answers is Michael Proctor. So who do we believe most reasonably would have supplied the information to Sergeant Buchanan to review? It stands to reason it could have been Trooper Proctor. Seems to be reasonable, but I don't know because Trooper Buchanan doesn't say, but that would be another question that would be open to answer if we had an evidentiary hearing.
Where's the sigh emoji, you guys? We have
Michael
sigh
Proctor was
emoji.
receiving the footage directly from DG and Petro, dating all the way back to February of 2022. He was the one receiving the footage directly from Buchanan, dating all the way back to the spring of 2022. Michael Proctor was receiving footage from both sources multiple times through the years. Proctor was the one who clearly had possession custody, and control over the exculpatory footage. It was his, every bit of it. And now let's recall what he said at trial when asked about all this footage, because he was confronted about footage. And keep in mind, Your Honor, when I'm asking these questions, I know none of this. None of it.
There's the prejudice, Your Honor.
Michael Proctor lied during his testimony, but he knew that we couldn't impeach him. There was no way I could impeach him. I didn't have any of these videos to impeach him with because we didn't have any of the evidence that had been secured concerning that Sallyport. Question. There's surveillance video from Canton Police Department's Sallyport garage that wasn't turned over, right? Answer. That video was discovered later on and then handed over. That video was discovered later on.
So where in the transcript is that?
I can get you the page and line number, Your Honor.
My guess is Ms. Little can get it pretty quickly.
I'm
Yeah,
guessing she
That's
can.
you in just a moment, Your Honor.
Would you like my yellow highlighter, Judge? We could highlight things for you and hand them to you that way. Was
June
that
10th?
better?
It was either June 10th or June 12th, but let me double check.
Well, she's looking for that, Your Honor. May I
Please go
proceed?
ahead. Yeah.
Okay. The only thing that's it's important to remember from a date standpoint, we'll get the date that he actually testified to this, but from a date standpoint, the only thing that had been handed over at the time that he testified to that was a single video with 42 minutes missing and a flatbed and the flatbed driveway footage outside the Sallyport that doesn't show much of anything. It's now been proven that testimony, that video was discovered later on and then handed over, suggesting there was either only one video or all of it was discovered later and turned over. Both of the clauses in that sentence are a lie. The video wasn't discovered later. It was discovered in February, at the latest, February of 2022, just days after this incident. He asked for it and he received it, according to Sergeant DGM Petro.
But then Brennan says, we didn't even know there were cameras at the Sallyport.
Turned over either. None of it. But at trial, we didn't have the truth. I couldn't impeach him with this. He made sure that all the footage was delivered directly to him starting days after this incident. And he controlled it, he hid it, and then he lied about it. That is the definition of bad faith. That is the definition of withholding exculpatory evidence. That is the definition of suppressing Brady evidence.
Egregious.
There
It's
is
egregious
no
too.
other way to define this. He fooled us, and it's egregious.
Oh, he said egregious.
Is it possible with all this sort of years-long flurry that we've just talked about surrounding these Sallyport videos that the actual trial prosecutors were completely unaware of their existence until Proctor testified before the federal grand jury? Is that possible? I suppose it is. I want to give the prosecutors the benefit of the doubt. I do.
No, don't.
Is it reasonable? That's another question. To believe that they just knew nothing about this. We know Proctor lied to us. Could he have lied to them? I suppose. But as the law mandates, Your Honor, it just doesn't matter.
That's right.
In the eyes of the law, Proctor is the prosecution, and the prosecution is Michael Proctor.
That's right. His knowledge is imputed
And then we
to
move
them.
to January 28th, 2025, this year. We're still getting additional videos at that time. This new camera angle, which is blurry and grainy and wobbly, it does, however, show the passenger side rear taillight as it's towed into or driven into the Sallyport garage. The footage is so grainy and so blurry, however, it's so corrupted that once again, the true condition of that taillight is completely obscured. At a certain point, it begins to defy logic. And the reason I wanted to talk about each one of these videos in turn is because it absolutely defies logic that all of this footage magically cuts out, blurs out, becomes grainy, becomes obscured at the precise time that the SUV is pulled in to the Sallyport.
Of course it does.
The question then becomes, what's been happening to these videos that have been in Michael Proctor's possession since that time, for the last 2.5, 3 years? And again, I've lost count how many times the Commonwealth makes the claim, quote, prosecutors had never seen this video, end quote. The entirety of the Commonwealth's defense on this issue is the indefensible, which is, it just wasn't me. Okay, fine, it may not have been you, but it was the Commonwealth, in quotation marks, capital.
It's the Shaggy defense. It wasn't me. It wasn't me. Doesn't matter. Look at the victim side. It has dwindled. There's only 6 people there again today. They have 10 seats available for the O'Keefe side.
The Commonwealth then claims that, quote, after directing a review of all physical evidence and data files, after directing a review of all physical evidence and data files, this video was located within a paper case file of the investigators, end quote. I believe that Mr. Brennan, when he came on the case, he's the one who directed a review of all physical evidence and data files. I would have to guess. Again, I would applaud that. Should have happened years ago. What's most curious about this video, however, is that the prosecution now admits, quote, after inquiry, it was learned that an investigator obtained this video from Canton Police Department in 2022. And it was placed in a physical case file, end quote. That's a direct quote from their opposition. They don't name who the investigator is. They don't indicate whose case file it was. They don't tell us where that case file had been, who had control over that case file, just a paper case file somewhere, mysteriously. Yeah. Whether it was CPD or MSP, we don't know.
No
Which
detail.
Investigator, we still don't know.
No big whoop.
What can we learn from this admission by the Commonwealth? That investigators did, in fact, download the Canton PD videos in 2022 before they were overwritten. That's the only way these videos could exist. We've talked about that. And what we don't know is where the rest of them went and why we don't have them and why we didn't have them for the first trial. The Commonwealth basically concedes that it is in direct violation of its discovery obligations not to have turned over these videos that were in their possession. But it makes the claim that it doesn't matter because, quote, the poor quality of the video makes it difficult for either party to benefit.
Oh, we laughed at this argument, boy.
End quote. In its opposition, it sounds like more of a desperate argument than anything else that these cumulative, that these egregious errors don't justify the court taking any action because they claim, quote, there's no evidence of bad faith. I would take issue with that. But the quote goes on, there's no evidence of bad faith on behalf of the Commonwealth, nor any of its agents, particularly where the Commonwealth is equally aggrieved by the poor video quality and inability to obtain a forensically extracted copy of the surveillance video. Equally aggrieved. First, in that sentence, the Commonwealth admits that the defense is aggrieved. They say they're equally aggrieved, however. Aggrieved means wronged or unfairly treated or suffered harm.
Right.
Or injustice. Merriam-Webster defines aggrieved as suffering from an infringement or a denial of legal rights. You bet we're aggrieved. But the Commonwealth can't claim that they're aggrieved when they're the ones doing the aggrieving.
Yeah.
It doesn't work that way. The Commonwealth concedes that there's irreparable harm. They acknowledge that the forensic videos were destroyed, or at least they claim now that they're destroyed. We can never obtain the information necessary to establish the validity of any of these videos or whether and by whom they may have been manipulated, if at all. The Commonwealth can't shift the blame because the videos have literally been in their possession the entire time.
Wow.
It was their actions and the actions of their agents that caused this irremediable harm. Your Honor, this is, as I said, this is the definition of bad faith. And this goes back to the court's original question this morning, which is, can you describe the prejudice that Ms. Reed has suffered? And I think we've done a pretty good job of describing that throughout this argument.
Yeah, you think?
But the definition of bad faith means we don't have to prove actual prejudice. Prejudice is presumed under the law. If we're to believe the declarations that were submitted by ADA Lally and ADA McLaughlin and ADA Brennan, then at the very least, there is no other conclusion but that Michael Proctor and other investigators intentionally secured these videos. They withheld the evidence from us, And they withheld the evidence from the prosecution team. Let's take them at their word. Even after being explicitly instructed to turn over that evidence, that is bad faith.
Yeah. Textbook. We learned that in law school.
And how many times do they have to say, we didn't know about this? It just doesn't matter. Let's, like I said, let's take them at their word. It doesn't absolve the Commonwealth of its obligations, and it doesn't reduce the prejudice that the defense has suffered. This was a pattern engaged in by the Massachusetts State Police, by the Canton Police Department, over and over and over again. And now we know through this new revelation that it was intentional.
Mm-hmm. There's no other remedy.
The prejudice the defense
than to dismiss this case
is legally presumed, and it's also factually proven. And thus the only remedy is dismissal.
I said that.
When is dismissal warranted? And this is, I'd like to talk for just a couple of seconds about the legal standards.
Just like looking at a watch, like
where there's misconduct that's so egregious, deliberate, and intentional, prejudice is to be presumed. That means that the defense is not required to show Ms. Reed suffered any actual prejudice, because dismissal is necessary to prevent the repetition of this type of misconduct. And that comes to us directly from Bridgman versus District Attorney for Suffolk District at 476 Mass 298. It's a 2017 case. Even if the court does not, and this is secondary to that, even if the court does not presume the prejudice and find that these myriad violations were somehow inadvertent or a mistake, the result of some accident or negligence, this case still has to be dismissed under the second scenario and the second prong, because Ms. Reed has suffered actual prejudice by the Commonwealth's violations. We could not cross-examine these witnesses the way they should have been cross-examined at the first trial.
Yeah. So obvious he shouldn't have to explain
discovery
it.
Violations were not an accident. I think we've established that at this point. They weren't a mistake. There were too many people looking at them, strategizing about them, to then say, I didn't realize their import. They were designed specifically, the fact that we weren't provided the evidence was designed specifically to obtain a strategic advantage over the defense and to get a conviction at all costs rather than to pursue the truth. There are obviously additional Brady violations and prejudices that Ms. Reed has suffered. I've detailed those in our moving papers. And I want to incorporate all of those arguments by reference here as well. But relating to the surveillance footage itself, there's no question that the Commonwealth intentionally withheld it, and they've been withholding it since January 29th, 2022. The Commonwealth can't really seriously claim, Your Honor, that 4 or 5 or however many different law enforcement officers were aware of and withheld the surveillance video or the surveillance footage, and who were supposedly specifically instructed by Adam Lally or his team back in April of 2024 to turn everything over, and it was just inadvertently withheld. This was intentional. And the Commonwealth then compounded those violations by Michael Proctor lying on the stand about his knowledge of the video footage and his turning it over to the defense. It was literally a fraud on the jury.
Yes, that's quite literal. Proctor lied.
And now, well after trial, the Commonwealth has been forced to admit that even more exculpatory evidence or surveillance evidence from January 2022 is in their possession. And it was also entirely withheld from the defense throughout this litigation and throughout the first trial. In addition to the presumptive prejudice, Your Honor, there has been actual prejudice. This was, some would say, a close case when it ended. The court recalls that. The jury was hung on some charge or charges, and the evidence suggests that they voted in her favor on others. The court needs to ask itself, what would the jury have done had they had all the evidence to which they were entitled, to which we were entitled? But they didn't. Every one of these videos was in some way compromised, even the videos that we did have. And the compromise always conveniently obscured the truth and obscured Ms. Reed's rights. This is an exculpatory fact that we should have been able to explore during the past 3 years, and certainly we should have been able to explore it at trial, but we did not have the videos. The Commonwealth did, though.
Uh-huh.
And it's the cumulative effect of all these gross and repeated violations that undermines the Commonwealth's argument that this is just about a broken camera. It couldn't be further from the truth. We're to believe that all these cameras just spontaneously became defective at the exact same time. Like I said before, it defies logic. For the Commonwealth to have all this footage for a solid 3 years and hold it back from us the entire time, it makes one question what was going on with that evidence. And I have to say, in terms of lesser remedies, Your Honor, what's interesting is that the exclusion, obviously the exclusionary rule exists.
But I understand that that does not help the defense.
It doesn't help the defense. And I appreciate the court.
You're going to cut them off
finishing my thought on that.
so the world doesn't
It's
know?
the opposite. The only remedy that can prevent this kind of repetition, this kind of misconduct, is dismissal. That's the only remedy available. And that's what the law, and that's what justice demands. As a final thought, if the court, even in the face of all this overwhelming evidence of gross misconduct, declines to dismiss this case at this time, we would urge the court to grant us an evidentiary hearing so that we can make an actual factual record of the myriad of issues brought up here.
You think they want
This
to
will
come in
give
and
the court
testify?
A much better understanding of the facts supporting dismissal, and it'll perfect the record on these critical constitutional issues.
Which we will
With that, I'll
appeal.
submit.
Okay, so thank you. I have a question for you. So go back to the podium, please, because you may need your notes. But Ms. Little, did you find the Proctor testimony?
I did, Your Honor. It's June 12th, 2025, the reporter's transcript at 1-148. And that's from the copy of transcripts with sidebars, just
Okay.
for the court's reference, lines 8 through 12.
Excellent. Thank you, Liza.
I have a question, Mr. Jackson, just about, so you argued obviously the importance of the Lexus arriving at the Canton Police Department. You argued a distinction between a cracked taillight versus a shattered taillight.
Correct.
In your pleadings, and again, you just saw, I want specifics where I can find something. On page 28, you talked at the top line, cracked, not shattered, when it arrived at the conflicted CPD on January 29, 2022. If the taillight was largely intact and only cracked rather than shattered and missing 47 pieces, as Dayton Police Officer Sergeant Barrows testified he observed earlier that day, after the Commonwealth claimed Ms. Reed had struck Mr. O'Keefe, the evidence would establish Ms. Reed's innocence and be case ending for the Commonwealth. The 47 pieces I'm having trouble finding. I just took a
I'm
quick
sorry.
review of
Were you
Sergeant
at the
Barrows'
trial?
testimony yesterday upon being prepared for this. I didn't see it in there. Ms. Little, do you know where that 47 pieces is?
Yeah, the 47 pieces is not related to Sergeant Barrows' testimony.
Well, it sounds it from this, so I'm not to read it this way.
What Sergeant Barrows clearly testified to was that he observed a taillight that was cracked and not broken.
Okay, the 47 pieces, I read that to mean it was from Barrows' testimony.
No, Barrows-
As Dayton Police, Barrows testified. All right, where do I find that 47 pieces?
The
Really?
47 pieces, I can get a.
Did you come? Were you
multiple
at the
transcript
trial?
sets, But those were the photographs the Commonwealth presented at trial, that there were that many pieces found at the crime scene.
It's the number of
Taillight.
pieces that
I'm
were
sorry,
looked into
what?
evidence.
Okay.
Yeah.
Great. Yeah, if you have trial transcript of that, I don't need 47 points, but if there's something that summarizes it, because I took that to read as I see it reading.
No, Sergeant Barrows.
Hey, Brenda. Hi. So nice to meet you. You've put in 2 comments so far that you think that I talk too much and that I should shut up and that I should just let the video play. So, hey, Brenda, take a ticket to Block Island. It's really lovely this time of year. It is so lovely on Block Island. It's a little island in between Long Island, Montauk, and Rhode Island. You can take a ferry there one way. Head on over to Law and Crime and enjoy yourself over there. Don't come into my channel to tell me how to run it. You've only commented twice in your entire life on my channel, and it seems to me that you're looking for a little of attention, so I'd like to give it to you. Hey, Brenda. So nice to meet you. Got to disrupt the whole class? You got to disrupt the whole class in the middle of like some really important stuff? Come on, who does that? Who does that?
Specifically testified about his observations of the taillight earlier that day.
Right.
It was uncontroverted that there were 47 pieces of taillight
Yeah.
recovered at the
That's not clear to me the way this is written, so I'm glad I asked you.
Oh, Because you weren't
All
at the
right,
trial.
So with that, now, Mr. Iannetti, I'm not going to hear from you now about the court officers not being in charge of the jury. I'm going to hear from Mr. Brennan, and then we'll get to you, and hopefully we'll have time. But Mr. Brennan, I have a question for you.
Wait, hopefully we'll have
As
time
I
for what? Hold on. For Alessi? Hold on. Sorry.
All right, so with that, now, Mr. Iannetti, I'm not going to hear from you now about the court officers not being in charge of the jury. I'm going to hear from Mr. Brennan, and then we'll get to you, and hopefully we'll have time. But Mr. Brennan, I have a question for you. As I started with a question for the defense, so I'd like you to explain to the court, please, what efforts the Commonwealth made to comply with the Rule 14 obligation regarding the Sallyport videos, and why the dribs and drabs of the way the discovery came
Yes,
in.
please explain yourself, sir, and go to
It
the
may be
podium.
most helpful if I give the court a history as I've learned it about the production of video in this case.
Okay.
And it will explain in context the production of video.
He can't go off script. He's got to read a script. He can't go off script. He can't work off the cuff. He can't answer. He can't riff. He can't riff. He can't ad lib. He's got to go by what's written on his paper. He's Lally. He's Lally squared.
And will help create the foundation so the court can understand, and perhaps the defense can best understand.
All right, and just like I did with Mr. Jackson, if I need to, I'm going to interrupt you
Of course.
to clarify some of this.
Oh,
So
good. We're
know
going to be
that
fair
that's
today.
That's what I'm focused on.
Goose and
I
gander.
understand clearly.
Cool, cool, cool.
In November of 2024, the defense asked me to see if I could provide a chain of custody regarding the production of video in this case.
Yeah, they did. Hold on. I just want to point out to the members that we have, when we covered the Robert Tellis trial, we made a boss baby emoji, and I am now officially allowing that to be used for Hank Brennan. Go on with your boss baby emoji, because he looks like boss baby too, and he thinks he's the boss baby of this trial, but we're smacking him down. And it's ironic too, isn't it, that Alec Baldwin played the voice of boss baby in the movies, right? And this case should be dismissed just like Alec Baldwin's was. So there's that. I hereby dub the Boss Baby 2, the sequel.
And so I agreed that I would do that and made best efforts to talk to as many witnesses as I could, review the discovery, and speak to the attorneys. Now, when I started sometime in late September, I had found the letter from Chief Rafferty with the production of video in August. The
Hidden in a file?
It was dated in August. So to start from the beginning, the prosecutors in this case did not have knowledge that there was videos from the Sallyport area.
Really?
There was nothing about it that was particularly relevant to them.
Really?
The defense theory did not make it clear to them that
The defense theory has nothing to do with it. Your theory is that John O'Keefe was killed by her car. Okay, so their theory about planting taillight should not make one ducking bit of difference, sir. It was your theory that John O'Keefe was hit by the car. It was your theory that the car was the murder weapon. And how can you get up there with a straight face and say that it wasn't clear that we should keep those videos because the car was in the Sallyport of the conflicted police department? I'm taking that back because my head is going to pop off. I can't even imagine. If Bob Mata if his head is already popped off and it's rolled down the street at this point. Here we go. It's not, we didn't know their theory, so we didn't know it was important to keep the video of the car because wow.
August, the letter or note was dated in August. So to start from the beginning, the prosecutors in this case did not have knowledge that there was videos from the Sallyport area. There was nothing about it that was particularly relevant to them. The defense theory did not make it clear to them that that was important. There was no motion filed by the defense.
At what point in time?
This is leading up to trial.
Ever.
At that point, there had been no request by the defense for video of the Sallyport area.
Wow.
What I learned is that
He doesn't know his obligations as a prosecutor,
Trooper
clearly.
Proctor had requested Sallyport video.
You're going to jail.
from Canton Police Department. And the person who was the custodian of Canton Police video who would download it from the DVR was Sergeant D.G.M. Petro. He made a request shortly after this event on January 29th, 2022. Sergeant D.G.M. Petro downloaded video from the front wall camera, which was later characterized as the blurry camera, and he left it at the front desk. Trooper Buchanan, at the direction of Trooper Proctor, picked up the video and he brought it to Trooper Proctor. Trooper Buchanan did not look at the video at that time. It was given to Trooper Proctor. Trooper Proctor did not provide it to the prosecutors. So Trooper Proctor was aware of the video. The prosecutors were not aware of the video. That video is the same video that Sergeant D.G.M. Petro says that he downloaded the video in 6-hour segments, and that contained the front wall blurry camera inside the Sally Port and camera in front of the police station. That remained with Trooper Proctor for some time. In June, around June of 2023, Trooper Proctor then made a second request from Sergeant D.G.M. Petro.
Even though we already had it?
For different cameras. He wanted cameras, a camera angle of outside the Sallyport area. So when the tow truck dropped the car off, leading into the Sallyport, which is now characterized as the exterior Sallyport video. Again, Trooper Proctor asked Trooper Buchanan to go to the Canton Police Department and pick up a copy of the downloaded video. Trooper Buchanan went to the police department, picked up the CD at the front desk. That CD had a yellow sticky tab on it with Trooper Buchanan's name, and Trooper Buchanan wrote in the case file on that yellow sticky. He brought the CD to Trooper Proctor. Again, Trooper Proctor in June 2023 had a copy of the exterior Sallyport video, but did not provide it to the prosecutors.
Oh,
Both of those.
the only thing that would make this more like the Baldwin case is if they put it in a different file with a different file number.
Those remain dormant. When Trooper Proctor was called to the federal grand jury, essentially he testified or was asked about video and said that he reviewed video.
Essentially, he gave us up. Essentially, he squealed on us. He's a snitch. You know what they say, Your Honor, because, you know, I used to work for the mob, represented Whitey and all, you know what they say. Snitches get stitches. Proctor, he's a snitch. He went in there and he snitched. And now look at what happened. Not our fault. It wasn't me. Shaggy.
This was not evidence that the Commonwealth intended on introducing or had any specific interest in. There was no particular.
Of course, you wouldn't intend to introduce it unless it showed a shattered taillight. Then you would have introduced it, right, sir? Yeah, of course you would have. So you hid it because it didn't help you because it's exculpatory. Let's say that all together, exculpatory.
Discovery request by the defense, and there was no order. But upon reading that grand jury testimony, ADA Lally reports that he then inquired about the video. This is
Inquired of whom?
Trooper Proctor.
Okay.
This is shortly before trial. ADA Lally was given a copy of one of two of those productions. He was given the copy of the front wall video, which also contained video of outside the front of the police station. That was quickly turned over after Attorney Lally received it on April 4th, 2022. So what we know at this point is Trooper Proctor has this original production on April 4th, 2022, shortly after January 29th, 2022. I'm sorry, it was provided April 4th, 2022.
2022 or later?
No.
It was later, right?
was
Because
later.
the
It was-
federal grand jury was later.
Don't help him. Don't help him. Don't give him your help. This is not extra help. He doesn't get to phone a friend, Your Honor. Like you helped Lally during the entire first trial. Mr. Lally, would you like to object, Mr. Lally? Mr. Lally? Madam Court Reporter, do you need a break? Yes, we need a break.
The eve of trial. So it was April 4th, 2024.
Yeah, 2 years later,
So
not
we know this
22.
production on April 4th, 2024 was in the hands of Trooper Proctor in
Can't make this
shortly
up.
after January 29th, 2022. At this point, the prosecution team is still unaware of the June 23 production, which has Trooper Buchanan's name on it, which shows the exterior sally port. As trial began,
Thank you for noticing.
there still was no specific order or request. The chief of police saw something about the trial and
She saw something about the trial?
prior to the
Oh,
trial.
hang on. He's stumbling over his words now because he's got to be careful because he can't throw again Chief of Police Helena Rafferty under the bus. So hang on, because he's gonna walk it back. We also have handcuff emojis for those of you who like to participate as members, and also this leaf blower, the solo cup. She saw something about the trial. Really? This town has been consumed with this trial for the past 3 years. She saw something about the trial. Just happened to be watching TV. She saw Ted Daniel reporting about it on TV. Really?
Saw something about the trial and let me rephrase.
Oh, please.
Prior to the trial, it's reported that Attorney Yannetti was discontent because the video of the front camera sally port was so grainy, intermittent, and not continuous.
Yes, there were pieces missing. It was skipping. There were ghosts coming in and out of the video, and it skipped, and it was inverted, and the timestamp was off, and there were pieces missing. So he was discontent. Oh, what a malcontent that Mr. Yannetti is. How dare he ask for evidence that is actually honest and truthful and has metadata and it can actually be authenticated. How dare he be discontent?
And that's an accurate description of that video. Chief Rafferty, in response to seeing Attorney Yannetti's concerns, then asked Sergeant D.G.M. Petro to see if there was another camera or to produce any other video from the sally port. Sergeant D.G.M. Petro then downloaded.
Who's conflicted off the case because he's Canton PD, but he had not yet retired. So the chief of police at Canton, they're not calling any, the CSI people or the crime scene services people in. Not calling Garino, the forensic tech from MSP. You're calling a Canton PD detective, even though you're conflicted off the case. Got it. This just gets even grosser and grosser as he keeps talking. So go on with your bad self. And you're saying he now downloaded the video from the DVR while the trial is going on? I thought it wasn't on the DVR anymore because it overwrote within 30 days. Hang on, because, Mr. Yannetti was discontent. When did Helena Rafferty become chief of police? Refresh my recollection. Listen, I thought it was off the DVR. I thought it overwrote within 30 days. Here we go.
Yannetti's concerns, then asked Sergeant D.G.M. Petro to see if there was another camera or to produce any other video from the sally port. Sergeant D.G.M. Petro then downloaded video from the DVR, which is the second camera that is inside the sally port, known as the inverted camera, or now characterized as the inverted camera. That was produced April 23rd, 2024, given to ADA Lally, then given to the defense. And so at that point, there are 3 video productions that exist. The first turned over to the defense April 4th, 2024, the second April 23rd, 2024, and the June 23 production of the exterior sally port has still not been turned over. It's in the possession of Trooper Proctor, and the prosecutors do not know about it.
Hey, the Kilo 2311. Thanks so much for the $4 super chats that you spent. Thank you so much for the $4 that you spent to insult me. Enjoy your trip to Block Island in 3, 2, 1. Bye-bye.
After the trial, one of the employees from Norfolk County Colleen Crawford, went to the Sally Port and looked at the DVR system. And when she looked at it, she saw that video still existed on that system. Although there was a 30-day overwrite on that system, the system had a number of backup hard drives. And because of the backup
Oh,
hard
they have
drives,
backups now.
the video existed longer than 30 days. She wrote an extensive report
Mhm.
that was turned over to the defense.
How many lies
and
are in
this
that
is
report?
after trial. The report notes her investigation about all the different videos, and it summarizes everything that she saw in that July 2024 visit. As I mentioned earlier,
Motion to speed him up. All in favor say aye, just so we can catch up with real time. All in favor say aye. He's a slow talker, and he's slow talking because he knows he's going to have to walk it back. If he'd be talking any slower, he'd be going backwards. If it's too fast, let me know, because I aim to please.
in August, Chief Rafferty provided video of the hallways that included some video of Brian Higgins, and she accompanied a letter or a note.
Mm-hmm.
I
LOL.
learned that video was copied during the trial.
Oh.
And it is noted in the sergeant's letter, the chief of police and the sergeant were downloading video, not in response to a motion to compel or produce, but rather because they
For
had
fun?
concerns about accusations that were being made about the department, and they were saving video, in their opinion or from their perspective, to help defend against future false claims against them.
Or the audit? Did it have to do with the audit? Because the auditors were in there looking at all their shit, and they had to get their shit together, and they realized that they have this video. And now after the trial is over, even though it was downloaded during the trial, that's when Helena Rafferty takes a little Post-it note and says, and I quote, what's on my other page? LOL, it records that way. LOL, it wasn't tampered with. Ha ha. They can't get us now. Wow. Yeah, ruh-roh. Tell us more, Spanky. Tell us more, Spanky. Where's Alfalfa? I'm going to speed him up to 1.5.
They downloaded a number of videos that were then turned over in that August 2024 production. When I first learned of that August letter and note, I turned it over to the defense immediately.
It wasn't me, Your Honor.
The
Don't
issue
just blame
came
me.
up regarding the DVR in November, and as we've litigated extensively, so I'll simply summarize it, I invited the defense to come to the Canton Police Department. Given the intermittent or spotty production of video, I tried it best they have an opportunity to look firsthand, although I didn't know if the video would exist, as I said. And then when they came in December, I think it was December 12th, if my memory serves, and learned that there was no longer video stored because it had been overwritten, I then went to the Canton Police Department so that I could have a closer look at the video cameras to see if there was something missing.
I don't know. Hey, how about maybe before you told them they could bring their expert in, you check to see if the stuff was there? How about that? Because that would have been like what a smart person would do. I don't know. This is wild. This is wild. Do you think during the break he called Carrie Morrissey and was like, hey, you got any advice for me? Should I put myself on the stand? What do you think? What should I do? Hey, Carrie Morrissey, you remember she was the prosecutor in the Baldwin case in the Rust trial in New Mexico, put herself on the stand right before Judge Summer tossed that case like the hot potato. And a lot of people thought that Alec Baldwin should have been convicted.
I learned about the videos, and then as a consequence, I spoke to the chief, other officers, and the sergeant unexpectedly. The sergeant told me that he would click and drag copies of video when he would download them from the DVR.
Yeah, the problem with that is it destroys the
Inevitably,
metadata.
We had the litigation about whether the defense was going to download in person or not. And then as I tried to finalize my investigation into the tapes and realizing there was no actual written chain of custody, I wanted best to memorialize it. I had been reviewing all files, data, hard files, but I had not been on the case long enough to review everything. So I asked that the parties of the Commonwealth look through all files, all databases, so that I could help facilitate my review.
Who
At that
found them?
point, I was provided by Trooper Tully the
Tully.
2023 CD with Trooper Defendant's name on it. That is the exterior Sally Port video. And within 24 hours, I provided that to the defense. I then asked both the sergeant.
Wait, you mean Tully, the same guy who set up Aiden Carney with Ken Mello, Kay Peter, and Lindsay Gattani? You mean that Tully? Oh, Wow. Who's going to flip first? Who's flipping first here out of all of these characters? Somebody get over to central casting because we need to start casting for this.
Trooper Dolly and Trooper Mechanic to write reports since there was no chain of custody. I wanted best to give as much information as I could and document the history.
And you know what's so funny about that? You said in open court, should I just create things that don't exist, Your Honor? These chain of custody things don't exist. You want me to create the thing? You want me to just invent them? And then Judge Cannoni looked at Elizabeth Little and said, Ms. Little, do you just want them to just make up stuff that doesn't exist? Is that what you expect them to do? Just create it? And now he's telling you that, yeah, that's exactly what he did. That's exactly what he did because none of these people want to come in and testify. So here, just take our word for it. Just trust us, bro. We're going to make up these chain of custody logs and, trust us, bro.
The video. That, Your Honor, is a summary of everything that I learned, the investigation, and the production of the videos.
Do you know which investigator's file it was found in?
Trooper Proctor's.
Yeah, Proctor is going under the bus, my friends. The bus, the wheels on the bus go round and round.
I will proceed with the
wheels on the bus go round and round, round and round, round and round. And guess who's underneath those bus wheels? Trooper Michael Proctor. Was it worth it? Was it worth it? Skippy, Chip, was it worth it? Chip, Bear, Chip, was it worth it?
The videotape argument since we've launched into it.
Sure.
Now, the defense has made a number of conclusions that there was somehow videotape that was tampered with. There's absolutely no evidence whatsoever, none. It's not even speculation. There's no evidence.
There's no evidence that you didn't. You don't have metadata. Doesn't that absolutely prove the fact that you tampered with it? You don't have metadata. They haven't proven that it was tampered with. You haven't proven that it wasn't. Show us the metadata. Spanky.
Ever tampered with. They say it, but there's none. I have seen none. They have produced absolutely no evidence.
You didn't see the video either. You didn't see the video either. You've seen no evidence of the tampering, so we're just going to trust you, bro. How does he get up there with a straight face? This is like the Little Rascals, so really Spanky is a good nickname for him. This is wild. He's getting back his gusto now. His gusto is coming back, his verve, his riz, as they say. He's trying to get his riz back. My little nephew calls it riz, and I'm like, what the hell's riz? It's like, it's like charisma. He's like 12. Spanky's trying to show us some riz here. But what do you think?
Was altered or tampered. The defense lodges the idea of bad faith, that there was some type of advantage in that this video was withheld from them on purpose. And again, that is a baseless claim. If the government was going to hide video from the defense, they never would have got it. Maybe they would have got something.
They never would have got it?
They would have not got this production.
Oh, okay. We got to slow this down now. If the prosecution was going to hide video from the defense, they never would have got it. We would have just kept it secret the whole entire time. But never fear, because Spanky is here. Are you kidding me?
On purpose. And again, that is a baseless claim. If the government was going to hide video from the defense, they never would have got it. Maybe they would have got something after I came in and looked. They would have not got this production in April 2024.
They did hide it. That's why they
did.
didn't get it before the first trial. What part of that don't you understand? Do we need to slow it down a little bit for you? They did hide it because they've had it since before the first trial. They've had it since the day the car was brought in. So they did hide it.
If the government was looking to hide anything. And so the idea of intentionally withholding or bad faith is just characterization by the defense. The words Brady have meaning. Now, first, Brady needs to be exculpatory, and that's going to be something I think I can demonstrate does not fit this case. And secondly, in order to compel the court to conclude there was some type of remedy that should be issued, they want the court to conclude, like they do, that there was some type of tampering or some type of destruction of evidence. There was none. There was none. Now, Trooper Proctor had this video from June 2023 in his file. And I think the best evidence that this was not intentional is if you review Trooper Proctor's trial testimony.
So do you have a volume? Is it at the same place that Ms. Little gave me?
Well, I have
going to
the same
jail.
volume. They gave you a fragment of his testimony, which is about 3 sentences. But if you actually read a number of pages of his testimony that deals with this video, and it begins on page 133.
Do you have an extra
What
copy
you
for the
will
court?
see, and I won't spend a half hour reading it, but what you will see is that Trooper Proctor was aware of the grainy video, which was the video that was provided right after January 29, 2022. He was unaware of the inverted video until it was produced right before trial or right during trial by the Canton police. And you can also see that he in no way was hiding the June 2023 video, because you can see the confusion between all the parties at trial.
No,
Attorney
no.
Jackson is asking Trooper Proctor about video, and Trooper Proctor is explaining there is a Sallyport video, and also there's an exterior video outside the Sallyport. And it is clear that Attorney Jackson does not have that June 23 exterior Sallyport video because he's very confused in the questioning of Trooper Proctor. And Trooper Proctor continually tries to explain that there is both the Sallyport and there's the exterior video.
Yeah.
So clearly Trooper
Proctor was was confused. It's a land of confusion, Spanky. Welcome, welcome. So glad to have you. Not really, but it's a land of confusion. It's a magical mystery Sallyport, and everyone's confused. They're living in a land of confusion. They're lying. They wanted to pin it on the girl. He decided he was going to pin it on the girl within 16 hours, sir. You might have wanted to watch the first trial.
Proctor was aware of the exterior Sallyport video, but it will be clear from the reading of his cross-examination that there was no intentional withholding. He should have, since it was in his possession, whether it was relevant to the government's case or not, he should have provided it to the prosecutor, and then it would have been properly provided. But it was his oversight. There was nothing intentional or advantageous about it because he struggled to try to explain to Attorney Jackson. And so it's also notable that Attorney Lally never has an opportunity to ask more details about those. Well, he has the opportunity, but he doesn't ask more details.
Yeah, that's his fault.
About that misunderstanding because he's wholly unaware that it even exists.
Don't speak for him.
It's a confusing moment, but it clarifies that there's nothing intentional whatsoever about this course.
Thank you, Kevin.
And so it's important
Kevin Higgins.
that although the defense now suggests there's something exculpatory about it or something about it that's important, it is important to note that the defense never filed a motion for the production of the Canton Police Department video.
Doesn't matter.
It is not incumbent or assumed that the Commonwealth is going to obtain every video from every part of a town during an incident. It's not assumed that they will do that. The Commonwealth seeks evidence that they think is exculpatory. They seek evidence that they think is...
Really, then why did Detective DG Ampietro download every single minute of video that the murder weapon was in their possession if they didn't think it was important? How can he's talking out of both sides of his mouth here. Isn't he? Are we being gaslit some more?
Relevant material, and when they receive it, they are supposed to provide it. There are many cases where video from a police department is never provided to the defendant unless they ask. Or many cases where it may be a video of the booking, but...
You got any case law on that? You got any case law? You're just going to spew forth from your mouth. He needs like that giant bucket of the guy that was vomiting in the Monty Python. What video was that where he explodes at the table because he ate so much and he's just like got a vomit bucket all over the place? Really?
Not the hallways, not the bathrooms, not the back parking lot. Put in context that the defense theory was a evolving theory throughout this case to this day. The defense theory was that it was some third-party culprit, unidentified, who committed this act that led to the death of John O'Keefe.
I'm going to say it again for a little bit louder for those in the back. Your theory was that John O'Keefe was killed by Karen Reed intentionally backing her car up into him and leaving him to die in the cold. I don't give a duck what the defense theory is. That's your theory. Don't you think that you'd want to preserve the evidence to prove your own case? What is he talking about?
In fact, if you see earlier interviews, the defense position publicly was, you know exactly who did it, intimating that there was a specific person. Now that recently has changed. If we see the recent interview 2 weeks ago on Fox 25.
Oh,
the quick
deflect,
answer was,
deflect,
we have
deflect.
no idea who did it. We don't have to know.
That's true.
And so this fluid position is not noticed to put the Commonwealth on notice. They're supposed to chase down every potential idea or creation that the defense has.
Welcome, Ozzy.
It's important to look at the motion that has been presented to your honor on behalf of the defense, where they claim that they moved to preserve video evidence. And when you look at that motion,
Got any case law on that?
the best it says is that they moved to compel physical evidence. That does not put the Commonwealth on notice.
Did Jennifer McCabe prep you for your argument? Did she prep you to say, oh, they never asked for it, so therefore I didn't answer that question. I didn't have to preserve it because they never specifically asked for it. You have an affirmative duty as a prosecutor to preserve all evidence related to this case. It was the murder weapon according to you, and therefore, if you're really that stupid, I'm not going to explain it to you.
Of video evidence at the Canton Police Department.
Was this the Stoughton District Court motion?
It is.
Okay.
And I know that the Superior Court did not adopt it. However, I think the Commonwealth being on notice is the point. And even if it's in district court, I think it's the Commonwealth's responsibility.
I agree with that.
Pull up the disciplinary rules for
And so,
prosecutors.
Attorney Yannetti, and I've mentioned this before, was very prolific in his pretrial discovery motions, very meticulous. And when you look at his meticulousness, if there was a need or a desire for video, he certainly would have asked for it. He didn't.
Because they didn't know it existed,
fact-
because you never turned it over until the trial. How do you request something that doesn't exist? That's why there are catch-all provisions. All evidence related to this crime, you are required to preserve. You can't specifically ask for something that you don't know exists because you didn't turn it over until trial, when you actually did know that it exists, because Proctor knew, as did DG and Pietro, who downloaded all of that video from the entire time that car was in the Sallyport. How can you get up there with a straight face as an officer of the court and make this argument? I don't even know what to say anymore.
Look at the perspective of Attorney Yannetti, you don't have to look much further than his characterizations of how he sees the difference between the crime scene in the Canton Police Department. I've attached, for your honor and for the defense, exhibit number 4, trial testimony of Trooper Nicholas Garino. And when he cross-examines Nicholas Garino, he is pretty clear that there is a difference between the Canton Police Department and the crime scene. He cites on page 75, but you'd agree with me, the Canton Police Department wasn't the crime scene, correct? And Trooper Garino says, I never said crime scene in my report, I wrote scene. And
Yeah.
Mr. Attorney Yannetti iterates, okay, well, Canton Police Department was not the scene of any crime, was it? So the defense is hard pressed now at this moment where they are trying to create prejudice that doesn't exist, to try to convert a motion that they filed with very specific intentions for physical evidence to now suggest that that includes Canton Police Department because the Canton Police Department is somehow the crime scene. It doesn't convert.
I mean, I could say it again, but I think I've said it all.
In argument, Attorney Jackson characterizes not only Trooper Proctor's testimony, and I encourage the court to look at that because when you read it in context, I think it clearly screams that Trooper Proctor is hiding nothing whatsoever. But if you look at Trooper Buchanan's testimony, on June 6, 2024, if you start at page 103, Attorney Jackson, and to paraphrase, I'm not quoting him verbatim, suggests that there's something about Trooper Buchanan that is lying about his position or about what he saw, or that Trooper Buchanan admittedly saw the inverted video. Not the case. Trooper Buchanan reported that he did not see the inverted video until after Canton produced it, because how would he see it before Canton produced it? And that was in his preparation in May. And he did not say that he sat down with ADA Lally and watched the inverted video. He was asked, were you shown any of the videos that you see in anticipation of your testimony? Now remember, there's not just Canton Police Department video at that point. There is video from Ring, Town Hall, a number of different places. And he said, not during the first meeting. I did review video during the second time. Question, okay. And that video that you did see the second time, was that the interior video of the Sallyport that we saw yesterday, correct? He says, Trooper Buchanan, I'm just trying to remember exactly what video I saw. I had reviewed videos outside of our meetings. That is what he put in his report about reviewing in May, not with ADA Lally. So I don't remember exactly what video Mr. Lally showed me. That wasn't the characterization that was provided in argument. This is very different. Question, but you do recall seeing the video that you saw yesterday, the sort of clear one that has the crime scene tape being put up and all that. You've seen that one before. That's the inverted video. The answer, yes. I'm on page 104. And that was with Mr. Lally, correct? Trooper Buchanan, clearly. That is not correct, because I do not recall when I saw that video or what video I saw with Mr. Lally. That sworn testimony is not only in stark contrast with the characterization that was offered by the defense, but it directly contradicts the conclusion they ask you to reach, that Trooper Buchanan watched this video with ADA Lally in preparation for trial. Therefore, it is a lie that the Canton Police Department provided the inverted video sometime earlier. That's sworn testimony. Now, again, trying to assert some type of relevance, the defense suggests there is something in the federal materials that would show relevance, because Mr. Higgins said in the federal materials that he does not believe he made any phone calls. If you were to look at that testimony in the federal materials, you would see there was an enormous amount of conversation about the period in which he was sleeping. And there were dialed calls between him and Mr. Albert.
Butt
So
dials,
you have
yeah.
to look
We
at
remember.
it in context rather than say it's an unequivocal denial and there's an aha moment. There is no aha moment. So
Do you have the grand jury cite? I think I might have got it from Ms. Little earlier, but the grand jury testimony of Brian Higgins, I have it. It's just easier if you have a cite to that.
I have a tab, but I don't perhaps Attorney
I'm sure
McLaughlin
Ms.
does.
McLaughlin can get it.
I'll
from-
provide it momentarily.
All right, thank you.
So what really arises from the subterfuge is that the defense did not ask for video. There was video provided when the prosecutors learned about it. There was video that was in the hands of Trooper Proctor that should have been provided to the prosecutor that wasn't. There was nothing done to alter or taint the video. There was nothing destructive about it. There was no tactical advantage. There was no benefit to the government. And clearly from Trooper Proctor's testimony, there was no effort whatsoever to hide it. It should have been managed better, no doubt. But there was nothing about it that was prejudicial. There was nothing about it that showed tampering or altering. And so ultimately, the import of the defense's argument is that this evidence, this information is exculpatory. It's exculpatory because what they claim is that it would show that Ms. Reed.
Oh, here he comes. He's got a smoking gun because he went, he got his laptop and this is it. This is going to be his big smoking gun. So we got to put it at real time because, you know, he likes to speed up when he thinks he's being truthful. Because you know what they did? They clarified the video. So they actually modified it again.
Evidence, this information is exculpatory.
Come back
It's
to the screen.
exculpatory because what they claim is that it would show that Miss Reed's taillight was cracked, not missing a piece. Now, first thing we look at is Nick Barros's testimony. And if you have an opportunity to look at his testimony on page 12, line 1, the defendant told you part of the story. I saw there was some damage to the rear taillight to my best ability and recollection, that taillight was not completely damaged. It was cracked, but they forgot the next part. And there, pause, a piece missing, but not completely damaged. That's exactly how we see Miss Reed's car later on after it is at Canton. The entire taillight is not missing. There is a piece
dude, are you serious?
missing.
Are you serious?
That piece, where the fractions of it are found at 34 Fairview, right near Mr. O'Keefe's body. The same parts of the taillight fragments that are found in the sleeve of his shirt. And so it's not simply.
There were no taillight pieces found in the sleeve of his shirt. Again, he is getting up there and lying to the world. There were scrapings that were all scraped into a whole envelope together. The taillight was in the same envelope with the cloth, right? The pieces that were found in the sleeve of his shirt. This is going to be the soundbite for tonight. They're not going to report on all the bombs that Alan Jackson dropped. Listen to this.
O'Keefe's body at 34. That piece, where the fractions of it are found at 34 Fairview, right near Mr. O'Keefe's body. The same parts of the taillight fragments that are found in the sleeve of his shirt. And so it's not simply cracked. Even the witness they tried to lean on, Mr. Barrows, says more. And so if that taillight is not just cracked, that taillight is missing, then there is nothing exculpatory whatsoever about the Canton video. It's a red herring, because there can be no plant of fractured taillight if it's already gone before it gets to Canton.
But you have no evidence of that because nobody took a duck and picture. And how about 47 pieces? Officer Barrow says there was a little piece missing. It was cracked, not totally damaged, and now it's shattered when you finally do decide to take pictures of it. Wow. Wow.
Canton. There can't be. And so when looking at the evidence, it is unequivocally clear that piece of the taillight is missing well before that car ever gets to Canton.
Bullshit.
And so we can
Where's that
quibble
evidence?
And we can dispute and we can go back and forth all day, but the best way is to just show you.
Right. Objection.
And so when we look at the evidence, let's start first with the claim that the Sallyport videos were tampered with. Canton went back before January 29, 2022, and they took samples of the video to see if it was in the same condition, inverted.
What?
For the back wall.
What?
And fuzzy for the front wall. And we have those, and we've turned those over to the defense, and I just want Your Honor to see.
I thought it overwrites within 30 days. How do you all of a sudden have those videos now after the first trial and right as the second trial is about to begin? Cindy's like, can I smoke what he's smoking? I don't know why I take this case so personally. I really don't, but I really do. I'm an empath, I guess. Can I smoke what he's smoking? What does he even want? Has he even watched the end? I have memory issues, and even I remember there were no pieces on his shirt. Cindy, they have been spinning this yarn, trying to make it into a sweater of a story since this case started. I'm so outraged.
A small clip of that to show this condition, these conditions existed before this case was even a moment. So with the court's permission, I'm going to ask to put up exhibit number 2.
Object.
Exhibit number 2.
There's no metadata.
Shows the inverted camera from January 1st, 2022. Now this is
Hold on. Oh, wait. It paused itself. I'm going to have to make this larger so you can see it and take myself off.
28 days before Ms. Reed's Lexus hits the Sally.
Where did this come from?
Now you can see, if you stop that, please. Thank you very much. On that wall, on that garage wall, there's a 4. It is backwards. This Sallyport video was not doctored by Trooper Proctor. It wasn't altered by.
Wait, the font on the bottom of this one is yellow. See how the police, the vintage car, it's written backwards. I mean, it says it's from 1/1/22. Was the font on the other video yellow or blue? And all of a sudden, here they look how clear it is, clear as day.
By Trooper Buchanan. It was in existence well before Miss Reed's car showed up to that Sally Port. Similarly, front wall camera, could you please put on Exhibit 3? Exhibit 3 is from January 28, 2022, a day before Miss Reed's vehicle.
Where did this video come from?
To the Sally Port, and you can see the quality. It wasn't distorted on purpose.
Why is your
Wasn't
timestamp at the top of the video now? Why is your timestamp at the top of the video instead of at the bottom of the video? I can't, it's dark. It purports to be from January 28th of 2022 at 12:01 a.m.
Manipulation by the state police. This is the way the camera worked in Canton. Thank you very much. And so the idea of tampering, we can claim it, we can assert it without fact, but we can prove it did not happen.
How? Where's the metadata? Well, I hope Jack gets up and
now. What we know is that
spanks him some more.
taillight was not tampered with because it was gone hours before police even touched Miss Reed's vehicle. At 5:08 a.m., she left Meadows Road.
No,
That's
it's one.
John O'Keefe's home.
It's not Meadows Road.
And when she left at 5:08 a.m., that taillight part was already missing. If we look at Exhibit 6, please. This is from the Ring video of John O'Keefe's home. This evidence directly contradicts the idea that the Sally Port video is relevant to show any break or planting of evidence. As Miss Reed nudges into Mr. O'Keefe's car, she will pull forward and we'll stop the video in 2 spots so you can get a clear look.
Yeah, we saw the wheel move.
Of that rear tail light missing.
No, it's not clear.
Forward, please. Thank you. And then ahead one more. You can see the white light shine.
That's the way that car is.
You can see it clearly missing. You can't plant something that's already gone. And the reason why you see white, it is a red taillight cover, and when the red is missing or gone, as it is in this case, the white bulb still shines, and that's why it shines white.
No, that's not. No.
The defense position is also contradicted by the ARCA witnesses. If we look at Dr. Wolf's testimony, day 31 of trial.
You see white on both sides,
Exhibit 10
dipshit.
in our package. Page 36. ADA Lally asks the good doctor, now doctor, in the course of your analysis or review of materials here, were you ever provided with a video of the defendant backing out a garage and making contact with Mr. O'Keefe's vehicle in his driveway at about 5:07 in the morning on January 29th? He says, I'm not aware of that. And then if we move to page 124, line 1. Now, line 2. Now, as far as you're aware from your review and your testing and everything that you did in this case, if a collision occurred at a lower speed, say 1, 2, anywhere from 0 to 5 miles an hour, would that create the damage to the taillight that you observed in this particular case? And Dr. Wolf says, at that speed, no. We provided notice of our own expert. And there's one thing, many things, but one critical thing the experts will all agree on. That nudging did not cause the damage to that taillight.
You're right. It cracked it.
The defense position is also contradicted by dash cam footage. Sadly, an officer went to the O'Keefe home to check on his niece and nephew on that tragic day. And when he did, he had a dash cam video further reinforcing that that taillight is missing well before that vehicle makes it to the Sally Port area. We could play Exhibit 7, which is the dash cam footage showing
This is some of the
Mr. O'Keefe's
finest
car in his
gaslighting
driveway at
you may have ever
8:22
seen.
a.m. if you could close up for the court, please.
Hmm.
If you compare the right side to the left side, although covered in.
Oh my God,
impacted
did you
by
see what just
snow,
came up on the screen? It said, edit your images using AI. Watch this. Aussie, are you watching this? Hold on. I'm going to full screen this for you because when they put this up on the screen, there was a little bubble that popped up right here and it says, edit your images using AI. Perfect your images or transform them into something brand new. Learn more. Are you guys seeing this? Are you seeing this? That is on the laptop that is being used to put up these videos for the Commonwealth to prove that this video is authentic and not doctored. They've got this program right here on their laptop. Video Jesus, are you here? Wow. Let's just take it back a second because, wow, they realized that mistake. Oop, there it is. Edit your images using AI. Perfect your images or transform them into something brand new. Learn more, click here. And we'll fix this right up for you with AI. There's no metadata. You can't prove it's real. Please, I hope someone in the courtroom is listening to me. I doubt they are because we're a little behind.
If you compare the right side to the left side, although covered and impacted by snow, if you could more close up, please, you can see that taillight, just like the detective from Dayton said, just like the 508 ring video shows.
Who did the AI manipulation?
Is missing.
Who did
There's
it?
no plan.
It's right there. It's right
The
there.
defense's position is also contradicted by the alarm.com video that we received pursuant to Rule 17. There are two videos, 8 and 9. If we could play Exhibit 8, please. This is the defendant's car arriving in Dayton in the driveway.
Yeah, it's real snowy.
The defendant on the passenger side, and you can see them walk to the back of the car near the right taillight and stop. And if the question is, what are they stopping?
Is this your smoking gun?
You can play video 9.
No, wait a second. Let's let that play. What if they needed to get something out of the fucking trunk? What if they were getting something out of the trunk? How about that? Did you cut off part of that video so we couldn't see that maybe they went around to the back to get something out of the trunk? No, it just ends right there, and that is his big smoking gun. Here you go. Looks to me like she's walking around to get something out of the trunk, but you know.
Walk to the back of the car near the right taillight and stop. And if the question is, what are they stopping for? We can play video 9. And this is when the car is being put on the tow truck before it makes its canton.
They just cut the court feed?
Like 508,
oh, I don't know. We didn't get up to that part yet.
Driveway of Meadows, John O'Keefe's home, you will see that right taillight shine white, showing the missing taillight cover.
Did you use your AI program on this video as well?
If you have an opportunity to stop the video at the important points, please do so.
The important point where you
lower it?
Did you use the AI? Yeah, no, that really doesn't show anything, sir. My brother.
Can you zoom in on it?
No, can't see it.
Your Honor, I would encourage the parties to look at it on the computer. The clarity is much better.
Everyone's seen it before.
It's very clear.
No.
The light in this video.
No,
I
it's
cannot
not.
see it clearly on the screen.
So will you give me a flash drive of all of these exhibits?
Can't see it.
Oh, there we go.
Okay.
If you look at it on a small screen, see right there?
I do see it.
Yeah. And then you'll
No,
see
you
it
can't
again.
see it. That's the way the taillight is.
So the alarm.com video contradicts the defendant's position that there is anything exculpatory about these Sallyport videos. In fact, this whole idea of third party or plant doesn't come to town until 9
It
months
shows
after
nothing.
Ms.
Shows
Reed is
nothing.
indicted. Perhaps the best evidence.
Now you're concerned
contradicts
about the
the
best evidence rule because the best evidence rule requires authentication and metadata, which you don't have or anything.
Position that there's any relevance to the Sallyport video, that there's any type of plant by anybody, is from the defendant herself. Ms. Reed spoke to Gretchen Voss on June 20th, 2023.
Oh, here we go. Gretchen Voss.
In that testimony, or in that interview, she said, when my car was seized, there was a few small pieces of taillight missing that I had picked out at John's at 5:45 before we drove over to Fairview. I'm showing Jen and Kerry, look what I just did to my light. And I'm worried that there's gonna be some kind of electric short circuit. There's like the bulb is showing and some of the red plastic is missing. So I picked pieces out of the light housing that kind of collapsed within the light and dropped them in John's driveway. And so I say to the court,
She said, she told Gretchen Voss this is what you got from her off the record interview or her video recording. I can't wait to see what Alan Jackson says about this. Gretchen Voss was the reporter for Boston Magazine that she did a couple of interviews with, or she met with a couple of times. Who wrote an article. Why didn't she put that in her article? This must have been in like the off the record notes that they were given.
the production should have been sooner. It should have been cleaner. This should have been
but it's not exculpatory
log or an entry. The failure to provide was inadvertent. It was unfortunate. It shouldn't happen, but it's not Brady. Yes. It's not exculpatory. It's not intentional. It's not tampered with. It was inadvertent and inconsequential because the evidence is overwhelming that that light is missing before the car makes it to the foot of the Sally Port, so there can be no claim. That is my argument regarding the Rule 14 issue.
and none of
I
it is
would
in
like
writing,
to
by the way.
have time to speak about the claim of jury tampering. I understand the temperament of the court.
Temperament of the court, you mean she's a bitch?
But it is a claim that was lodged that has collateral consequence. And I think it's important for me to be able to address it. May I?
Yes.
Yes.
The claim of jury tampering is probably one of the most serious claims that one can make because it's not simply an attack on a case. It questions the fabric of our entire judicial system. If a good juror comes to court and believes there is no integrity in the court or in the judicial system,
We're watching it right now in real time.
it is impossible for a fair-minded juror to even consider evidence because they do not trust the system to begin with. And if a government actor or a trooper or a police officer tampered with a jury, that would be one of the biggest, most abhorrent transgressions that could happen because of the collateral consequence of tampering with the jury. It would take away the community's belief in our system. On the other hand, if there is a claim of jury tampering and it's baseless and there is no evidence, it is not only a direct attack on the judicial system, it would seem to be an effort to try to undermine the authority of the system in court before a trial to impede the ability to have a fair trial. It is an extraordinary claim. And it's notable, the defense motion dismiss. It's not just a motion dismiss. It's a motion to dismiss for extraordinary government misconduct. So when you make an extraordinary claim about jury tampering, there should be extraordinary evidence. There isn't even ordinary evidence.
How about when you made a motion to exclude Richard Green's debunked opinions? How about that? Pot, meat, kettle.
There is no evidence of jury tampering in this case. Now, I don't want to belabor this, but it's important.
That's why we need a
because
hearing.
of the consequence of what happens when a claim like this is lodged. There is damage. And why I'd rather sit down, as I said before, a lie unchecked becomes the truth. And so how does one propagate a claim of jury tampering when there's no evidence? Well, first you need to plant the seed of corruption. And all you have to do is whisper it and hope the poison goes out there and is resonating in the potential community. And so what happens in this case? The defense finds a willing partner who covets an opportunity to meet with the defendant. They find a time, like after the Super Bowl, so there's this national exposure, and they just seep the information. They just seep it into the public and let it resonate. There can be no retort. The government can't respond.
Like your lies that have
No
become the
facts,
truth?
no evidence. Just saturate the public. Now it's important to see or hear or read what is said, because this really is the acorn that is being planted that cannot be rebutted. And it's not insignificant that this same information before this interview is being disseminated by Mr. Kearney. This idea that there was tampering by Lieutenant Fanning.
Oh, you want to
Not-
bring Aiden Carney into it? His name's Carney. Well, you don't even know how to pronounce Alessi, but now you're bringing Aiden Carney into it. Okay, cool.
Coincidence. And so during this interview that the defendant and the attorney have, the question's asked, I don't know why it's asked, but it's asked. There have been sort of these unsubstantiated claims in the atmosphere that there might have been some funny business with the jurors who were dismissed. Really? And Mr. Jackson says, right. The question, is this a real concern that you have? Is this something that you were looking at, or have you just dismissed it as a rumor? Answer, I never just dismissed that as rumor. Something like that, it's too convenient for the prosecution for us to just dismiss out of hand. Do I have any evidence, specific evidence that there was jury tampering? I don't have any specific evidence of it. And yet we have a motion filed 2 weeks later. Do I think there are questions that should be asked? Do I think that there are questions that have been raised about the way the jurors were dismissed and who was dismissed very specifically? And then it continues on page 13 of the transcript. Question, one of the state troopers who was involved with the Norfolk DA's office and on the periphery of the investigation was also responsible for the jury? Not sure where these questions come from. Answer, right. He wasn't that far on the periphery of the investigation. He was involved in the investigation. He was direct supervisor over the individuals that were testifying and over and about whom we had leveled some very, very serious claims and ended up proving those claims during the course of direct and cross-examination in the presentation of our case. That person, that supervisor, we found out well into trial. As a matter of fact, at the end of the trial, we found out is the very person who was governing the jurors. That's a question that should be raised. That is an issue that should be teased out. Should never, ever happen. That is the very definition of a conflict of interest.
That's not Ted Daniel in red. That is Matt from Core TV. Just to clear up the confusion in the chat.
Is that standard in Massachusetts for just the DA's office to assign whoever they want to be sort of, supervisor of the jury? Yeah. Is it standard in Massachusetts? I hope not. Never seen that in my life. But if I had a nickel for every time I said I've never seen this type in my life as it pertains to the Massachusetts justice system.
We all
the
feel that
criminal
way.
Justice system, I'd have a lot of nickels.
Somebody changed their username to Alan Jackson's
I didn't
Nichols.
see that interview. I don't have the transcript. I'd like a copy of that transcript.
Your Honor, I understand. I may be mistaken. We produced all of the exhibits to the court, and you should have a transcript. If not, I will get it to you immediately.
Okay.
He didn't put anything in writing either. Shocked.
Okay. So after step one, finding a vehicle to plant the seed, and they did that very effectively. The next step is they have to identify our target. Who are they going to blame? Who's going to be the villain?
I know I'm behind. I'm going to speed it up because we're going to lose this feed and we have to switch feeds.
Anybody that gets in the way. It could be a soccer mom. It could be a police officer. It could be a good Samaritan.
Soccer mom.
Anybody that crosses the path is a target. And now they decided they were going to identify Lieutenant Fanning. Lieutenant Fanning is one of the most conscientious, dedicated, admired state police officers in Massachusetts.
I don't think he's so admired for clearing Matthew Farwell of murdering Sandra Birchmore. Really? He's conscientious? Go on with your bad self. We know better.
After having his name attempted to be sullied all over social media,
Besmirched.
attacking his integrity and his name, I can dare say that Lieutenant Fanning is in a different position than many. His integrity is so reputable, none of that will break him or his reputation.
He's the one that cleared Farwell,
When you
right?
look at the motion filed
Does he not
by
know?
the defense in this case, and they found their target in Lieutenant Fanning. You look at this motion, page 15. It's important when they made this public pleading, getting back to my request, Your Honor, the other day. You look at the bottom of page 15. It talks about Lieutenant Fanning and tries to align him or associate him with Trooper Proctor because Trooper Proctor's text message was on a chain that included Lieutenant Fanning. Lieutenant Fanning did not reprimand or otherwise correct his subordinates' disgusting and inappropriate behavior. As a result, he was investigated by the Office of Professional Integrity and Accountability for allegations of inappropriate correspondence between department members. True. But then they leave off the punchline. They put this in a public document. They tried to smear him.
That is a punchline.
Degrade, demean, dehumanize. But what they leave out is that after this thorough investigation by the Office of Professional Accountability, where they took strong measures, very strong measures when they found something that they were not in agreement with, they concluded that these complaints were not sustained.
So we were all aware of that. I received verification of that through the pleadings council.
Yeah.
Was all aware of that. I just need the date. When was he cleared? When was that made public?
He was on vacation.
Was it prior to this? Was it prior to the motion being filed?
Yes, it was last year, last fall. I can find the date right now.
Okay.
He was clear because he says he was on vacation and he didn't get those messages from
Lieutenant
Proctor
Fanning
looking
is
about
not in a
Proctor
unique
looking
position.
for nudes. So, they cleared him because, internal affairs.
If I may, Your Honor, sorry. It was July 17th, 2024.
Oh, look at Laura
We are similarly
McLaughlin.
situated
After the
to
trial
many
was
first
over.
responders and witnesses in this case.
We're a little
And
behind,
then,
so it's
without
there
any basis,
for you.
The defense then distorts that Lieutenant Fanning was in charge of juror security. He had control of the jury, and he had access to the jury. Think about what those statements say to our community. We're going to pile in here in less than a month to try to give a fair trial to both sides. Think about what those words mean.
Yeah. No fair trial for the Commonwealth, everyone.
After selecting their target and trying to dehumanize him and degrade him, they then try to create an illusion of this grandiose havoc that is running amok. Trying to get the community to think Trooper Fanning controlled, had access, and tampered with the jury. Think about that concept. Not only is it an attack on Lieutenant Fanning, it is an attack on the integrity of the trial court. I've walked a lot of hallways in the trial courts over the past 30 years. And the heartbeat of trial courts is the court officers who take their duty so seriously. They help, they assist, they guide, and they have solemn pledges. They are charged with the responsibility of the jury. To suggest this is to suggest that the hardworking men and women in our trial court system who come here every day for everybody else's benefit, it is to suggest that they would cede their authority to the state police and abscond from their duty and responsibility to protect that jury with no basis whatsoever. That is the concept that they are promoting in this motion. The trial court personnel throughout the state are steadfast and dedicated. I've tried a lot of cases, and I think most of the lawyers in here have. It is without a doubt in Massachusetts that these dutiful men and women of the trial court protect and are sworn at the end of every case in jury instructions to protect the jury. And these trial court employees, especially here in Dedham, some of the finest, would never abscond that duty. And yet it is now in the public domain, this suggestion.
He doesn't want that guy by the door kicking the shit out of him after this is over. So he's trying to, he's trying to warm up. He's trying to keep them all warm, the court officers. What do you think they think of him?
The only way that you dispel innuendo, suggestiveness, unsupported claims, and the poison that can seep into the community, the only way you can stop that is with fact. So I'm going to list a few facts.
Oh, lay some facts on us.
Lieutenant Fanning was not in charge of juror security. Fact. Lieutenant Fanning did not have control of the jury. Fact.
Says who? You didn't swear to any of this. It's not in any papers. It's not in any affidavit. You also said fact. You didn't know there was a camera in the Sallyport and you didn't know about the Sallyport videos. We can't believe any of your facts.
Lieutenant Fanning did not access the jury. Fact. Lieutenant Fanning was part of a multi-agency cooperative effort to ensure the safety of the public and court participants, which required numerous local police officers and state police because of the bedlam that was created outside.
The bedlam! The bedlam!
Fact. Lieutenant Fanning never, ever, ever met with...
Because of all the Free Karen Reed supporters who are outside this courthouse who are outraged. the bedlam that they created. Imagine people who don't even know Karen Reed coming together to stand up for truth and justice, who see the evil persecution that's going on here. And that's bedlam. And he points his finger in the air. Wait, let's watch that again. And the closed captions even capitalized the B for bedlam.
Police, because of the bedlam that was created outside. Fact, Lieutenant Fanning never, ever, ever met with or interacted with any juror. Fact, at all times, Lieutenant Fanning worked from a remote location.
Did he follow them?
Jointly managing operations for the safety of the public. Never setting foot on this property when the jury was here. Never meeting a juror, never looking at a juror, never being seen by a juror.
Well, you don't have the facts of the law. Pound the table, Hank.
Fact, no evidence any trial court personnel ever ceded their obligations and duty and handed them off to Lieutenant Fanning. Fact, Lieutenant Fanning heard numerous rumors from various sources about a juror who expressed potential bias. Fact, Trooper Fanning never investigated, approached, or inquired. He heard the information and provided it to the trial court as is responsible, dutiful, and proper. And I'll repeat one more time, Lieutenant Fanning never, ever, ever interacted, controlled, or met with any juror. Your Honor, these claims in the motion to dismiss have a theme. Different issues, same theme, same pattern, same effort. Your Honor should dismiss it outright, and we should move to trial. Thank you.
All right, we have to switch feeds because apparently the court TV feed, thank you so much to the viewer who told me that, the court TV feed cuts out. So we got to go to Boston 10 and flip it over as we watch Mr. Jackson get up to give him a bit more of a spanking. Here we go. Oh, I think he's going to be fired up.
We're going to address in reverse order some of the statements made by Mr. Brennan. And I want to talk first about this issue of.
Oh, he's eerily calm. It's freaking me out a bit. Hold on. I got to move the
interference.
All right, everybody got your popcorn? Got your drinks? Got your snacks? He's eerily calm. It's unlike him. Hold on. He's mad. Maybe he's mad, and this is his way of being mad.
And I want to talk first about this issue of juror interference, which is what we called it. These words matter. We've claimed that there's interference. He indicates that that would be an abhorrent transgression if there were interference with a juror or a jury. We agree. It would be an abhorrent transgression. The information that we have in front of us is not the information that Mr. Brennan just recited, which is interesting. I'll get to the facts. He very dramatically stated in just a second. Because this is a fact-based inquiry, one that we asked for standing right over there at sidebar and didn't get. But Mr. Brennan, with no support to back it up, and I'm going to ask a couple of pointed questions about that, recites these facts after facts after facts that he claimed absolved the Commonwealth of any transgression as it pertains to the jurors. And when I say Commonwealth, I'm talking about the Massachusetts State Police. Very clearly, in a clever, almost too cute by half argument, Mr. Brennan talks about the good court officers populating this courtroom and this courthouse, about whom we have made no allegation, no claim, nothing. We have nothing but the highest respect and regard for the men and women who wear that uniform and perform these duties. None, zero. And he knows that. But in an effort to create an enemy where there isn't one.
That's right.
He acts like we've insulted the court officers.
That's
We
right.
haven't.
Great
He
question.
also said that Lieutenant Fanning stood up here and gave basically a CV, a resume for him, and said, the greatest guy on the face of the earth. I don't know Lieutenant Fanning. I don't know if he knows Lieutenant Fanning. Not really the point. It's in the personality contest. He said that we identified somebody with an unassailable reputation. We identified him. We didn't identify anybody. We were standing up at sidebar, fat, dumb, and happy, not knowing what was going to happen when somebody else identified him.
Fat, dumb, and happy has
Wasn't
entered the
us.
chat. Fat, dumb, and
And
happy.
by the way, everything that we filed concerning this was under seal. We didn't disclose anything in any court document.
He
It
did.
wasn't a public document, it was under seal.
That's right. They never mentioned Fanning's name in their papers, never. And then Hank did, and we pointed that out.
Mr. Brennan then states that he was also a subject, this person with this unassailed career, was the subject of an IA investigation for his conduct on this case. It's not even about something tangential.
Right.
It's about his conduct on this case, his supervisory role as it pertains to Michael Proctor and his, and I'll repeat it, disgusting conduct as it relates to my client and his text messages, etc. When he was asked about those text messages, his claim was, I was on vacation and I didn't read them. And ultimately, the Massachusetts State Police investigation cleared the Massachusetts State Police officer. We've seen that happen before.
Yep.
The question, or questions, if I could, that surround this inquiry, and the reason that we included it in our motion to dismiss is because it appears that Ms. Reed did not get a fair trial because of this juror's dismissal. How would the person who's unidentified, to this day, unidentified, how would this person know who the juror sitting in one of these seats was?
Right.
If she was at a private location. I won't mention the location. How would they know? How would they know to identify her? How would they know what she said? How would they know to record her illegally, potentially, if that happened? How would they know these things?
Right.
How would they know that if she was a juror, that she was a juror on the Commonwealth versus Reed matter specifically? And how would this unidentified person know of all of the authority figures to go to Lieutenant Fanning, of all people, who is then described to us after the fact as the, quote, commander of the extensive security operations that this case has required. And I went through that with the court this morning, but I just want to reiterate it one more time. Of course, it makes perfect sense that we would presume that if he's the commander, I don't think it gets much bigger than commander. If he's the commander of all security operations, he's a commander over operations that are attendant to the courts, the actual court's security,
Supreme Commander,
the personnel security, the party's security to whatever degree that is necessitated, but maybe most importantly, the juror's security. That is a reasonable next step to conclude, a reasonable inference from the facts that we were given.
Thank you,
But
Max.
we do know this. He was this same Fanning that was just randomly picked to go report this to, was also the person that was in Ms. Reed's house seizing her phone just months before the trial.
Right.
He's also the person that was interviewing witnesses or supervising the interviews of witnesses in this trial. He was also the person that was on the text messages between Proctor and his buddies at MSP talking about her and trying to find nudes. We know all of that existed. And yet we were denied an opportunity, Your Honor, an important opportunity to simply inquire before this before this juror was dismissed. That's all we asked. Let's get Lieutenant Fanning in here. Let's find out what the source of this is, and let's figure out, is it even remotely true? Remember, the juror never said it was true.
Yeah.
But lo and behold, minutes before I stood up to give my summation, that juror's removed. That's the problem. This isn't about court officers and besmirching court officers' reputations. That's not what this is about. This is about what happened at sidebar in the matter of minutes that denied Ms. Reed her constitutional right.
He's so good. So good.
There's a couple of other points that I just want to make. Mr. Brennan started his comments by talking about the Sallyport video and how unimportant it is. How unimportant that video is. And I'm not going to go through all my points again. The court doesn't need to hear that. But I do want to make this point. He says it's not important. There was nothing to see here. We don't pull videos normally. Yeah, of course you don't pull Sallyport videos if you're investigating a bar fight. This was the purported murder weapon. This truck is the thing that the Commonwealth suggests was used to kill a cop.
Yeah.
You think the video of it being pulled into the Sallyport might be of some evidentiary value? I don't know. Can't imagine why that would be important. Can't imagine why that might have some evidentiary materiality. But I do know this. I do know this much. One guy who thought it was important, the lead investigator, he pulled it all of it. He was super convinced it was important. And he's the guy that once pulled it, hid it from us for nearly 3 years.
Bang, 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 bang.
Mr. Brennan spent some time talking about the difference between cracked and missing. Interesting point. Now, I'm not going to go through a bunch of videos and audios. The court has seen all the pictures and photographs that it needs to see, and the court has a very, very good memory. We've never, ever disputed that the light was cracked at 5:07 or so a.m.
Mm-hmm.
That's how it got cracked, is the point. It got cracked on that traverse. And a piece was missing. A piece was missing. Not according to me, according to another agency's sergeant, Barros, who said a piece was missing, but it wasn't completely damaged.
Dayton PD?
Recall that when that light was completely reconstructed with the 46, 47 pieces that were purportedly found, well, they were found at or near 34 Fairview, and then they were reconstructed. Does the court recall what that reconstruction looked like? That taillight was put together almost in its entirety. Almost.
Listen.
Except a piece was still missing.
Uh-huh.
There was a piece unaccounted for. It's a big difference between a crack and the condition of that taillight, which we've now seen, where literally the entire lens material is basically gone. There's a few shards left on some edges, but the entire lens is basically gone. So yeah, it's relevant. And it's exculpatory. The condition of that light when it pulled into the Sallyport driveway. And with regard to the inverted video, again, Mr. Brennan says there's nothing to see here. We've got inverted videos dating back days earlier.
No big one.
Then why, if that's such common knowledge, then why did Mr. Lally and Sergeant Buchnick in front of a jury present that video as a true and correct presentation of what that car looked like and where that car was? Mr. Lally actually asked the question. I don't have a page in sight now, but I remember it because I was sitting here. He asked the question, did you see Mr. Proctor? It was something, I'm paraphrasing, something along the lines of, did either you or Trooper Proctor approach that right passenger taillight? And the answer was no. Because on the video that was being played, it looked like the right passenger taillight was the one closest to the jury. And of course, Michael Proctor walked right around that and went over to the other taillight. Except when you reverse it, you realize that's the right taillight.
Is there a copy of the reverse, the one that you played? Is that in the exhibits for today's motion?
No. The one that's been corrected?
Yes. I'd like a copy of that.
I don't think I have. Sure. We
Yeah, they didn't alter it. They flipped it. Can somebody just confirm for me that Aiden's hearing was not broadcast at all? Because I may just cancel the other live. If somebody just told me they got a notification that I'm going live in 30 minutes, and I know that there's people over there, and I just if there's nothing for me to play, then I'm just going to cancel that live. So let me know. I'll let him keep talking. It was muted, so nobody got to hear anything. So the only way that we're going to get to know what happened at Aiden's hearing is by listening to Aiden talk about it. It was not broadcast. Okay. All right. If there's anybody over there, there's a Zoom feed, but there was no audio. So there was nothing. It was muted. So unless people were there, Young Jerks had it, but what did it play? It was muted. So that doesn't help at all. No sound. Yeah. All right. All right. Cool.
We get that for the court immediately. Also, he played a video of the grainy video showing, hey, look, some of these cameras are just grainy in other particulars as well at other times and places. Maybe, or maybe not. What's interesting is the grainy video that we saw, if my memory serves me, and it's my memory and it's being taxed at this point, but my memory is the chyron on that video, in other words, the running numbers.
That's right.
Was at the bottom. That video he just played is at the top. That's the exact same video. It's apples and apples, oranges and oranges. Why is that different? That's interesting.
That would have been nice to know.
With regard to Ms. Reed's actual statements in that interview that was played, or I'm sorry, it wasn't played, it was recited. She said, some of the red plastic is missing. Some of the red plastic is missing. In other words, a piece is missing. It's completely consistent with the condition of that taillight before it was at the Sally Port. With regard to the facts that were recited by Mr. Brennan at the very end, every one of those is unsubstantiated. How does he know all that information? Who has he been talking to? And why don't we know about it? If in furtherance of this motion, there was an interview done of Lieutenant Fanning that laid out all of this information about not having contact with jurors and not doing this and not doing that, but yes, doing this and that and the other thing, why is the first time I'm hearing about this when he stands up and tells us? That has been the pattern of this Commonwealth's presentation to this court and in front of the jury consistently. That is the punctuation mark at the end of the sentence. Why am I just now getting that? Why wasn't that appended to his motion? Was there a conversation Mr. Brennan had with Lieutenant Fanning that we need to know about? This is exactly why, Your Honor, exactly why. If this court is not inclined to dismiss this case, and it should, the maladies of the Brady concerning the Brady violations and the discovery violations are so manifold in this case. They cannot, it's irremediable harm. Irremediable harm. This case should be dismissed because of the conduct of the Commonwealth, including Michael Proctor holding onto those videos, hiding those videos, and then others involved with strategizing how to use the videos against us, against the defense, in a murder trial without our knowledge and without giving us the videos.
He's pissed.
But if the court, in the face of all this, determines that it's either unconvinced at this juncture to dismiss this case, then we urge the court to have an evidentiary hearing. That's what this demands at the very least.
Oh, yeah.
An evidentiary hearing so that the court can perfect the record. We shouldn't be guessing at things. And I'll submit.
Any follow-up, Mr. Brennan?
No, thank you.
Ms. Gianetti, do you want to say something?
I don't think I need to in light of that presentation, Your Honor.
All right. I know you want to do your motion, Mr. Alessi. I cannot imagine that you can summarize it all in 10 minutes, can you?
I cannot, Your Honor.
Okay.
He's gonna have to come back.
So I'm not going to have anybody back here this week or next week. We'll hear that on the 18th when we hear everything
Really?
else. I urge you, Mr. Alessi, to condense it as much as possible, okay?
No.
I mean, you're pleading.
He'll take as long as he needs to take.
I will do so, Your Honor.
Okay. Not yet. So
Yeah.
I gave the parties until, instead of Friday for all the motions and limine, next Monday is fine. But by the following Friday, I want any responses, oppositions, any responses to the other side's motions. And then we'll have a hearing on the 18th. Jim, did we put aside any other days as well?
We did, I thought.
Yeah, Friday of this week.
Just a sec.
Yeah, we did 18 and 19.
That's what I had, yeah.
All right. I would expect that we would finish all the motions in limine in 2 days and wrap up whatever we have here. All right. All right. Yes.
Fox 25 produced the materials at the beginning of March 1st. I went down to see if I could get a copy. It's on a hard drive. I can't simply look at it in the clerk's office. I would like permission from parties to be able to take a copy of the hard drive, or if I can get the hard drive and make a copy and return it.
Does the defense want a copy as well?
Yes, Your Honor.
All right. So you can make copies.
I'll make 2 copies and then I'll return the originals to the court.
Okay. All right.
Just before you leave the bench, Judge, I do not want the court to decide that motion for sanctions until I just supplement the record. I could do it in 3 minutes, and if
Go
you
ahead.
don't, you can cut me off.
Go ahead.
Very good.
Go ahead.
Just briefly, Judge. Yesterday, Mr. Brennan represented to this court that I had made an extrajudicial statement regarding Mr. Morrissey and the federal investigation. You'll recall that I stood up in rebuttal and said that it was in court advocating for my client. He then said court TV is not a courtroom.
So before you go further,
Yes.
I don't know if Mr. Brennan was going to give me a court TV site on that. Is
Right.
there one, Mr. Brennan?
I'll have to provide a video. I think that Mr. Yannetti is referring to that comment that was a court comment. And so I intend on remedying that record. There was also a conversation after with court TV.
All right. So provide it to Mr. Yannetti. Mr. Yannetti, I'll give you an opportunity to respond once you get that. But go ahead. You can tell me what you want to tell me now.
Right now, it's out in the court of public opinion that
Yeah.
I made this extrajudicial statement. I said specifically I did not. He contradicted me, and that's where we left it. And he said that he would produce the receipts.
Mhm.
Now he's admitting he does not have the receipts. There was no court TV interview where I said anything of the sort. That was a Zoom hearing, excuse me, where I was arguing before Your Honor.
That's right.
And, I would just note, Your Honor, I don't think it makes sense that Mr. Brennan would have done this on purpose because it was so easily disprovable. But
He's stupid.
It's troubling that he would make this damaging accusation without properly vetting it to see if it is true before he attacks opposing counsel. So that was disappointing to me. And I would just point out, and I only need 30 seconds, that
You can take your time, Mr. Yannetti. You're not going to be
we're all
45 minutes.
Right.
We're all tired.
I certainly will not be. This new false allegation comes after my colleague, Mr. Alessi, co-counsel, Mr. Alessi, on February 25th, detailed 9 or 10 false statements that Mr. Brennan has made to this court. And I want to make it clear, I don't need an apology from Mr. Brennan. I don't expect one.
I'll never admit he lied.
Perhaps he should apologize to the court. He said today, a lie unchecked becomes the truth. And I just would hope, Your Honor, that you hold Mr. Brennan to the same standard that you hold the defense team. And that's it.
I certainly do. So, Mr. Brennan, if you do not have a site, then I need you to let us all know that as well.
I will. It's convenient to retort that there were 10 lies by the court that Mr. Alisi lined up. In fact, I looked at the transcripts. Some of his suggestions that
It's a lessee and go to the podium, you duck and jerk.
Alisi lined up. In fact, I looked at the transcripts. Some of his suggestions that I didn't read the paperwork properly were just wrong. I didn't try to shame him today. It was part of advocacy, and I accept that. There was a conversation, and if you remember, when I related Ms. Yanetti's remarks, it wasn't in relation to 3.6. It was in relation to the fact that they were using the federal investigation to create innuendo that could not be responded to. But I will provide.
For your request for the gag order? In support of your argument for the gag order?
In response to how they had used federal materials that were under seal that couldn't be rebutted to make suggestions. It directly related to that point, not 3.6. But I will provide the videos. Mr. Yannetti is right that the exact statement that I used was from a court hearing, but then there were subsequent statements made. And so my regrets to Attorney Yannetti, but it wasn't in fashion of a 3.6 violation. That wasn't the intention. It was to show how they've used these federal materials before the case was closed to their advantage.
All right. So if you have the site, I'll give you
It's a
until
Zoom
tomorrow
hearing.
afternoon to find the court TV site.
Very well.
If you have it, supply it to all, Mr. Yannetti. So I'm ordering the Commonwealth, if they have that court TV site,
We have
to
it.
provide it to all of
We
us.
watched
And
it.
If you don't, provide that as well. Provide that information as well.
Thank you.
Thank you.
Pull it up and
All right,
play it on
that's
the
it.
little TV.
All rise for the court, please.
Lies, lies, lies. Yeah. All of them. Oh my God. So many lies. So many lies.
You are muted.
Wow. Just wow. Typical gaslighting narcissist. Where's all the shaking and the rage and the anger? It's just not there. It's just not there. This was wild. This is some of the wildest stuff I've ever seen, ever in the history of ever. I just want to tell you guys that I'm canceling this stream that I have up for 5 o'clock. But before I do that, there was a super chat that was sent over there by mistake by Chris 10. Thank you for your 10. Who says Trooper Proctor is currently hiding under his bed. And to all of the new members whose names came up in the other stream, Margaret Hutchins, Karen Reed's Taillight, Jen Shep, Joanne Lindner, Kevin, Rebby, my puppy George, Mandy Shelton, Dennis the Menace, Nesme, and Amber. I put a note in there that we're canceling that stream. So there's that. There is so many questions that we have here. That most of them were put up already. But Edwards points out that the yellow timestamp for the January 1st, 2022, but the January 29th timestamp is blue. Someone messed with the settings but forgot to correct the timestamp. We've all noticed that as well. I think that's a great point. Al Dente said, Jackson asked Proctor the crime scene. Proctor answered, which crime scene? There's two. He said the Sally Port where the vehicle is parked is considered a crime scene. Good point. Nina said Proctor testified that the timestamp was yellow. That's why Brennan showed this video and not the one from the trial. Well, he also showed this video as a prior video to say, look, the camera always was inverted. But again, how did they have this exemplar video if that video overwrote itself every 30 days? Craig Tracy said Hank's OJ moment, the grainy video in trial had a blue timestamp at the bottom. He said it. Can somebody please show the difference between the actual taillight that they have in evidence and the videos? Red missing in the actual taillight, not missing in the videos. Yeah, there's plenty of people on Twitter that have done videos about it. If anybody can point out one in the chat, that's really good. To direct 10 misstatements of fact to, I'd appreciate that. Maybe Microdots has a video. Referring to the video, says Jane Jim, Buddy Crafts, it took me a while, but all makes and models of Karen Reed's LX 570 Lexus car has a white area on the red taillight as standard. Thank you. There's your answer. There's your answer. And people have done videos about that. Thank you for your super chat, Cindy. Thanks for your email. I will take a look at that later. The missing piece of taillight is still to this day the only piece never found, said JDD. And we heard Alan Jackson Mike slap that at the end of his argument. Commonwealth and Bev just got served. I agree, Sarah. Bex, thanks for 10, says, just got caught up. I can't catch my breath. This is infuriating. Free Karen Reed. Thanks for everything you do. Today's swearing. Just know we're screaming and cursing too. Happens. I get mad. Certainly do, Miss Dianetti, says Judge McBev. Thank you, Dr. Russell is the GOAT, for tuning in from Norway. Dr. Tracy Marks has a really good video today on breathing exercises to soothe emotions. Thank you. I don't know Dr. Tracy Marks as a creator, but thank you for a lot of people may need that. So that's a very good resource. Thank you. Too cute by half. I've never heard that expression. Is that an expression that you guys are familiar with in the chat? Too cute by half. I mean, I thought it was great. I thought it was also great that I pointed out and froze frame where the AI little icon came up when they were showing that video. So, you know, there's a whole bunch of more nothingness, in my opinion. Can Proctor plead the fifth, and with that keep him up? Will that keep him off the stand? No. The pleading the fifth is on a question by question basis. So even if the prosecution does not call Proctor, which I don't think they will, the defense can call Proctor, and he cannot just plead the fifth in general and answer no questions. It has to be pled on a case by case basis. I mean, a question by question basis. I'm sorry. And then you say which is what the Commonwealth wants and bring evidence in through other officers. No. So the defense can call him, and I think that they said that they will. I think we saw that in an interview that we watched together. And so thank you, Chris, for that super chat. And again, nefarious Commonwealth for nefarious. I call it nefarious. He calls it nefarious. Commonwealth says this case should be thrown out so far out of court that it circles the planet. Quit now, Spanky. Thank you so much for your very generous $50 super chat. And then Cindy in the house tells us that Rafferty has been the police chief since June 15th of 2021. So she's been the police chief since before even the murder of Officer John O'Keefe. Gretchen wanted to know if Karen can attempt to seek recovery costs from the trip the defense expert made to the Canton PD, seeing as now we know they did have the videos. She already made that motion. It was already denied. I think personally their time is better spent on many, many, many other things like motions and lemonade, as the captions call them, to keep certain evidence out. I think that's where their time is better spent at this point, but that is a good question. How long has Brady v. Maryland been law? I thought it was like around 1960, but now that you've piqued my curiosity, I'm going to bring it up. Oh, 1963. Brady v. Maryland was a 1963 Supreme Court case that established that prosecutors must disclose favorable evidence to criminal defendants. This is known as the Brady Rule. It's pretty much black letter law at this point. So when he gets up there and he says they never specifically asked for us to preserve that, but then we found out that it was preserved, but now there's no metadata. It's a completely disingenuous argument, in my opinion. Was Rafferty on the witness list? Weren't they sequestered and couldn't watch the trial? I do not know, because I don't know that we ever really saw the final witness list. Does anybody in the chat know whether Chief Rafferty was on any witness list? I do not know. Thank you, Mark, for your Venmo. Says don't change your commentary. I appreciate it. Thank you, Allie, who says this is outrageous. It's out of control, for your Venmo. Thank you to Jen, who says I happen to love when you stop the video and explain and give your opinion because I love your passion. Thank you. Thank you so much, Jen. Leslie, did I just roll my eyes out loud? She says, thank you. Nurse Jones for your super chat, for 2 super chats, and then says, thank you, Melanie. It wouldn't be the same without your commentary. I love you. I love you too, Nurse Jones. I love you too. I love you more. Steven says, don't stop, and we're here for your commentary. Your humor is a bonus. Thank you, Steven. Thank you for thinking I'm funny. I appreciate that. I appreciate that. Marie Spillane, I'm sorry, Marie says you're on fire today. I appreciate you, Marie. I appreciate you so. Heather, no words for the Commonwealth. Free Karen Reed, thank you for your Venmo. We have confirmed, apparently, that there have been some new charges levied against Aidan Carney. We don't know what happened at his hearing because they cut off the audio on purpose, apparently. And so nobody's going to get to hear what happened on the Zoom feed. And apparently there were some officers outside after court not letting anybody into the courthouse. Thank you, Emma, for buying me a matcha latte. I appreciate you. You know my coffee order. And thank you to Sherilyn for your Cash App. Didn't Ronnie know exactly who Fanning was? How? I don't know. I don't recall that from the juror interview of Ronnie. So I don't know. Thanks, Maria, for thanking me via Venmo. I appreciate you so much. And Lupus Lady, who bought me 5 matcha lattes, says, thank you for the lovely and often hilarious distraction making me laugh out loud for my grief about my husband. I'm so sorry about your husband. I'm so very grateful for you, your mods and fellow cupcakes. Prayers up for Lupus Lady who recently lost her husband, and my heart breaks for you. And I'm very sad for you. And thank you for giving me some matcha lattes to get through this day. There is so much to go over. Let's see, Kevin. This was from yesterday. Yeah, I know. I think I addressed those this morning. Okay, so thank you so very much, every single one. What actually happened? Well, what actually happened? You guys, there's so much to recap that I don't even know if I can do it. I don't even know if I can do it. Gonna need a bigger bucket, says Alan Jackson's Bucket of Nickels. Well done on the username. Gonna need a bigger bucket. Attorney O'Leary says in Massachusetts, the Fifth Amendment is a blanket privilege not asserted on a question-by-question basis. Really? Really? Another reason why I don't ever want to practice in Massachusetts. That is, thank you so much. Thank you so much. I appreciate that. Allie, I am still going, but I'm about to wrap because I'm exhausted, but I do love you, girl. And we will get together very soon, Allie Mata and I, and scream into the wilderness. You're watching Yellow Jackets, by the way. It's a must-see TV. Sandy says, Weinberg asked the Supreme Court to voir dire jurors at the court. Oh, that's great. Great info. Dr. Russell is the goat is here. Too cute by half is a sly person who is half smart. Oh, I like it. I like it. I'll allow it. Alessi Spanks, the Commonwealth is here and says the MSP page says Rafferty became chief in June of 2022. All right. Well, somebody else said 2021, so that would have been after his death. So now I'm confused. All of AJ's Nichols says, thank you for covering this case. Well, thank you guys for watching, and make sure you're smashing the like button. Smashing it. Because, you know, let's see, we had like well over, I don't know, like 12,000 people in here all day and only 7,000 likes. So let's please do that. Smash the like. It helps the algorithm, helps the girl out. Vinnie Politan now knows about the secret competition. Attorney O'Leary says, and keep talking, you're fantastic. Turtle Boy's arraignment is scheduled for 3/18. Thank you very much. Received a summons. Thank you. So that is confirmed. Something happened, I think, last night at CF McCarthy's, and I think it has to do with Chief Rafferty. So it's ironic that we're talking. Isn't it ironic? Don't you think? A little too ironic, if it's true that Aidan Carney said something to Rafferty last night at CF McCarthy's, that Rafferty was even at CF McCarthy's. And did she know that he was going to be there? Because they were posting pictures on socials. I saw them. It was Glare and Nan Gallagher, Law Furio, or only Nan. Thank you, Maureen, for your super sticker. And Meredith and Turtle Boy, and they were all at CF McCarthy's. And did Rafferty know that she was there? I have so many questions. Like rain on your wedding day. Yeah, I really don't think it's ironic, but it's so bizarre. Let me just get onto StreamYard so I can cancel that other stream. And then let me also thank each and every one of you for joining me today. Delete on YouTube. Yes, please. But I'll save that thumbnail for later. Mark Betterow was there today. He was in the courtroom for the Karen Reed hearing in the morning, and then he went to a different courtroom to do the Aidan Carney hearing, and we don't know. We don't know what happened. No, Aidan is back in court tomorrow at noon. It was Chris Albert. Aidan put his face on the window of D&E Pizza. That's what happened. So, well, see, this is why I don't like rumors, because people were saying it had to do with Helena Rafferty. So he has to go back to court tomorrow at noon on other charges, or did they hear the motion to dismiss today? I don't even want to go to Twitter to look it up. But I know you know. He's back in court tomorrow. Something about D&E Pizza, security camera, witness intimidations filed by Chris Albert. Oh. Shh. Look the other way. He looked in the D&E window. Okay. You know, I'm sure is he going to go live tonight? And because I can redirect you. Tell me who's live right now, and I will do a cupcake invasion. Because, you know, it's the nice thing to do. Right? I mean, we should do that. You guys should go invade someone's chat that I like. Someone who's, but it has to be. Here's the caveat. It has to be someone that's nice to me. Is Turtle Boy is live tonight? Okay. Nurse Kim is live now? Hang on. Turtle Boy and Bedro said they like the judge. He smashed his face on the window. Turtle Boy at 9. Go watch Turtle Boy at 9 for all the details on what happened today. All the details on what happened today. Is Emily Baker still alive? Is Emily Baker still alive? I've been trying to get in touch with her for a long time. She doesn't. I don't think she has any idea who I am. But this is what we're gonna do. If she allows it, if creators don't allow it, then you can't redirect to them. But let me just say if she does, because then you can be like, you guys should collab. Hold on, wait. Because I actually was gonna tell you to go over there and I was going to tell you to go over there for the recap because I'm too exhausted to even do a recap for you. She doesn't seem to allow redirects, but you know who does? Lawyer, you know. I don't know what time that is coming on, but I'm going to send you to Peter Tragos. I'm going to send you over to Peter Tragos so that you can get a shorter. Well, what is that going to be? 8:45 p.m. Well, that's going to conflict. Anyway, it's already done. So Andrew Burkhardt is live. Okay. All right. Done. Hold on. Let's go to Andrea. I don't know. How come it doesn't come up when I try and search for it? She might not allow it. Yeah. You got to have redirect privileges. It's like a thing. It's like a thing. I don't know. These are all upcoming. These are my subscribed channels that are upcoming that will allow it. What about Turtle Boy? Look, I'm trying to do a nice thing and nobody's got their settings correct. I don't know. They may not let Turtle Boy do it because they think, isn't he kind of not really officially able to be on YouTube, but he does anyway, even though he can't monetize it. All right. Go watch whoever you want. I'm trying. But, all right. You know what I did? I already put Peter Tragos in here. So I'm going to, when I hit end on this, it's going to direct you over to his 8:45 live show. And you can tell Peter Tragos that I sent you. I can't redirect to Andrea. She doesn't allow it. I'll have to get her to put me on the list. I got to be on a list, I guess. And he did a great show yesterday, Peter, because listen, I watch other law tubers too. After I do my thing, I go watch them to see if their reactions are the same as mine, to see that I'm not crazy. And he did a great show yesterday with his dad, and Peter's outraged. And Peter doesn't get outraged. He really, a lot of time tries to see both sides of it. Unlike me, when I get dug in, I get dug in, and you know it. Jess Machado live tweeted, it was good. Aiden, thank you very much. So you guys can go watch look at Jess Machado on Twitter and all that. So I'm going to redirect you over to Peter's stream. I respect him very much. I love what he does. He is able to keep it to usually an hour at a time, which is something that I am clearly not able to do because I talk so very, very much. And if you weren't here earlier, Mr. Alessi's daughter was in chat, and that was awesome. She's gorgeous. She was in court the other day, and she was in the front row. So if you know, you know. All right, everyone, moderators, thank the moderators. Thank the moderators. They worked double, triple overtime today for us and making it a great place to be. Thank you to my channel members, to my viewers, to my replay viewers. Please smash the like. Do all things that YouTube likes so that we can get to 100,000 and I can get that silver plaque. Andrea is live, but I can't redirect. Go watch her. But when I hit end, it's going to send you to Peter Tragos' stream so that you can hit the reminder button, the reminder bell on that for his 8:45 stream because he's good to watch too. If you need somebody who's a little bit calmer than I am. Stay cool, stay kind, stay classy. I love each and every one of you with all of my heart. If I don't see you soon, I'm gonna die. And if you want to know where that's from, go just Google Clemenz's Meatballs on YouTube, and it's from The Godfather. And there's that. Peace, my friends. I'll see you real soon. Good night, everybody. Go to Emily Baker for the recap later.